Lordships kindly. Sole breadwinner for 1.5 years. I'm without job. That research experience versus work experience. My Lordships have heard it and taken.
ಈಗ ಆಗುದಿಲ್ಲ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕೊಳ್ಳಿ. ಮೋಸ್ಟ್ಲಿ ನಮ್ಮ ಮುಂದೆ ಬರಂಗ್ ಕಾಣ್ತದೆ ಮತ್ತೆ ಬೇರೆ ಆಪ್ಷನ್ ಹೋಪ್ಫುಲಿ. ಏನು ಎಂತ ಲಿಸ್ಟ್
Final list. It's just appointment is concerned. The thing is, I have lost the case.
ಫೈನಲ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡೋದು ಬೇಡವಾ?
That is why
ಇಮಿಡಿಯೇಟ್ಲಿ
one submission, my lord. The State Consumer Court issued NBW, my lord.
NBW ಕಮಿಷನ್
State Consumer Court, my lord.
ಸ್ಟೇಟ್ ಕನ್ಸ್ಯೂಮರ್
State Consumer Court. NCRT also directed to bank DRT, my lord. Deposit ಮಾಡಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಡೈರೆಕ್ಟ್ ಮಾಡಿದೆ. ಸೊ ಅಷ್ಟರಲ್ಲಿ ಇವರು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಶ್ಯೂಡ್ ಅಗೇನ್ಸ್ಟ್ ವಾರೆಂಟ್.
ನಾಳೆ ಹಾಕೋಣ
ಪ್ಲೀಸ್. Connected matters, my lord. Connected matters, 2 matters.
ಎರಡಿದಾವ
Fresh matter matters regarding reversion matters. Yesterday, we also passed matters to keep the order in abeyance, my lord.
ಹೌದು
Similar batch of
ಮ್ಯಾಟ್ರಸ್ ನಾಳೆ ಐಡೆಂಟಿಕಲ್
please, same matter.
ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬರ್ಲಿ.
ಅಲ್ಲ ಇವು ರಿವರ್ಟ್ ಮಾಡ್ತಿದ್ದಾರೆ.
ತೊಳಿ ನಾಳೆ ಹಾಕೊಳ್ಳಿ. ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ ಏನು?
ಟ್ರೂ ಮ್ಯಾಟರ್. ಸೇಮ್ ಇಂಪಾರ್ಟೆಂಟ್.
Promotion are never, matters relating to promotion are never treated as urgent matters in service. In other matters. Sorry, ನಾಳೆ ಹಾಕೊಳ್ಳಿ.
My lord, humble submission.
ಅದು ಯಾವ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಕೊಟ್ಟೇವಿ ಅದನ್ನ ಇದನ್ನ ತೊಗೊಂಬರ್ಬೇಕು. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ತೊಗೊಂಬರ್ಬೇಕು.
The connected matter is listed today at serial number 18, my lords.
18.
Yes, my lords. It might be listed along with that, my lords, today. Fresh matter, my lords, regarding suspension.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ? ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್.
ಹೌದು, my lords. ಅವ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬಿಡ್ತಾರೆ, ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದಾರೆ ಅದಕ್ಕೆ, my lords.
ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು. ಅದಕ್ಕೆ ಇವತ್ತು ಸೀರಿಯಲ್ ನಂಬರ್ 18 ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆಗಿದೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್, my lords. It might be listed along with that today.
ಇದನ್ನ ಅದ್ರ ಜೊತೆ ಕರೆದು ಬಿಡ್ತೇವೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
My lords, ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇದೆ, my lords.
Call this matter immediately after vacation.
My lords, ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇದೆ, my lords.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದರಲ್ಲಿ.
ಏನ್ ಅರ್ಜೆನ್ಸಿ? ಆಲ್ರೆಡಿ ಟ್ರೈಬ್ಯುನಲ್ said tribunal has not granted relief to you.
Yes, my lords.
ಮತ್ತೆ
My lords, ಅವ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಅದಕ್ಕೆ.
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ರಿ ಹೋಗ್ಬೇಕು. ಔಟ್ ಆಫ್ ಸ್ಟೇಟ್ ಇದ್ರೆ ವಿ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಇಲ್ಲೇ ರಾಜ್ಯದಲ್ಲಿ ತಾನೇ ಏನಮ್ಮ ಇಲ್ಲೇ ಅಲ್ವಾ? ಕರ್ನಾಟಕದಲ್ಲೇ ಟ್ರಾನ್ಸ್ಫರ್ ತಾನೆ. ಅದು ಅಂದ್ರೆ ಅಸ್ಸಾಮಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಅನ್ನೋದಕ್ಕೆ ನಾವು ಅದನ್ನ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ವಿ.
My lords, at least it might taken up tomorrow together, my lords.
All right. Call this 18. Call tomorrow along with ಅದೊಂದು ಇಟ್ಕೊಳ್ರಿ. WP number so and so. ಏನಿಲ್ಲ ಅದ್ರ ನೋಡೇವ್. Yes. Selection or election? Selection. Immediately after vacation. ಈ 2 ದಿವಸ ಕೋರ್ಟ್ 2.5 ದಿವಸ ಅಷ್ಟೇ ಕೆಲಸ ಮಾಡೋದು ಇನ್ಮೇಲೆ. ಹಂಗಾಗಿ ರಿಯಲಿ ಅರ್ಜೆಂಟ್ ಇರೋನ್ ನಾವು ತಗೊಳ್ತೇವೆ. ಸುಮ್ಮನೆ ಎಲ್ಲದನ್ನು ಮೂವ್ ಮಾಡಬೇಡ್ರಿ.
Sir, I had moved on recall petition. On the December 6th, you directed the branch to post the case for next week. They have misplaced the memo, sir. They
ನಮ್ಮನ್ನ ಮಿಸ್ಪ್ಲೇಸ್ ಮಾಡಿಬಿಟ್ಟ.
the entry is there for tomorrow.
Sorry, ನಾಳೆ ಆಗಲ್ಲ. ಆಫ್ಟರ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ತಗೋಣ. ರಿಕಾಲ್ ಅಲ್ಲ ಆರ್ಡರ್. Sorry, immediately after vacation. ಒಂದು ಡೇಟ್ ಕೊಡಿ, ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್. ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಅವ್ರಿಗೆ. 7th of January.
Okay, thank you.
Yes. ಇಮ್ರಾನ್ ಸರ್ ಏನದು? ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ ಕೋರ್ಟ್ ಅನ್ನ?
3 appeals, my lord, connected. So there are 3 appeals in item number 1, 1.1, 1.2. I am for the appellant in item number 1 and 1.1. 1.2 is filed by Balaji. So all common against the very common order.
Common judgment and decree.
Common judgment. Suit for expressive performance has been.
Your lordship.
Amend caste title amend ಮಾಡ್ಬೇಕಲ್ಲ.
Your lordship, it has come on the last occasion. As I mentioned to your lordship, 20-year-old matter. Last 10 years before this honorable court, they have not. Your lordship, there's some. Your lordship, on your jacket, your lordship, this.
These are there.
I am not
That is the only one which should
responsible
dare.
for that at all.
Your Lordship, the difficulty is this. Last 10 years, they are not amending, even bringing in the LR, that is the wife. And Your Lordship, last time we sought permission, we will ourselves do it. They are not doing it.
Because
They are benefiting by the interim order. 20 years, we have a decree. We have deposited
ಅಲ್ಲ,
the
ಈಗ
entire amount.
ಅಮೆಂಡ್ ಮಾಡ್ತೀರಾ ನೀವು?
We will do it in their
But in
place,
one
Your Lordship, because
appeal,
they are not.
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ.
one appeal filed by the Balaji, there
no,
it
no.
has been amended.
ಎಲ್ಲಾ ಕಡೆ ಅಪೀಲ್
I have
Brother,
perhaps to my
ಸ್ವಲ್ಪ ಏನು CPC ಎಲ್ಲ ಓದೋದೇ ಇಲ್ಲದ ಏನು? ಎಲ್ಲದನ್ನು ಇದನ್ನ ಮಾಡ್ಬೇಕು.
My lord, with
Cost-
great respect, I don't understand Kannada at all.
Learned,
Then he has to learn.
you have to amend the cost title of every appeal.
But
There is such a ruling.
in his appeal, it has been amended.
It is not our appeal. There is no appeal of ours at all, Your Lordship. There are 2 RFAs, 1 MFA.
Appellant to ಯಾವ್ದ್ರಲ್ಲಿ appellant to amend the cost title and file amended cost title as well. ಹಾಕಿದ್ದಾರೆ amend ಆಗಿಲ್ಲ. Amend the cost title
Your
right
Lordship,
now. ಕೊಡಿ ಮಾಡಿಕೊಡಿ.
Lordship, in fact, there's an observation that it would be dismissed if it is not amended, that there's an order also.
ಹೆಂಗ್ dismiss ಮಾಡೋದು? Application dismiss ಮಾಡಕ್
ಇಲ್ಲ, order ಇದೆ.
correct. That is wrong.
I understand, Your Lordship. If might I request that interim order will be vacated if he does not amend.
Sorry. Amend,
But
to be
it's okay, by
amended
the way.
within 3 days. One, ನೋಡಮ್ಮ, RFA 1 ಮತ್ತು RFA 1.1, failing which
I have,
the interim order granted would discontinue.
Please, obliged.
Ah.
I
Obliged.
can amend right now, my lord.
ಮಾಡಿ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಿಕೊಡ್ತಾರೆ ಅಷ್ಟೇ.
Because once it is amended, it should be treated
ಅವ್ರಿಗೆ
in
ಕೊಡಿ.
all the appeals.
ಫೈಲ್ ಕೊಡಿ.
Obliged.
ಅಮೆಂಡು ಮಾಡ್ಲಿದ್ರಂಗೆ ಅದಕ್ಕೆ ದೇ ಆರ್ ಆಂಗ್ರಿ. Yes.
Lords,
What happened was against a common order of the tribunal.
Ah.
2 writ petitions were filed.
Ah.
First, our writ petition came up and stay has been granted. After a few days, my lord, state government's writ petition came. They had not filed the proper papers before the court. The final seniority list, they had not produced at all. Therefore, my lord, the court on a mistaken notion, my lord, that what is challenged is a provisional list. It disposed of that writ petition, directing our objections be considered. Actually, what has been
The final list itself.
final list itself has been set aside. On merits finding has been given. My writ petition is pending. Stay is there. When
ಇದ್ರಲ್ಲಿ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ಲ ನೀವು.
I was not a party before the tribunal. What happened was the promotees, without making any direct accrued a party, they got an order.
Suppose if court proceeds on the assumption that it is not, it is only a provisional list and passes some order. But final seniority list is passed.
And that submission was made by the state government itself.
ಅವ್ರು ಹಂಗೆ ಹೇಳಿದ್ರು.
ಹೌದು, ಅದು ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ನಾವು ಮಾಡಿದ್ವಿ ಅದನ್ನ.
ಇಲ್ಲ ತಾವು ಮಾಡಿಲ್ಲ, ಅದು ಮಾಡಿದ್ದು
One bench.
ಆಮೇಲೆ then both the learned judges are not here.
my lords,
Therefore,
Lord, may I?
Here ಅಂದ್ರೆ ಇಲ್ಲಿ.
submit?
ಅಲ್ಲ ಇಲ್ಲಿಲ್ಲ, ಇಲ್ಲ ಅದಕ್ಕೆ ಇಲ್ಲಿ ಅಂತ
ನಾವೆಲ್ಲ ಅಲ್ಲೇ ಹೋಗೋರಲ್ಲ.
ಇಲ್ಲ both of them have laterally moved, not vertically.
My lords, may I make a submission, my lord?
Appearing for the review petition.
My lord, may I make a submission, my lord?
ಇಲ್ಲ ಅವ್ರು ಇಲ್ಲ. ಇಲ್ಲ.
My lord, am I audible, my lord?
Yes, Mr. Ramesh.
My lords,
Listen, Ramesh.
your lordship's kind indulgence, my lords. I could not be physically present, my lords. It was clashing with another matter, kind indulgence.
Ah.
My lord, in this matter, it is not as simple as it is presented, my lord. Here is a case where their grievance is before the tribunal, these petitioners, review petitioners were not parties. And the matter was decided, their representation.
Mr.
Thereafter,
Nitin, 1 second. Small
Please.
question to you.
please,
If the court structures its final order
please.
on an erroneous assumption that only the provisional list is published and employee can file his objections.
No, my
When
lords, it is
already final public list is published, can it not be an error apparent on the face of the
My lord,
record?
I will not go into the merits at the moment, my lords, because I want to file my objections. what really happened here, what really has happened here is,
One submission, my lord.
ಅಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ ಲೆವೆಲ್ ಬರ್ಲಿ
Only one
ರಿವ್ಯೂ
submission.
ಏನ್
He
ಅರ್ಜೆನ್ಸಿ
is not the learned counsel who appeared in the writ
my lords,
petition.
may I complete, my lord? May I complete what I want to say? What I want
Then,
to
my
say.
lord, when this matter was
ಅಲ್ಲ
heard,
ವಾಟ್ ಇಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ ಇದೇನು ಬರ್ತದೆ
urgency ಏನಿಲ್ಲ.
ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡೋಣ
My lords,
ಡಿಲೇ ಕಂಡೋನ್
ಏನಂದ್ರೆ,
ಮಾಡೋಣ
ಒಂದೇ ಒಂದು ನಾನು ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ submission.
ಹಾ.
There is a very critical issue here. The way in which the conduct of the petitioners has been. What the petitioner does is, my lords, I will not get into the merit. I am not arguing on the merit.
ಅದಕ್ಕೆ ನಾವು
what
ಮೆರಿಟ್ಸ್
the-
ಮೇಲೆ ನಾವು ನೆಕ್ಸ್ಟ್ ಡೇಟಿಂಗ್
ಇಲ್ಲ.
ಮಾಡೋಣ ಈಗ ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡೋಣ
My lords, ಇಲ್ಲಿ ಒಂದೇ ಒಂದು ಏನು ಅಂದ್ರೆ ಒಂದು ಅಂಶ ಹೇಳ್ಬಿಡ್ತೀನಿ ಸರ್.
ಹೇಳಿ
Your lordship will appreciate the facts in its totality as regards how the conduct has been.
Yes.
The petitioner is not a party before the tribunal, very well,
Correct.
admittedly. In the writ petition also, the first round, which is under review in this petition, they were not parties. Both are factual statements. Now what they do, my lords, they have filed another writ petition in which they have got stay. Now they are asking for the same relief in this review petition and the writ petition where they have already got the stay. My lords, two petitions against the same tribunal's order, one
Correct.
by way of review and other by way of writ is not maintainable.
ಬರ್ಕೊಳ್ಳಿ ಅಪ್ಲಿಕೇಶನ್ ಇನ್ IA number 2 of 2022 supported by a verifying affidavit seeks condonation of delay of 165 days for the reasons stated therein. First, admittedly, review petitioners are not parties to the writ petition in which the order now put in review is a writ petition from which the order and review emanated. First, ordinarily in such circumstance, delay is viewed very leniently. First up, added, condoning delay would not add merits to the case of review petitioner to the disadvantage of other side. First up, in the above circumstances, the subject application having been favored, delay of 165 days in moving the review petition stands condoned. First up, rest of the things you file objections and then.
Please, very well, grateful.
My lord,
ಅಲ್ಲಿ ಪರ್ಮಿಷನ್ ಟು ಪ್ರಾಸಿಕ್ಯೂಟ್ ಇದಲ್ಲ ಎರಡರ ಮೇಲೇನು ಮಾಡ್ಕೋಬೇಕು ಆಯ್ತಾ ಕೆಳಗೆ ಅದಕ್ಕಿಂತ ಮೊದಲು ಅದರ ನಂತರ ದಿ ಅಪರೆಂಟ್ಲಿ ದೇರ್ ಆರ್ ಎಲಿಮೆಂಟ್ಸ್ ದಟ್ ಮೇ prejudice the review petitioner who is fighting another case in WP number
24166 of 2021.
24166 of 2021, in which he has secured an interim order as well. First off, therefore, the application seeking leave to prosecute the appeal is accorded. First,
We were called along with that
immediately after.
WP.
call this, ಅದು ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದಿದೆಯಾ ಡಬಲ್ ಅದು?
ಇಲ್ಲ, division bench.
Call this review petition along with WP number so and so that everything will be. open.
24166.
Only one
That's
submission,
the-
my lords, since your lordship has given permission.
Ah.
My lords, if the review petitioners were not made a party in the tribunal, the KT rules itself provides that the opportunity for them is to file a separate review petition in the tribunal itself. The law is well settled.
Even this aspect is looked into by Enta Singh, 1963 or 64 Supreme
for-
Court. Answers your point.
Yes.
Okay.
Subsequently, that is followed in Paula Singh.
Paula Singh also.
Paula Singh.
ಅದೆಂತ ಅದು? ಎಂತ ಸಿಂಗ್ ಅದು?
ಅದು some
ಶಿವದೇವ್ ಸಿಂಗ್.
Shivdev Singh.
ಶಿವದೇವ್ ಸಿಂಗ್.
DO.
Correct.
Shivdev Singh.
All right.
Good.
Yes.
My lord, I say for the petitioner. Here,
Any
my lord,
report?
the only of objection is in respect of translation of annexure D. Annexure D, my
ಎರಡು
lord, is an
ಅಂತಿಲ್ಲ.
order of the tribunal.
ಅಷ್ಟೇನಾ?
And in the
Forward.
meanwhile,
ಏನದು ಮೆರಿಟ್ ಮೇಲೆ ಏನಿದೆ?
in the meanwhile, my lord, 20651 of 2023, my lord, has been entertained by this honorable court. In respect of one of the common order, my lord, made in LGC number 1219 of 2019. I have also produced a copy of the interim order, my lord.
ಅದರಲ್ಲಿ
Wide connection.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಟ್ಟಾರ?
ಕೊಟ್ಟಿದ್ದಾರೆ 73,
ಎಲ್ಲಿದೆ ಪೇಜ್?
page 73,
93.
20651 of 23, annexure D.
Issue emergent notice. Learned AGA is requested to accept notice for 1,
1, 2, and
2,
7.
and 7. From first, learned AGA is requested to accept notice for 1, 2, and 7. Issue emergent notice to the rest. First. Interim order as prayed for. First, other ಕೆಳಗಡೆ. This interim protection is granted on the assertion of petitioner's counsel that in a substantially similar matter in WP number
20651 of 23.
20651 of 2023, a coordinate bench of this court has accorded reprieve. Wide order dated 3/11/2023.
11/23.
First,
Acho.
call along with. Okay.
Your Lordship.
Yeah.
In order dated 13/11, your Lordship had directed them not to precipitate the matter.
Not to precipitate the matter.
Please,
Know what they are doing.
on 22/11, they've issued a termination order, which has not been communicated to us by post till today. By WhatsApp message, they've terminated.
ಹೇಳಿದ್ರೆ
Yes, please.
ಅಷ್ಟೇ ಹೇಳ್ಬೇಕು, ಜಾಸ್ತಿ ಹೇಳ್ಬಾರ್ದು. ಎಷ್ಟಾಗ್ತದೆ ಟೈಮ್ ನಮ್ದು? Yes. But who appears for the respondent? Yes, when there is non-precipitatory order, why did you issue termination order?
His communication has gone.
Why did you? Then it's a grave misconduct from the side of employees. Berkeley, learned counsel for the petitioner draws our attention to our own order dated 13/11/2024, which reads as under. Next paragraph. She further submits that despite the above reprieve, comma, now the order of termination is stated to have been issued, although it is not yet served.
They've sent a WhatsApp message.
Is it served on you?
No.
That's what we are telling.
No.
Although it is not yet served on her client. And therefore, the conduct amounts to conduct borders contempt of this court. First up. Learned AGA appearing for the respondents seeks time to come out with a reply.
Yes.
In the meanwhile, next paragraph. The non-precipitatory interim order shall be abided by, and the termination order shall not be given effect to till next date of hearing. Call this matter in the 3rd week of January. First up, this order shall not be released. Copy of this order shall not be released, nor web hosted, till steps are taken as indicated in the cost list. Okay. The service to R4 is held sufficient because of postal shara inwards refusal. Okay. Next. Yes. Madhusudan. Anything.
Not appearing for the petitioner in this.
Translation dispense.
The annexure B, Tribunal order, my lord, on 30th August 2023. Lord, there is a FIR against the petitioner and other 33 DGOs, my lord. Lord, the FIR lodged against the petitioners in the year of 2013. Till today, my lord, even though the DPC, my lord, the promotion has not been granted and not considered. Even the juniors also considered, my lord.
Notice, sir. Learned AG is requested to accept notice for respondent. Copy from
Please.
petitioner to serve
This
copy
was-
of the petition on him. Next. Yes, sir.
But I beg to appeal for the question of the, sir, there's office of the transited copy.
Next,
The,
merit ಹೇಳಿ.
for 9 months, my lord, that I was unauthorized as a police constable on the ground of head health.
What
I
is
was
your explanation? What is the post you were holding?
Civil police
constable.
constable, civil police constable.
Police ಅವರೆಲ್ಲ ಅಷ್ಟೆಲ್ಲ ಅನ್ನ ಹತ್ರ
There-
ಇಟ್ಕೊಂಡು ಕೆಲಸ ಮಾಡ.
There is some dismissal from service, my lord. I can understand. Doctrine of proportionality, your lord.
ಅದು many depends upon several factors. ಕೆಲವುದ್ರಲ್ಲಿ ನಾವು ಕೊಟ್ಟಿದ್ದೇವೆ ಅದನ್ನ. But police force ನಲ್ಲಿ if he goes, who should police us?
I understand.
Ah.
Sufficient reason has been, the Honorable
call-
Supreme
no, no,
Court has
wait.
said that
Call
the
after vacation. ಬೇರೆ ಮುಂತೊಳಿ.
notice may be kindly be ordered.
ಬೇರೆ ಏನಿಲ್ಲ.
ಇಲ್ಲ,
Covered by judgment of the apex.
ಇಲ್ಲ, ಅದೇ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ charge itself is not willful, ಸ್ವಾಮಿ.
Habitual absentee.
ಒಂದ್ಸರಿ ಅಲ್ಲ, ಎರಡ್ ಸಾರಿ absent.
Charge, the Honorable Appeals Court has said that.
ಅಂತವ್ರನ್ನ ಇಟ್ಕೊಂಡು ನಾಳೆ ಪ್ರೊಟೆಕ್ಷನ್ ಆಗಿ ನಾಳೆ ಜಡ್ಜಸ್ ಮನೆಗೆ ಬರ್ತಾರಲ್ಲ ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ರೆ.
He is willfully absent, then only misconduct, not that. So not may kindly order for notice, not let it.
We are not convinced of prima facie case. However, matter be posted before some other bench. Yes. Recall that order, otherwise he may be affected by that. Recall that. Post after vacation. Yes. ಏನಿಲ್ಲ ಏನಿಲ್ಲ.
Kannada annexures we have dispensed, we have sought more.
ಕನ್ನಡ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿಬಿಟ್ಟೆ ನೀವು ಆಲ್ರೆಡಿ ಈಗ 1956 ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿ ಹೋಗಿದೆ. ಡಿಸ್ಪೆನ್ಸ್
My lord, the land, Granby Court, my lord, they discharge the petitioner from the charges leveled against him, my lord, section 4 and 5.
Huh?
Yes, discharge from the charges, my lord.
ಫ್ರಮ್ ದ ಚಾರ್ಜ್.
Yes, sir,
ಚಾರ್ಜ್ ಮೆಮೊ ಇಶ್ಯೂ ಮಾಡಿದ್ರು.
yes, my lord, yes, sir, land grabbing
Absolve
at section 4, yes.
ಅಬ್ಸಾಲ್ವ್.
So, but my lord, the direction has been given to the rank forest officer, my lord, to take possession of the land, excess of land. My lord, within the boundary, my lord, what land is granted by the government is in possession. But my lord, they are alleging that 3 acre 40 cents of land has been encroached. But that, my lord, the land grabbing court has told that it's a granted land. 2 acre 16 cents have been granted, but excess land any, it has been ordered to be take possession of the land. That's what.
ಸರಿ, ನಮ್ಮ ಮುಂದೆ ಬಂದಿತ್ತಾನೆ ಇದು?
ಇಲ್ಲ, ಇದೆ ಫಸ್ಟ್.
ಬಂದಿಲ್ಲ. ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ ಒಂದು ಬಂದಿದೆ.
ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಕಮಿಟಿ ಮುಂದೆ
ಕಮಿಟಿ ಮುಂದೆ ಅದು ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ ಏನದು?
is given undertaken by that only 4 acres is actual land, remaining land is left to the department, forest department.
ಓಕೆ.
Based on that
ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ
observation,
ನಾವು
our lordship dispose the matter. Based on that observation, dispose the matter, that application.
ಅಲ್ಲೇನು ಮ್ಯಾಟರ್ ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅನ್ನೋದು
ಗೊತ್ತಿಲ್ಲ, ಇದೆಯಾ?
ನೋಡೋಣ.
ಮುಂದೆ ಪೆಂಡಿಂಗ್ ಇತ್ತು.
ಕಮಿಟಿ ಮುಂದೆ ಪೆಂಡಿಂಗ್ ಇದೆ. ಮತ್ತೆ ಅದಾಗೋ ತನಕ ಹೆಂಗೆ ಕಮಿಟಿ ಹೆಂಗ್ ಹೌ ಇಟ್ ವಿಲ್ ಟೇಕ್? ಕಮಿಟಿ ಮುಂದೆ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
To take instruction.
ತೊಳಿ ನೋಡ್ ವಿಲ್ ಸಿ. Nagaraj will never lie to the court. Bakali, issue emergent notice. Lieutenant EG is requested to accept notice for respondents 1 and 2. First, counsel for the petitioner submits in all fairness that his claim is confined to only 4 acres of subject land and rest of the land remains with the forest department itself. Correct?
2 acre 16 cents.
2 acres 16 cents.
Only the granted land.
No, 2 acres 16 cents of granted land. 4 acres land. And rest of the land belongs to the government and he is not in possession of the same. First up, in view of the above, issue interim order as prayed for till next date of hearing. First, however, it is made clear that the forest department can safeguard rest of the land. Okay. At least. Yes.
Petitioner. This is my lordship, rule 32 promotional.
Motion ಅನ್ಬಾರ್ದು ಅದಕ್ಕೆಲ್ಲ.
Rule 32.
Rule 32
placed under
position.
Rule 32, my lordship.
Sir, emergent notice and interim order as interim order ಕೇಳಿರನು?
ಕೇಳಿದೀವಿ sir.
As
This
prayed
is
for.
my lordship covered by recent
ಅದಕ್ಕೆ?
correspondence.
Okay. Next. Yes,
Lordship.
yes, Prithvishan idu.
Lordship appearing, Lordship has directed me to secure instructions as to when are the petitioner is going to be posted. So, the
ಹಾ,
posting will be
ಪೋಸ್ಟಿಂಗ್
shown.
ಕೊಡ್ಬೇಕು.
ಕೊಡ್ತೇವೆ 1 week.
One week ನ ಪೋಸ್ಟಿಂಗ್ ಕೊಟ್ಬಿಡ್ರಿ.
ಕೊಟ್ಬಿಡ್ತೇವೆ.
Just this I wanted to place for your lordship consideration.
ಅಷ್ಟೇ
Ultimately, I'm in your lordship hand.
ಬರ್ಕೊಳ್ಳಿ.
May I just make this simple. I displaced a certain person.
Anyway, you are getting posting now.
My only difficulty is I was posted to a certain place. I displaced a certain person because he was facing certain allegations and enquiries. Now, within a span of 1 year, he is brought back to the same place despite he having completed his tenure. I am rendered without posting. My lord, your lordship-
ಕೊಡ್ತೇವೆ ಅಂದ್ಬಿಟ್ರು ಅದು ಹೋಗ್ಬಿಡುತ್ತೆ ಈಗ.
that lordships have taken a view, my lords, in Vasu, saying that, my lords, after the application is filed and litigation is pending, they can't give me a posting only to liquidate my legal ground that I was rendered without posting when the order was passed. KM Vasu versus BBMP, para 6-4. Your lordships have taken that view, my lord.
Lordship vacancy, she holds the post of assistant director. Now, regular deputy director is posted there. That is the
Against
regular post.
who is facing charges?
My lords, I was working in Kolar. My posting was cancelled. I was posted in place of that person who's facing allegations.
But whether you on substantive basis ಅದು.
No, my lord.
ಬಿಡಿ
Now,
ಮತ್ತೆ, what is your right?
my problem is, my lord, my regular posting was cancelled.
We will ask, see, nobody has a right to say,
Please.
I should be placed under rule 32.
Please, absolutely.
Therefore, regular, you can say, it's great that you want to work. Obviously, your client appears to be very, very sincere also, that he wants to work. There are many things.
In the last.
Jagadish is also smiling. Our Wilgul is also smiling anyway. We all understand that.
We'll show the posting, Lord. We'll give the
Berkeley.
posting.
Your lord-
Let the DGA issue notice, let
Now
the
it is
DGA
placed before
requested to
the
accept notice
Ministry, Lord.
for respondents. First off, let the DGA on being asked, why no posting is granted to the petitioner? Comma, he assures that something would be done in that regard before the next date of hearing.
Please, Lord.
First, call this matter immediately after vacation.
Please.
Oblige.
Great.
ಅದೇ ನೋಟಿಸ್ ಮಾಡಿದ್ವಲ್ಲ ಈಗ ಮೊದಲಾಗಿರ್ಲಿಲ್ಲ. may not be necessary. Notice to private parties is dispensed. Okay.
I appear for the
In
petition.
Jagdish.
See,
Ha.
annexure 11, 10, 11, 12, it is reflected.
7 objections ಇದೆ.
Old letter ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವ್ರೇನ್ ಮಾಡಿದ್ರೆ ಆಫೀಸ್ is not properly
ಅಲ್ಲಿ
verified.
ನೋಡಿ ಸ್ಟಿಚ್ ನೋಡಿ ಹೆಂಗಿದೆ ಅನ್ನೋದು ನೋಡಿ.
Sorry,
ನಿಮ್ ಕೇಸ್ ಹೆಂಗಿದೆ ಹಂಗೆ ಇದೆ ಸ್ಟಿಚ್
ಇಲ್ಲ,
ಸೈ
sorry,
ಮಾಡಿಕೊಡಿ. ಬಸವ
230 ಇತ್ತು.
ಏನು ಒಂದ್ 2 ನಿಮಿಷ ಕೊಡಿ, ಇದೇನ್ ಕೊಡಿ ನೋಡ್ಕೊಂಡ್ ಮಾಡಿ. ಏನಿದೆ ಜಗದೀಶ್?
Lord, third respondent has completed his tenure. He was posted, my lord, to the said place on 28/1/2022.
ಒಂದು ವಿಷಯ ಹೇಳಬೇಕು. ಐ ಆಮ್ ರೀಡಿಂಗ್ ಎ ಬುಕ್ ಆನ್ ಹೋಮರ್ಸ್ ಇಲಿಯಡ್ ಅಂಡ್ ಒಡಿಸಿ. ಇಂಡಿಯಾಸ್ ಪರ್ಸ್ಪೆಕ್ಟಿವ್ ಆಫ್ ಬ್ಯೂಟಿ, ಟ್ರುತ್ ಅಂಡ್ ಬ್ಯೂಟಿ ಮೇಲೆ ಇದೆ ಅದು. ಅದರಲ್ಲಿ ಒಂದು DVG ಅವರ ಒಂದು ಮಾತನ್ನ ಡಾಕ್ಟರ್ ಅರ್ಜುನ್ ಭರದ್ವಾಜ್ ಅಂತ ಗ್ರೇಟ್ ಸ್ಕಾಲರ್ ಅಂಡ್ ಪಾಲಿಮ್ಯಾಥ್, he says the life is nothing but a movement, a perennial movement from truth to beauty ಅಂತ. ಹಾಗಾಗಿ ನಾವು ಮಾಡೋ ಕೆಲಸದಲ್ಲಿ ಸ್ವಲ್ಪ ಬ್ಯೂಟಿ, ಮಾತಿನಲ್ಲಿ ಬ್ಯೂಟಿ, ನೋಟದಲ್ಲಿ ಬ್ಯೂಟಿ ಅಲ್ವಾ? ಇವನ್ ತಿನ್ನೋ ಪದಾರ್ಥಗಳಲ್ಲಿ ನೋಡಿ, ನಯನಾನ್ ಆ ಪದಾರ್ಥಗಳು ಚಂದ ಇದ್ರೆ ಎಷ್ಟು ಖುಷಿ ಅನಿಸ್ತದೆ. ಕೆಲವು ಪದಾರ್ಥ ತುಂಬಾ ರುಚಿ ಇರ್ತದೆ, ಭಾರಿ ಬೆನಿಫಿಷಿಯಲ್, ನೋಡಕ್ ಚಂದ ಇರಲ್ಲ. ರಾಗಿ ಮುದ್ದೆ ನೋಡ್ಲಿಕ್ಕೆ ಚಂದಿಲ್ಲ, ಬಟ್ ವೆರಿ ವೆರಿ ವಂಡರ್ಫುಲ್ ಫುಡ್ ಅದು,
Nutrition.
ಅದಕ್ಕೆ ಇಂಥವೆಲ್ಲ ಮಾಡುವಾಗ ಸ್ವಲ್ಪ ಯಂಗ್ಸ್ಟರ್ಸ್ ಎಲ್ಲ ಇರ್ತಾರೆ. ಇದು ನಿಮ್ಗಲ್ಲ, ಯಂಗ್ಸ್ಟರ್ಸ್ ಹೇಳ್ತಾ ಇದೆ. ಎಸ್,
My lord, he was, the third respondent it was posted to the my lord at the present place, that is my lord in Bangalore.
ಅಲ್ಲೇ ಇದನ್ನ ಹಾಕೊಳ್ಳಿ, ಮೈಕ್ ಹಾಕೊಳ್ಳಿ.
From Gulbarga on 28/1/2022. My lord, while I was working as a deputy chief fire officer, I was placed under suspension. Thereafter, I made a representation to the authorities that I should be given a posting. My lord, annexure A10 is the posting, my lord, to given to me.
A10. ಪೋಸ್ಟಿಂಗ್ ಕೊಟ್ಟಾರೀಗ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾ.
My lord, since the third respondent has already completed his tenure, he has been posted to Gulbarga. Earlier, I was posted to Gulbarga. I made a representation because I was the verge of retirement. Give me a posting to the.
ವರ್ಜ್ ಆಫ್ ರಿಟೈರ್ಮೆಂಟ್ ಅಂದ್ರೆ ಎಷ್ಟು
6 months. 6 months ಇದೆ ಸ್ವಾಮಿ.
6 months.
ಇವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, ನೀವು ಡೈರೆಕ್ಟ್ ಆಗಿ MLA ಇದು ಹೋಮ್ ಮಿನಿಸ್ಟರ್ಗೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ. ಸಿನ್ಸ್ ಯು ಆರ್ ಫೇಸಿಂಗ್ ಚಾರ್ಜಸ್, ದೇರ್ ಫಾರ್ my lord, this post would not have to have been given to you. My lords have taken a view once he has completed the tenure. In the case of my lord Sidlingu, the lords have held that a person who seek a posting for if his charge
ಏನಂತ ಮಾಡಿವಿ ಇದರಲ್ಲಿ?
para 6 ಇದೆ ಸರ್.
para 6
sorry.
6 ಇಲ್ಲಲ್ರಿ, 4ಕ್ಕೆ ಮುಗಿದಿದೆ ಜಜ್ಮೆಂಟ್.
ಅಲ್ಲ ಸರ್, ಸಾರಿ. ಐ ಆಮ್ ಎಕ್ಸ್ಟ್ರೀಮ್ಲಿ ಸಾರಿ my lord. ಐ ಆಮ್ ಹೋಲ್ಡಿಂಗ್ ಇನ್ನೊಂದು ಜಜ್ಮೆಂಟ್ ತಗೊಂಡ್ಬಂದಿದ್ದೆ, ಅದಕ್ಕೆ
ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಏನಿದೆ?
ಇಲ್ಲ.
ವೇರ್ ವಿ ಕೋಟೆಡ್ ಆಸ್ಕರ್ ವೈಲ್ಡ್.
para 4 ಅಲ್ಲಿ ಇದೆ. Having heard the learned counsel for the parties and having perused the petition papers, we decline to indulge in the matter, broadly agreeing with the submission made by the learned counsel appearing for the caveated bar respondent. Once an employee has completed the maximum period of retention, ordinarily, we will not have any right to complain when somebody is sought to be posted to each place on these premises.
ನಿಮ್ ರಿಟೆನ್ಷನ್ ಪೀರಿಯಡ್ ಆಗಿದೆಯಾ?
One submission, my lord.
ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡಿ, ನಂತರ ನೀವು ಹೇಳೋದೆಲ್ಲ ಕೇಳ್ತೇವೆ.
Oh, my lord. But 7.1 of the transfer guidelines, he is having also 11 months of tenure for the retirement. That 7.1A, my lord.
ಎಷ್ಟು ವರ್ಷ ಇದ್ದೀರಿ ನೀವು?
ಇಲ್ಲಿ 2 ವರ್ಷ 6 ತಿಂಗಳು ಇಲ್ಲಿ ಪೋಸ್ಟಿಂಗ್ ಅಲ್ಲಿ.
ಅಲ್ಲ, ಈಗ ರಿಟೆನ್ಷನ್ ಪೀರಿಯಡ್ ಎಷ್ಟು?
Another 2 years it can be extended because of 7.1A, my lord. He made representation to the government. It was not considered. It is pending. My lord, in the meantime, my lord, that he is facing the inquiry, my lord, and he is asking specifically this place, my lord. That is prohibited under the transfer guidelines. Specific posting he cannot ask. That is what observed by the tribunal, my lord.
ಅದೇ ಊರು ಯಾಕೆ?
ಹೌದು, anybody, any place.
Completed his tenure.
It is not right.
What is your right to say? I should be posted here only.
Specific.
Suppose ಒಂದು ಪೋಸ್ಟ್ ನಲ್ಲಿ ಇದ್ದಾಗ ನನ್ನನ್ನು ಅಲ್ಲೇ ಇಡ್ರಿ ಅಂತ ಹೇಳ್ಬೋದು. ಚೌಹಾಣ್ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದೇನು ಅಂದ್ರೆ, ನಾನು ಶಾರ್ಟ್ಲಿ ಐ ಆಮ್ ರಿಟೈರಿಂಗ್, ನನ್ನ ಡಿಸ್ಪ್ಲೇಸ್ ಮಾಡಿದ್ರೆ ಬೇರೆ ಸಮಸ್ಯೆ ಆಗ್ತದೆ, ಹಾಗಾಗಿ ನಾನು ರಿಟೈರ್ಮೆಂಟ್ ಒರಿಜಿನಲ್ ಇರೋದಕ್ಕೆ ಕೀಪ್ ಮೀ ಇನ್ ದ ಸೇಮ್ ಪೋಸ್ಟ್ ಅಂತ ಹೇಳಿಕ್ ಬರ್ತದೆ. ನಾ ರಿಟೈರ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದ್ದೀನಿ 6 ತಿಂಗಳಲ್ಲಿ, ಹಾಗಾಗಿ ಈ ಪರ್ಟಿಕ್ಯುಲರ್ ಪೋಸ್ಟ್ ಕೊಡಿ ಅನ್ನೋದು.
ಬೆಂಗಳೂರಲ್ಲಿ ಇರೋದು ಒಂದೇ ಪೋಸ್ಟ್. ಬೆಂಗಳೂರಲ್ಲಿ ಇರೋದು ಒಂದೇ ಪೋಸ್ಟ್, ಚೀಫ್ ಫೈರ್ ಆಫೀಸರ್ಸ್. He has completed the tenure. Other persons have not completed. Therefore, I have sought that I may be posted to his place.
ಶಾರ್ಟ್ ಅಬ್ಜೆಕ್ಟ್ ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ತಿಳ್ಕೊಂತ ಹೇಳಿ ಪ್ಲೀಸ್. ಇದು ಬೆಂಗಳೂರಲ್ಲಿ ಒಂದೇ ಒಂದು ಪೋಸ್ಟ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
ಬೆಂಗಳೂರಲ್ಲಿ 4-5 ಪೋಸ್ಟ್ ಇದೆ ಮೇಡಮ್.
ಬೆಂಗಳೂರು ಟೆನ್ಯೂರ್ ಕಂಪ್ಲೀಟ್ ಆಗಿರೋದು ಇವ್ರದ್ದು ಒಬ್ಬರದೇ ಐತಿ.
ಇದು ಈಸ್ಟ್ ಝೋನ್ ಈ
ಕರೆಕ್ಟ್, ಉಳಿದವ್ರದೆಲ್ಲ ಅವ್ರನ್ನ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ
ಅಲ್ಲ,
ಟೆನ್ಯೂರ್ ಮುಗ್ದಿದ್ದಕ್ಕೆ ಅಂತ ಇವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಎನಿವೇ, ಯು ಲೆಟ್ ಹಿಮ್ ಫೈಲ್, ಯು ಮೇಕ್ ಎ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೆಕ್ಸ್ಟ್ ಡೇ. ಪ್ಲೀಸ್ ಕಳ್ಕೊಳ್ಳಿ. ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. Learned AGA appears for respondents 1 and 2, and R3 is on caveat to counsel. First off, learned AGA to make a statement on the next date of hearing as to whether petitioner can be accommodated at Bangalore, where the respondent caveator has completed his tenure. Just explore madi. Will not say anything. Then come out with statement.
Till then stay may be granted. Stay ಕೇಳ್ತೀವಿ.
ಅಲ್ಲಿ ಕೆಳಗೆ
ಇಲ್ಲ,
stay ಇತ್ತಾ?
ಅಲ್ಲಿ ಸ್ಟೇ ಅಲ್ಲಿ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅವರು. Stay was not granted to him. I filed a caveat. Stay was, my lord, stay was not granted to the respondent there.
Till next date of hearing, matter shall not be precipitated. Call this matter immediately after vacation.
my lord, one date may be fixed.
At the first week.
ಇಲ್ಲಿ ಏನಾಗಿದೆ my lord?
Immediately after vacation.
My lord, is totally contrary to the guidelines of the transfer guidelines, my lord.
In the second week of January.
Totally contrary to the guidelines, my lord.
Not.
It is an allegation of.
This order shall not be released. Copy of this order shall not be released till office requirement is satisfy. Next.
ಅದನ್ನ
Nor web hosted nor released. Neither web hosted
Plus.
nor released.
ಅನೇಕ ಟ್ರಾನ್ಸ್ಲೇಟೆಡ್ ಕಾಪಿ
ಅದಾಯ್ತಲ್ಲ, ಅದು ಬಿಟ್ಟಾಯ್ತು. ಉಳಿದಿದ್ದೆಲ್ಲ ಮಾಡ. Yes.
There are some minor office objections.
Urgency ಏನಿದೆ?
Urgency is now the petitioner has to relieve from from Mysore, my lord, on 20th/12/2024. On earlier round, my lord, his tenure was extended
To
for
which
6
place?
months. To Bhubaneswar, my lord, as per Annexure A6.
That's page 36 may be seen for a moment. On earlier occasion, petitioner had approached the tribunal, my lords, challenging the transfer. Page 36, para 2, my lords, last 4 lines, my lords, last 3 lines. Learned counsel for the applicant fairly submits that the impugned order, Annexure A7, may be kept in abeyance for a period of 6 months. Thereafter, the same could be given effect to. After noting this submission, my lords, the transfer order was kept in abeyance for 6 months, my lords. Again, they have petitioner has now approached the tribunal.
Yes, your
And
lordship. My lord, may I make one
he has
submission?
stayed in Mysore from last more than 15 years, my lord.
15 years.
ಹೌದು. ಈಗ ಪಾಲಿಸಿ ಮಾಡಿದರೆ that persons who have stayed more than 5 years, they have to be transferred. The policy for everyone, my lords.
I'll state
Any-
only few things, my lord. Thereafter, I leave your lordship's discretion, my lord. Only thing is, yes, I have approached the CAT on
You
earlier.
have given assurance.
Yes, my lord.
ನಂಗೆ 6 ತಿಂಗಳು ಕೊಡಿ, ನಾ ಹೋಗ್ಬಿಡ್ತೇನೆ.
ಹೌದು. At
ಮತ್ತೆ
that,
ಅಲ್ಲೇ ಇರೋದು 15 ವರ್ಷ ಇದ್ರೆ.
thereafter, my mother's position is even more worsened, my
ಎಷ್ಟು
lord.
ಮಕ್ಕಳಿದ್ದಾರೆ ನಿಮ್ ತಾಯಿಗೆ?
That I'm
Where
not.
have you stated? I am the only son. Therefore, there is nobody to look after. Or take your mother there also. Give facility.
My lord,
They are agreeable to give
Yes.
facility also.
my lord, one more submission on instruction I'm making, my lord. There is one more institute which is setting up in Andhra
What is
Pradesh.
your right?
No, I am not seeking anything as a right, my lord.
ಆಂಧ್ರದಲ್ಲಿ
It's
ಏನಾದ್ರು
only a
correct
request.
ಅಲ್ಲ, ಪಾಲಿಸಿ ಪ್ರಕಾರ we had asked for options, 5 options. ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದ್ರ ಪ್ರಕಾರ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಆಂಧ್ರ ಕೇಳಿದ್ರ?
ಈಗ
At that
ಬರ್ತಾ
ಇಲ್ಲ-
ಇದೆ ಅಂತ ಇದ್ದಾರೆ.
ಇಲ್ಲ, ಅವಾಗ ಇರ್ಲಿಲ್ಲ.
ಅವಾಗ ಇರ್ಲಿಲ್ಲ.
ಈಗ ಬಂದಿದ್ಯಾ?
ಇವಾಗ ಬಂದಿದೆ.
ಕನ್ಸಿಡರ್
That respondent 2 and 3 have to consider, my lords.
ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
ಅದು ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು, ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು, ಅವ್ರನ್ನ.
ಬರ್ಕೊಳ್ಳಿ.
Till then,
Time
my
ಬರ್ತಾ ಇದೆ.
interest may kindly be protected, my lord. And if it is not at all possible, then it
19
is.
years he is in Mysore.
19 years.
ಹೌದು, 19 ವರ್ಷ. 2005 ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ, ಅವಾಗಿಂದ ಇದ್ದಾರೆ. I will leave to the court. I appear only for R1, R2 and 3 have to be served.
ಯಾವತ್ತು ರಿಲೀವ್ ಆಗ್ಬೇಕು ನೀವು?
20th/12/2024, my lord.
20th 12
12.
ನಾಡದ್ದು
ಆಡ್ದು. But January 1st, 6th of January we'll have that. Till then don't do.
ಟ್ರಿಬ್ಯುನಲ್
But
ಆಲ್ಸೋ.
he is agreeable now to go to Andhra Pradesh. They are not our enemy countries.
I am not saying
Yes,
anything.
your lord,
ಅಲ್ಲ.
because difficulties,
Difficulty ಇರ್ತದೆ, ತಾಯಿ.
Bhubaneswar is too far and my
That
wife is
argument
also,
you cannot.
no, my lord, I'm,
No part in India is too far.
yes, your lordship. But because of my position now,
What is
right
that
now,
position?
because of the
19 years?
circumstances, my lord,
19 years you have been here.
and my wife is also state government employee of Kerala. Her job is also not transferable. She's a teacher here.
ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ. Petitioner is knocking at the doors of writ court for assailing the administrative tribunals. Assailing which order?
Annexure B, page 51, refusing interim order, my lords, on that.
Assailing the Central Administrative Tribunal's order whereby reprieve has been declined. First, learned counsel for the petitioner submits that her client has to look after mother, aged mother, and that her his spouse is also working in Karnataka only.
Kerala, my lord.
Kerala,
Kerala.
in Kerala.
Yes, your lordship.
In Kerala, in the neighboring state Kerala, and therefore Kerala, semicolon. Now a vacancy having accrued in the corresponding position in Andhra Pradesh.
Nellore, Andhra Pradesh.
At Nellore in Andhra Pradesh, comma, he can be accommodated there instead of being deployed to Bhubaneswar in Orissa. First, next paragraph. Learned CGC
For respondent number 1, my lord.
appearing for the first respondent submits that, opposes the petition, drawing our attention to the tribunal's order dated 5/7/2024, rendered in OA number, petitioner's OA number 379 of 2024, correct?
ಹೌದು.
2024. Wherein petitioner had sought for reprieve for a short period of 6 months. And therefore, now he cannot turn around and take a contra position. First up, we agree with this. Next one, in view of the above, we decline indulgence in the matter. First up. However, it is open to the petitioner to give representation to the respondent numbers 2 and 3, if at all he so desires. And if such a representation is given, comma, the said respondent shall take a call on that on a war footing. And in accordance with law. Okay.
My lord, can my interest be
Ordered
protected?
accordingly. No. The request of counsel for the petitioner to protect request of the counsel's petitioner, the petitioner's counsel, that till decision is taken on said representations in contemplation, comma, cannot be accorded. Okay.
Great.
Be promoted. Register to send a copy of this judgment order to the respondents 2 and 3 by speed post immediately. Okay. Yes.
Let's-
Yes, Sandesh.
Here the thing is, my objection is concerned, my lords. I have met, Tahsildar has not made as a party because he has not participated to the proceedings, my lords. But I am filing application with respect to that, my lords. The thing is, my lords, the urgency is, I have filed an application before the land grabbing court, my lords, to discharge because application is pending for grant, my lords.
ಎಷ್ಟು ದಿವಸದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ?
Last 2009,
2009?
9.
What, brother? Discharge application pending?
No, not discharge application. my lords.
Matter is pending.
Grant application.
That committee ಮುಂದೆ.
Committee ಮುಂದೆ.
ಮತ್ತೆ ಅದು ಕನ್ಸಿಡರ್ ಆಗೋವರೆಗೆ ಹೆಂಗೆ? ಸಪೋಸ್ ನಾಳೆ ಕಮಿಟಿ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ತು ಅಂದ್ರೆ ಅವಾಗ ಈ ಕೋರ್ಟ್ ಬರ್ತದೆ, ಲಿಟಿಗಂಟ್ ಜೈಲಿಗೆ ಹಾಕಿರ್ತೀರಿ.
Moreover, with respect to only 4 guntas, because I have been granted 40 into 42 square meters, the measurement itself is in dispute, my lords. If it is 40 into 42 square meters, as per the objection filed by the state, my lords, I have no grievance. I will withdraw the application filed before the granting also, my lords, because I will restrict only to the house is concerned and cow shed is
40
concerned.
house.
Oh, yes.
They
my
want to say 40 square meters.
Objections before the, but Hakkupatra itself speaks, my lords, they have not mentioned the feet or square feet.
Issue the emergent notice. Learned AG is requested to accept notice for respondents 1 and 2. First, learned counsel for the petitioner in all fairness submits. His holding is confined to the area in which the structure is existing.
Yes, my lords.
And not 40 into 40 square meters.
40 into 42
40 into 42
square meters.
Square
as per the
meters.
objections by the state.
square meters. First up. This is appreciable. First up. Next paragraph. Issue interim order as prayed for. So far as, anyway, prayed for, ಅಷ್ಟೇ ಮಾಡೋಣ, ಮುಂದೆ ನೋಡೋಣ, till next date of hearing.
I will bring up charges objection.
It is open to the state to take rest of the land, leaving aside the site on which the structure does exist. Okay. And ತೊಂಬಿಡ್ರಿ immediately. Why Tahsildar should be arrayed, brother?
My lords,
Yes.
but there is a
I'll mark it.
notification from the Honorable High Court. That is why.
Sorry. Latest judgment ಬಂದದ apex court just about 1.5 months back. Work it. Petitioner is directed to array the jurisdictional Tahsildar as respondent number 3.
Yes.
First, petitioner has amended the cause title with leave of the court in open. Okay. ಮಾಡ್ಕೊಡಿ ಇಲ್ಲೇ ಮಾಡ್ಕೊಡಿ. Yes. ಅಲ್ಲಿ ಅಲ್ಲಿ ನೋಡಮ್ಮ. He appears for ಇದು ಮೊದಲಿನ ಈ ಲೈನ್ ಮೊದಲು ಹಾಕೊಂಡು ಮಾಡ್ಕೊಂಡು.
My lord, I
Yes.
have complied with all the directions
ಮಾಡಿಲ್ಲ.
issued by us. ಪುಸ್ತಕಗಳನ್ನು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀನಿ, ಪೇಪರ್ ಬುಕ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಹಾ.
My lord, and I have sought for my injunction because my lord, she was served their response. ಎಲ್ಲ
ಈಗ ಕೊಟ್ರಿ ನೀವು ಅವ್ರಿಗೆ.
ಇವಾಗ ಜಸ್ಟ್ ನಾವು ಯಾಕಂದ್ರೆ ಇವರು ವಕಾಲತ್ತು ಇವಾಗ ಕೈಂಡ್ಲಿ ಸಿ my lord.
ಅವ್ರಿಗೆ ಒಂದು ಈಗ ಕೊಟ್ಟ ಮೇಲೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದು ಬೇಡವಾ?
ಅಲ್ಲ ಹಾಕ್ಲಿ ಸ್ವಾಮಿ ಅವ್ರು, ಅದೆಲ್ಲ ಎಲ್ಲ
Call this matter.
ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಕೈಂಡ್ಲಿ
ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡೋಣ.
ಆಗಿದೆ.
ಬರ್ಕೊಳ್ಳಿ. ಎಷ್ಟಿದಾವೆ ಅಪ್ಲಿಕೇಶನ್ಸ್?
ಒಂದೇ
ಬರ್ಕೊಳ್ಳಿ. Application in INM 1 of 2023 supported by narrative affidavit seeks to bring LRs of deceased respondent number 1 on record. First, rightly, no objections are filed by the other side to the same. First, there is no reason to doubt the version emerging from the affidavit that supports the subject application. First, in the above circumstances, application having been favored, leave is accorded to the appellant to bring LRs of deceased respondent number 1 on record. First, appellant to amend the cause title.
I will amend it.
Okay.
My lord, matter is
Call this
urgent.
matter immediately after vacation. Okay. For consideration of
IA for my lord,
application in IA number 1 of 24.
not to alienate the property. It would be an
ಎಲ್ಲಿ
innocuous.
ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಷ್ಟೇ ಸ್ವಾಮಿ, ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ, ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. What happened, my lord? Notice was served.
Next date ಹಾಕಿ.
Alienate.
ಪೇಪರ್ ಒಂದು ಇಲ್ಲೇ ಕೊಟ್ಟು
ಅದು ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ಪೇಪರ್ ಬುಕ್
Like it would be an innocuous order. You will maybe direct.
is served on the council appearing for the
May I
respondent.
make one
in the-
submission, my lord?
What next? Yes,
For the petitioner.
yes. ಏನಿದೆ?
Absence from duty.
Huh?
Absence from duty for 1065 days in 18 years, my lord. After 18 years,
65 days ಅಂದ್ರೆ ಎಷ್ಟು ವರ್ಷ ಆಗ್ತದೆ? ನಿಯರ್ಲಿ 3 ವರ್ಷ, 3 ವರ್ಷ ಮೇಲೆ ಆಗ್ತದೆ.
ಬೇರೆ ದಿವಸ,
Huh?
ಬೇರೆ ಓವರ್ ದಿ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್.
3 9 900 6 18 1080 6 18 1090 ಇದ್ರಾಗ ಎಷ್ಟು ದಿವಸ ಇದೆ?
Totally 1657 days. In that, your lordship, 602 days were regularized. Even thereafter, 1055 days, he remained
20 years
unauthorized
served.
object.
Only endeavor is, my lord, the family is on street, therefore I filed this petition.
ಹಂಗಿದ್ರೆ ಅಷ್ಟು ವರ್ಷ ಮುಂದೆ ಹೋಗ್ತಿರ್ಲಿಲ್ಲ ಬಿಟ್ಟು.
Suffering from, my lord, not well ಅಂತ ಹೇಳ್ತಾನೆ.
Huh?
ನಾಟ್ ವೆಲ್ ಅಂತ ಹೇಳ್ತಾನೆ. ಆಮೇಲೆ ವೈಫ್ ಆಪರೇಷನ್ ಆಗಿತ್ತು ಅಂತ.
ಏನ್ ಆಪರೇಷನ್ ಆಗಿದೆ? ಎಲ್ಲಿದೆ ಮೆಟೀರಿಯಲ್? ಏನಾದ್ರು ಇದೆಯಾ?
ಎನ್ಕ್ವೈರಿ ಕೊಟ್ಟಿದ್ದಾನೆ, ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಲಿಲ್ಲ.
ಏನು
ಆಪರೇಷನ್ ಆಗಿದ್ದ ಬಗ್ಗೆ DW ಎವಿಡೆನ್ಸ್ ಅಂತ ಹೇಳ್ತಾನೆ.
ಆಪರೇಷನ್ ಇಸ್ ಎ ವೆರಿ ಮೆಡಿಕಲ್ ಆಪರೇಷನ್, ಅದು ವೆರಿ ಇಲಾಸ್ಟಿಕ್ ವರ್ಡ್ ಅದು. ಅದು ಎಲ್ಲ ಇನ್ಫ್ಯಾಕ್ಟ್ ಸ್ವಲ್ಪ ಇನ್ಗ್ರೋತ್ ಆಫ್ ನೇಲ್ ಇರತ್ತಲ್ಲ, ಅದನ್ನ ರಿಮೂವ್ ಮಾಡ್ಲಿಕ್ಕೂ ಆಪರೇಷನ್ ಅಂತಾನೆ ಕರೀತಾರೆ. ಅದು ಯಾವ ಆಪರೇಷನ್ ಅಂತ ಹೇಳ್ಬೇಕು, ಎಷ್ಟು ದಿವಸ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದ, ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಎಷ್ಟು ದಿವಸ ಅವನಿಗೆ ರಿಲೀಫ್ ಕೊಡ್ಬೋದು ಅಂತ ಹೇಳ್ತದೆ, ಇದನ್ನೆಲ್ಲ ಹೇಳ್ಬೇಕು.
Please, my lord, your lordship may, my lord, modify the, my lord, penalty from dismissal, give one opportunity. I'll ask him to correctly work. 20 years, yes, sir.
ಕರೆಕ್ಟ್. ಇಷ್ಟು ಮತ್ತೆ 11,600
65 ದಿವಸ within 18 years.
ಬೇರೆ ಕಡೆ ಕಾಲ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಎಸ್, ಏನು ಬಿಡಪ್ಪ, ಒಂದು 10 ದಿವಸ 20 ದಿವಸ ಅಡ, ಒಂದು ಮ್ಯಾಕ್ಸಿಮಮ್ ಏನೋ ಒಂದು. ಕೆಲವು ಕಡೆ 1 ವರ್ಷ ಆಗಿದ್ದನ್ನು ಮಾಡೇವ್ ನಾವು. ದೋ ಹಿ ಖಾನ್ ಅಪೋಸಿಟ್ ಇಟ್ ವೆರಿ ಬ್ಯಾಡ್ಲಿ, ವಿ ಸ್ಟಿಲ್ ಗ್ರಾಂಟೆಡ್. ನೆಕ್ಸ್ಟ್. ಹಾ, ಎಸ್ ಮಿಸ್ಟರ್ ಹೊಳ್ಳ, ಏನಿದು?
Petitioner was appointed as Assistant Commissioner Commercial Taxes. That's 2 persons who are appointed as Assistant Commissioner.
Not before, after vacation.
So I request
After vacation.
date on
Yes.
Prepare for the respondent. Case, Your Lordship, granted interim order and connected with other cases, Your Lordship.
Sorry.
But in this case, only.
Call this matter along with
Petition number 30875 of 24, Your Lordship.
30875 of 2024 in the second week of, in the third week of January 2025. Interim order to continue.
Public. ಅಲ್ಲ interim order ಇದ್ರಲ್ಲಿ ಇಲ್ಲ.
ಇಲ್ವಾ?
ಇದ್ರಲ್ಲಿ ಇನ್ನು ಕೊಟ್ಟಿಲ್ಲ. ಅಲ್ಲ not
ಮತ್ತೆ interim order
contempt ಇದೆ.
ಇದೆಯಾ?
ಇದೆ.
See, issue interim order as prayed for till next date of hearing. Call this matter in the second week of, the third week of January 2020.
Public.
First, this interim protection is granted on the assertion of the learned AGA that there is a related contempt proceeding. Okay.
I do admit that.
Huh?
There is a contempt proceeding.
Ade, which is not disputed by the counsel for the respondent, caveator respondent. Okay. Next. Yes, Professor Nagarajan.
The petition was the petition was initially appointed as bill collector. Subsequently was from Panchayat Secretary grade 2, thereafter grade 1, then Panchayat Development Officer. I sought for the previous service by referring to Rule 235 of the KCSR. I must admit to the old pension. That was rejected by this honorable court, by the honorable KSCT. Previously, similar circumstances, the Annexure 8 and the honorable KSCT allowed such petition.
ಯಾವ rule ಅದು? Should previous service should be counted ಅಂತ rule ಇದೆಯಲ್ಲ?
Rule 235 of KCSR.
35. Consider ಮಾಡಬೇಕಾಗ್ತದೆ. Learned DGA.
Single bench of the
Learned DGA is requested to accept notice for. ಅಲ್ಲಿ Dr. S.S. Vishweshraya versus Karnataka University ಅನ್ಕೊಂಡು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ.
Yes, ma'am.
ಪ್ರೀವಿಯಸ್ ಸರ್ವಿಸ್ ಅನ್ನು ಕೌಂಟ್ ಮಾಡಬೇಕು ಅನ್ನೋದ್ರ ಮೇಲೆ ಹೌ ಇಟ್ ಜಸ್ಟಿಸ್ ಆನಂದ್ ಬೈರಾ ರೆಡ್ಡಿ ಅವ್ರ ಮ್ಯಾಟರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಚೆನ್ನಾಗಿ ಬರ್ದಾರ ಅದನ್ನ ನೋಡ್ಕೋಬೇಕು.
Great.
Yes. 19.
Filed wakalat for respondent.
My lordship, his request is only for my lordship, consider his date of correction. That is my lord, date of correction in, when he is completed the PhD, my lord. That is my lordship, he complied the honorable tribunal direction. Second person is concerned, my lordship, they have directed to give the notional benefits. That is my lordship, not permissible under the.
Oh, no, notional benefit ಕೊಡಬೇಕು ಅಂತ.
Yes.
Notional benefit ಅಂದ್ರೆ ದುಡ್ಡು ಕೊಡೋದಿಲ್ಲ ಎಂತದಿಲ್ಲ.
That is.
How you are aggrieved?
No, because my lordship, he completed the PhD course in my lordship, that is the 2015.
In 2015 he completed.
Please, my lordship.
ಯಾವಾಗ ಅದು
That is-
ಬಂದಾಗ
that is
ಕನ್ಸಿಡರ್ ಮಾಡಿ
wrongly mentioned that my lordship, 10/7/2015. That is correctly 10/9/2015. Tribunal is, my lordship, directed the department to consider the correct date. That is
10/7.
only his request in the representation, my lord. We consider his representation. Second portion is concerned, my lordship, kindly see, that is the financial burden to the state, my lordship, 1,500 employees is there, the officers is there. That is why 300 to 400 crore incurred by the state, my lord.
May I make this submission, Lord? This is interim order, my lord, which is granted by the honorable
court, tribunal.
tribunal, my lord. Specifically directed them to file the objections. It is mad. They don't file the objections, my lord. And they've already given the benefit extended with retrospective effect to some gentleman called Dr. B.V. Kiran Kumar from 2013.
They have given.
Yeah, they have given paid.
Any is a PhD, my lordship, that date is considered.
ಅದೇ ಡೇಟಿಗೆ.
Is, my lord.
Yes, as I'm asking, all that is from the date of PhD only.
No, that is not a financial benefits you are not given.
No, yes, they have given.
That- No, my lordship.
Plus the annexure A26 is the order of the this thing, my lord, KSAT, which was complied by them.
Only prospective effect, my lordship.
No, no, no.
Financial
With
benefit.
retrospective, so
Kindly
I
see the
represented.
Rule is there.
I represented, my lord, in that.
Order. Where is the order?
26, my lord. The copy ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ, petition, they have not served copy to me.
ಕೇವಿಟ್ ಹಾಕಿದ್ರನ್ನ?
Kevit ಹಾಕಿದೆ
ಇಲ್ಲ,
sir.
ಈಗ ವಕಾಲತ್ ಆಗ್ತಾ ಇದೆ.
ನೋಟಿಸ್
ಇಲ್ಲ,
ಆದ್ಮೇಲೆ
Kevit ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಹಾಕಿರಾ?
Yeah, yesterday only I filed Kevit. Wakalat I filed today.
I will serve.
ಕೊಡಿ.
I'll file objections. Contempt is there, my lord.
Contempt precipitate ಮಾಡಬಾರ್ದು.
My lord,
You should not precipitate the contempt.
absolutely, my lord.
ಬರ್ಕೊಳ್ಳಿ. Learned the issue notice.
Chandrasekhar.
Learned counsel represents the caveator, respondent. ಹಾಕಿದಾರಂತ ಇವತ್ತು.
ಇವತ್ತಾಗ್ತದೆ.
caveator ಇವತ್ತು ಹಾಕ್ಬೋದು.
ನಿನ್ನೆ ಹಾಕಿದೀನಿ ಸ್ವಾಮಿ, ಇವತ್ತು
Any time before grant of interim order, any time caveat can be filed.
The number is 23997 of
Not
2024.
put up.
Appears for so and so. Learned DGA presses for grant of interim prayer, saying that contempt proceedings are coming up before the tribunal.
311.
First,
10th January.
3-1.
10th January, next date of contempt.
learned counsel appearing for the caveator assures that he would not precipitate the said proceedings. First, assurance placed on record. Call in third week of January 2025.
Much of.
Great.
Let's kindly recollect, my lords, it's a case of specific performance where
amount ಏನೋ ಸ್ವಲ್ಪ ಏನೋ
then my
ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
my lords have directed both of us, if possible, explore the possibility of the compromise.
We only said both of them should sit under the shadow of some beautiful tree. See the flowering.
Yes.
You will not find even in Switzerland, in the Mount Titlis also.
Yes.
So beautiful trees we have in the
That's
court
what we were-
premises. Yes.
That's what we were discussing in the morning. We'll send them for a
Right,
cup of tea and ಇಲ್ಲ ಅವ್ರು ನಮ್ಮ ಪಾರ್ಟಿ ಬಂದಾಗ ಪಾಪ ಅವ್ರು ಬಂದಿರ್ಲಿಲ್ಲ ಅವ್ರ ಪಾರ್ಟಿಗಳು.
ಈಗ ಇಬ್ರು ಇದಾರ.
ಇವತ್ತು ಅವ್ರು
my
ಬಂದಿದ್ದಾರೆ,
party
ನಮ್ಮವ್ರು
has
ಇನ್ನೂ ಬಂದಿಲ್ಲ ಇದರಲ್ಲಿ.
ಹಿಂಗೆ ಹೇಳಿದ್ರಿ ಏನ್ ಮಾಡೋಣ ನಾವು? ಆಫ್ಟರ್ ವೆಕೇಶನ್ ತಗೊಳ್ರಿ. ಅವ್ರು ಏನಾರ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
Yes.
Both the sides assure that some positive development court will see on the next date of hearing towards amicable settlement. First, call in the third week of January 2025 as requested.
Please.
Further hearing, the release ಮಾಡ್ಬಿಡ್ತೇನೆ. Release, we don't remember the release from further hearing, the part heard. ಎಲ್ಲಿ ಬರತ್ ಬರ್ಕೊಳ್ಳೋದು.
I'm sorry, I was not there on the last date. I think because of.
We also missed his presence.
No, and of course, Mr. Samit has brought me up to date on what transpired on the last date. Now, just if your lordships indulges me for about 5 minutes, but I just want, of course, your lordships that I'm told. Correct. Right.
ಆ ಸೂಟ್ ಎಲ್ಲ ಏನದು? Suit still pending.
Suit, madam.
Suits which you have filed. Your client has
Pending,
filed. They are
pending,
still pending. Pending. Injunction order ಆಗಿದೆ
ಎಕ್ಸ್ಪರ್ಟೇ ಆಗಿದೆ. ಅದಾದ್ಮೇಲೆ it is posted for orders on the IA itself. After that, the orders have not been passed for the last few occasions.
Mr. Shankar, it is better to have some arrangement. We are telling to you also.
Of course.
Please, some
Further
amount.
concrete step in that direction is the affidavit filed by the propounder. He has given several undertakings that has not been brought to the notice of the honorable court. If I can show it, perhaps, and with benign presence, I would have the.
ಅದಕ್ಕೆ ನಾ ಹೇಳೋದೇನು ಅಂದ್ರೆ ಎಂಡ್ಲೆಸ್ಲಿ ಫೈಟ್ ಮಾಡ್ಕೋತ ಹೋಗೋದ್ರಿಂದ ಕೋರ್ಟ್ ನಲ್ಲಿ ಲಿಟಿಗೇಷನ್ನಿಗೂ ವಯಸ್ಸಾಗ್ತದೆ, ವರ್ಕ್ಮೆನ್ನಿಗೂ ವಯಸ್ಸಾಗ್ತದೆ. There are arguable points on either side is true. By which points will be impressed during or after, immediately after vacation, nobody can predict it. Therefore, we are just thinking aloud.
Please.
Some financial benefit.
Constructively.
some lump sum amount, some reasonable.
No, well, your lordship knows I'll be the last one. In fact, as far as workmen are concerned, labor are concerned, always, of course, Maharaj, this court has always has viewed it with a slightly more lenient. See, there's no doubt.
135 jana idare anta ಹೇಳಿದ್ರು last time.
Correct, Maharaj. Now, my only endeavor today, of course, I leave it to your lordships. My only endeavor today, Maharaj, since finally your lordships is calling upon the court's powers of equity to sort of bring a quietus to the litigation. My endeavor today was to point out, Maharaj, now this saga has been going on for
many years.
Many,
it has
many
been
years.
Going on.
But I would, and I'm saying this with great sense of responsibility, Maharaj, the conduct of the laborers in this case
We have
leaves a
seen
lot
that.
to be desired.
In fact, we have seen that.
Yes, Maharaj. So
That would have been perhaps arguably sufficient to deny relief
Yes.
to them.
Correct,
Arguable.
correct.
But unfortunately, Mr. Shankar is coming in our way. But for him, he would not have said that. Now, just why can't you now,
Yes.
before 130, 120, why can't you have a word with your client and come back
No,
with some
he's had, in fact,
package?
we anticipated this, Maharaj. So therefore, what Mr. Samit informs me is this. There was, I think, the party in person, one Mr. Vasu. We're filing a memo, Maharaj, where back in several payments have already been made. About 91 lakhs have already been paid.
Paid to
Now,
whom?
To Mr. Vasu, on the understanding, I'm told that it will be given to the union for the payment of the employees. Now, I don't know
What was he?
what was it?
Have you
Company
served a
sec-
copy on
Company secretary, ಕೊಡ್ತೀವಿ.
company secretary? Have you received 91 lakh?
Correct.
Have you given it to the employees? How it is given to the employees? No, how that money was given to them, workmen? Then check ninda ಕೊಟ್ಟಿರಾ? Entire amount is paid by check. By DD. Full amount is, we will record and we will investigate also now. ಈ ಕಡೆ ಬನ್ನಿ. ರೆಕಾರ್ಡ್ನೇ ಬರಲಿ ಅವರು. Who is there your union leader?
ಅವರು ಬರೀ ಸ್ಟಾಫ್ ಮಾತ್ರ ಕೊಟ್ಟಿರೋದು. ನಮಗೆ ನಮ್ಮ ಯೂನಿಯನ್ ಯಾವುದು
They paid to the employees who are on the rolls.
We'll go one by one. So it's a serious matter. Otherwise, we may direct a prosecution also. Learned senior advocate Vikram Gold appearing for the counsel on record for the respondents submits files a memo dated 18/12/2024 along with copies of
Bank statement.
bank statement which prima facie vouch the payment of a sum of rupees
Approximately 91 lakhs. 4507 plus 4598. About 91.
approximately a sum of rupees 91 lakh. 90 lakh.
45 plus 45, 90 ಆಗತ್ತೆ. 98 plus 7.
91 lakh 5,000.
91 lakh 5,000.
Approximately 91 lakh 5,000 to Mr. Vasu, son of
Late S.Y. Babu Rao.
late
S.Y. Babu Rao.
S.Y. Babu Rao.
Yes, ma'am.
He's also the applicant.
Who happens to be ఎంత applicant ఇవ్వరు?
Applicant in company application 46 of
Who happens to be an applicant in COP company application.
Company application, ma'am.
Number
46 of 2024.
46 of 2023.
24, my lord.
24.
My lord.
First. Mr. Vasu, who is personally present before us on being asked, admits the payment. First, however, he hastens to add that this amount has been distributed to
Employees who are on the rolls as on the date of ending up.
entire money.
Yes, ma'am.
This entire amount is distributed to the workmen on the rolls
Yes, ma'am.
as on the relevant date.
About 8 months salary was due and gratuity was paid, ma'am.
And, by way of gratuity and
Arrears of salary.
arrears of salary.
Yes, ma'am.
Salary. And this payment, he adds, is made through check
Yes, ma'am.
by through check,
Yes.
correct?
Through DDs and checks, ma'am.
Through bank instruments.
Yes, ma'am.
Bank instruments. First, what your client, Mr. Shankar, what your client you are the union. Do you dispute, do you know anything about this payment, etc.?
ಇದು ಸ್ಟಾಫ್ ಆಫೀಸ್ ಸ್ಟಾಫ್ಗೆ ಕೊಟ್ಟಿರೋದು ಅದು ನನಗೆ ಗಮನಕ್ಕೆ ಬಂದಿದೆ ಇದು ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ ಇದನ್ನ ಅವರು ಅಷ್ಟು
Did you take any money in this?
Yes, my lord. I was also employed.
How much you have taken?
About 6 lakhs, ma'am.
6 lakh.
Yes, ma'am.
Remaining amount will be
Distributed to other employees.
85 people.
Yes.
85
Not
lakhs.
85 lakhs.
85 lakhs. To how many people you have given that?
About 27 or 28. Exactly, I don't remember. I have to see the.
Less than 3 lakh, about 3 lakhs to them.
Yes, ma'am.
But you have taken 6 lakhs.
Yes, ma'am.
What was your position?
I was manager, secretarial and administration.
And the persons to whom you have given that money, what are they?
They were all accountants and also workmen in the factory.
Order inquiry to this. We will direct the. That's what, and how he took 6
My lord.
lakhs. Why he gave less money? Why he take a bigger share in that? Let there be an inquiry by the Commissioner of Labor. ಇವರು ಈ 135 ಬೇರೆ ಇದಾರ? We will come to that. Kindly be
I'm
seated.
told, in fact, I asked,
Mr. Vasu, be seated.
I'm told, my lord.
We
that-
may direct an inquiry into this matter for our ascertainment, whether amount has reached.
Actually, my lord, I was the first contender to file a scheme of arrangement, my lord. When the BIF referred to this
But
this High Court.
why you took 6 lakhs and only less amount is paid to the workmen? and
Other
the
work,
part-time?
other production people also, they got about 4 to 5 lakhs and all.
It cannot be.
My lord.
Then what is given to the workmen will be peanuts if we go by your version. ನೀವು ಮತ್ತೆ
Yeah, as
ಅವರೆಲ್ಲ
per
ದುಡ್ಡು
their
ತೋರ್ಸ್ಬಿಟ್ಟು
sal-
ತಗೊಂಡ್ಬಿಟ್ರೆ
yes,
12 ಲಕ್ಷ.
As per their salaries, last grant salaries, it was given.
It appears. Let us, we don't
As
know.
per their
We
last
don't
grant
know.
salaries, it was given.
Anyway, we'll come to that one.
But it was as per the instructions of the.
Okay. Huh? No, we want to say, because once we record the inquiry, which we want to initiate against him, it may go RE. Therefore, we'll keep that one. Yes, now, Mr. Shankar, we are just thinking. Your clients have nothing to do with this one. This is another matter. Therefore, you need not get embarrassed at all. It is different matter. Elegant. We'll come to that one. Now, sir, just consider getting instead of gone, because there are, we have spent lot of time with this file, even after hearing. Whether your clients are agreeable for some package, just ask them. Just ask them. Otherwise, we'll.
Because why I wanted to point this out is this, that list which was handed over to your lordships and which was supplied to us.
150 ಇದ್ರು 135 ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು last time.
Why I said the conduct leaves lot to be desired, that if my lords were to see the computation, they assume that retrenchment is illegal. And based on that assumption, compute
ಇಲ್ಲ, ಆ
from
ಪ್ರಶ್ನೆ
19
ಬರಲ್ಲ, ಯಾಕಂದ್ರೆ
ಅದು then.
ಅವರಿಗೆ ಅದು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿಬಿಟ್ಟು.
ಹೌದು, but
Division
Justice Arvind Kumar then holds that there has to still be an adjudication on
If
whether
they
the
want.
retrenchment is illegal.
Correct. If
Correct.
they did not avail that opportunity.
Now they have not availed. 2022, finally they availed it. That's when the Labor Commissioner said you have come 28 years too late. So Manas, now my only thing is, after so much passage of time, fine, even if they now get an adjudication that the retrenchment is illegal, the next step is to quantify the amount under 33C2.
Yes.
So there are still 2 more hurdles to be crossed.
ಇನ್ನು 10 ವರ್ಷ
And
ಬೇಕು.
my apprehension is that this court should not be used as a vehicle to circumvent that. That's all.
That's all right. But anyway, that's true. we keep
Yes.
it in our view.
Yes.
Because we are not labor court.
Of course. No,
If labor court's proceedings come before us,
Correct.
our powers are coextensive with the court,
Yes,
whose proceedings are being examined in this
Absolutely.
jurisdiction. That we understand.
correct.
Anyway, we don't have original jurisdiction at all. We straight away, we agree with that proposition. That being said, how long these employees should go on fighting the battle? There are, we know
Yes.
what is their stand. There are some elements of unconscionability.
Yes.
Because they wanted to drill hole in the ship itself, in which they were also sailing. That we understand. That being said, some amount, because you said that you
I'm-
contemplated, you foresaw
Yes.
what we were going,
No, which is why I'm asking,
you
can I,
predicted our
can I,
words. You are a great astrologer.
not an astrologer, no, appearing before your lordship
There
on
are-
a daily
no,
basis,
no,
that's
Mr.
a few elements of.
Vikram, no. There are three places where prediction is impossible. In that share market,
Correct.
number one. Number two, we will not say. Number three, it is said, quotes, where prediction is not possible. Even Jeremy, right from days of Jeremy Bentham, he also says that the predictability of law is essential. Okay. Anyway, it's nice that you have predicted.
Yes, that
Maybe
reminds me, I think Mr. G. Ramaswamy may have said that,
Ramaswamy
I think
says-
Mondays and Fridays, game of skill and game of chance.
in that RMD Chamar Bagwala
Chamar
versus
Bagwala,
so and
that's
so
it,
in that it happened. That's what.
So, Malaj, we are, Malaj, on instruction, I'm submitting rupees 1 crore, we're ready to give by Jan 31st.
135 people. It will be less than 1 lakh. Em bartad 1 lakh rupayi.
Also, Malaj, there is some dispute regarding the number of employees also. I'm told 55 was one number.
Number of employees kanmunde itkondu helbidi. ಎಷ್ಟು ಕೊಡ್ತೀರಿ?
I think we gave the list. The
Yeah,
list
but-
was given years ago.
On
In
the
2014, it was
ಒಂದು
given.
ಚೀಟಿಯಲ್ಲಿ ಬರ್ಕೊಡಿ. ಅಂದ್ರೆ
Yes.
ಅಗತ್ಯ ಇಲ್ಲ ನೋಡಿ ಮುಂದೆ ನಾವೇನ್ ಮಾಡಕ್ ಮಾಡಿಬಿಡ್ತೇವೆ ಅಷ್ಟೇ.
150 ಅಂತ ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. I'm not.
He could be,
ಅಲ್ಲ,
he could be
it is
the-
a- ಅವ್ರು ಎಷ್ಟೇ ಇರ್ಲಿ 130 ಇರ್ಲಿ 135 ಇರ್ಲಿ ಬರೇ 65 ಇರ್ಲಿ ನೀವು ಒಪ್ಪೊಪ್ಪ ಇವರಿಗೆ ಒಂದು ಚೀಟಿಯಲ್ಲಿ ಹಚ್ಕೊಡಿ ಜಸ್ಟ್.
Yes.
ನಾವೇನ್ ರೆಕಾರ್ಡ್ ಮಾಡಲ್ಲ.
Of course, of course.
ಜಸ್ಟ್ ನಮ್ಮ ಅಂದ್ರೆ ಬಹಳ ಗ್ಯಾಪ್ ಇದ್ರೆ ಮುಂದೆ ವಿಲ್ ಗೋ ಫಾರ್ ಆರ್ಡರ್ಸ್ ಅಂತ.
120, I'm told, Malaj, as per the list.
120 ಇದಾರ
120
ಅವ್ರಿಗೆ ಚೀಟಿ ಕೊಡ್ರಿ. ಕೊಟ್ಟು ಚೀಟಿಯಲ್ಲಿ ಹಾಕಿ ಕೊಟ್ಬಿಡ್ರಿ. ನಾವು ಸ್ಕೂಲ್ನಲ್ಲಿ ಇದ್ದಾಗ ಹಂಗ್ ಮಾಡ್ತಿದ್ವಿ. ಈ ಚಾಕ್ಲೇಟ್ ತಗೊಂಡಿಯಾ ನೀನು ಅಂತ.
ನನ್ನ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಯಾರಿಗೂ ಅರ್ಥ ಆಗಲ್ಲ, ಅದಕ್ಕೆ ಸಮಿತಿ ಬರಲಿ.
ಬಡಿ.
ಅಫಿಷಿಯಲ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ 150 ಜನ. ಟೋಟಲ್ 183 ಜನ.
ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ 135 ಅಂತ ಹೇಳಿರಿ, ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೇವೆ.
135 ಅಷ್ಟೇ.
Sure.
ಅದ್ರಾಗ ಇವ್ರು ಬರ್ತಿಲ್ಲ, ಇವ್ರೇನ್ ಬರಲ್ಲ.
ಇಲ್ಲ ಇವ್ರು
ಅದು ಸಪರೇಟ್ ಇಶ್ಯೂ.
ಹೌದು.
ಆ ಅಮೌಂಟ್ ಮುಟ್ಟಿದೆ ಇಲ್ಲೋ ನಾವು ಇದನ್ನ ಅಲ್ಲಿಗೆ ನಿಲ್ಸಲ್ಲ, ಅದನ್ನ ಸರ್ಟನ್ ಮಾಡ್ಕೋತೇವೆ.
I filed my application for, there are a lot of violations in this. That's why
ಫಸ್ಟ್ ಅದನ್ನ ಮಾಡಿ.
Just one more, this one more aspect your lordships may keep in mind. At the time of the retrenchment in 1994, as a severance, Malaj, about 20 odd lakhs was also paid.
20 lakhs was paid.
Yes, Malaj, 20 lakhs was paid. That is part of the record, page 190 to 112.
ಎಷ್ಟು ಜನರಿಗೆ ಕೊಟ್ಟಿದ್ದೆ ನೀವು ಇದನ್ನ?
That is for this 120.
120. ಆ ಟೈಮ್ ನಲ್ಲಿ ಹೆಂಗಿತ್ತು? ದಿಸ್ ವಾಸ್ ಹೌ ಮೆನಿ ಇಯರ್ಸ್ ಎಗೋ?
1994. The retrenchment date admittedly is 27/4/94.
30 years ago.
30 years ago.
ಅದು 25 ಡಬಲ್ ಎಫ್ ಪ್ರಕಾರ ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ.
Correct,
ಮೋರ್ ದನ್ 100
ಡಬಲ್ ಎಫ್ ಬರೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ.
ಅಲ್ಲ ಅವಾಗ ನಮ್ದು 100 ಮೆಂಬರ್ಸ್
Division bench said it is not a transfer, therefore no question of transfer compensation. Therefore, our argument ನಿಲ್ಲೋದಿಲ್ಲ. Fact remains that they have made the payment by check.
ಎಲ್ಲ ನಾವು ಅದನ್ನ ಅಂಡರ್ ಪ್ರೊಟೆಸ್ಟ್ ಅಂತ ಹೇಳಿ ಅಂತ ಬರೆದು
So,
ನಾವು
Malaj, so 20 odd lakhs then, this 91 lakhs now to settle the.
ಒಂದ್ ಜಸ್ಟ್ ಒಂದ್ ಚೀಟಿಯಲ್ಲಿ ಹಾಕ್ಬಿಡಿ. ನಾವ್ ಯಾರಿಗೂ ತೋರಿಸಲ್ಲ, ನಾವಿಬ್ರೇ ನೋಡಿ.
Yes.
ನಾನು ಇವ್ರಿಗೆ ಹೆಂಗೂ ತೋರಿಸ್ಲೇಬೇಕಾಗ್ತದೆ, ಇವ್ರಿಗೂ ಬೇಡ. ಅವರು ಇವರು ಎಂಪ್ಲಾಯ್ ಅದು ಅವ್ರು ಬರೋ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ.
Another,
ಅದು ಸಪರೇಟ್.
again, Malaj, coming back to the previous issue, I had, again, which is specifically why I requested Mr. Samits to be here, because we are only bound by his instruction. And
Of course, ಇವೆಲ್ಲ ಕೌನ್ಸಿಲ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಷ್ಟೇ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ನೀವು ಅದ್ ಮಾಡ್ಲಿಕ್ಕೆ ಯು ಕ್ಯಾನ್ ಆರ್ಗ್ಯೂ.
ಅವ್ರ ಕಲೀಗೆ ಹೇಳಿದೆ
Correct,
ಸರ್.
In lighter vein, as far as labor are concerned, they are always ready for a compromise, provided they are on their terms.
ಎಕ್ಸ್ಪೆಕ್ಟೇಷನ್ಸ್ ಎಲ್ಲ ಇರೋದಿಲ್ಲ.
My lords may keep also the fact that the 20 lakhs plus 91 lakhs also were
Which is already paid.
already paid.
Even that's paid to the employees who were on the roads as the data finding.
Office staff, now we are the labor.
ನಿಮ್ದು ಪ್ರಪೋಸಲ್ ಏನ್ರ ನಿಮ್ಮ ಯೂನಿಯನ್ ಲೀಡರ್ ಇದ್ದಾರಲ್ಲ ಅವರಿಗೆ ಕೌನ್ಸಿಲ್ ಆನ್ ರೆಕಾರ್ಡ್ ಮಾತಾಡ್ಕೊಂಡು ಕೊಡಿ.
Yeah, just at an appropriate time.
ಬಹಳ ಅನ್ರೀಸನೇಬಲ್ ಇರೋದು ಬೇಡ, ಯಾಕಂದ್ರೆ we are telling it actually.
That was my only concern, was now ಅರ್ಥ ಆಯ್ತು.
ಸಪೋಸ್ ಇದರಲ್ಲೇ ಆಗ್ಬಿಡ್ತು ಅಂದ್ರೆ
Correct.
ಇಟ್ಸ್ ಬೆಟರ್ ಟು ಬೈ
Put a
ಪೀಸ್,
quietness in.
ಆಲ್ವೇಸ್ ಬೆಟರ್.
As per that list, how much do we have to pay? 50 crores. 24. But as per that list which was submitted, we have to pay 24 crores. But that is on the assumption that the retrenchment is illegal right from the inception and then multiply into.
They will always say like
Oh.
that. They know where they stand, though they do not disclose it to us. We know that they know.
As per 21-22 minimum wages act ಪ್ರಕಾರ calculation. ಅದ್ರ ಮೇಲೆ ನಾವು.
That's what I'm saying. Assumption is that the retrenchment is illegal. There's no adjudication.
I encourage compromise, but don't participate in compromise.
ಅದು ಕರೆಕ್ಟ್. ದಟ್ಸ್ ರೈಟ್. ಅದು ಒಂದ್ಸರಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ಮೇಲೆ
ಅಯ್ಯೋ
ಸ್ವಲ್ಪ ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಒಂದ್ ಸ್ವಲ್ಪ ಮುಜುಗರ ಆಗ್ತದೆ.
Sobra comes. ನೀವೇನು ತಿಳ್ಕೊಳ್ಳಿ. Next question ಕೇಳ್ತಾರೆ. Deduction from earlier payment ಸಾಹೇಬ್ ಕೇಳ್ತಾರೆ. ಹೇಳ್ಬಿಡಿ. Subject to deduction from what is already paid ಅಂತ ಹೇಳಿ. You should be fair to them.
Yes.
ಹಣ ತಗೊಂಡಿದ್ದಾಗಿದೆ ಕೆಲವು ಅಂಶ ಏನು ಇವು ತಗೊಂಡಿರ್ಬೋದು, ತಗೊಂಡಿಲ್ದೇ ಇರ್ಬೋದು. ಏನ್ ತಗೊಂಡಿದ್ದರೆ ಡಿಡಕ್ಟ್ ಮಾಡ್ಬೇಕು. ಕರೆಕ್ಟ್.
ಆಮೇಲೆ 5,000 ರೂಪಾಯಿ ಇಂಟ್ರಿಮ್ ರಿಲೀಫ್ ಕೂಡ ಕೋರ್ಟ್ ಗ್ರಾಂಟ್ ಮಾಡಿತ್ತು ಸ್ವಾಮಿ, ಅದನ್ನು ತಗೊಂಡಿ. ಅದು
ನಿಮ್ಮ ಕೇಸದ ಮೆರಿಟ್ ಬಗ್ಗೆನೂ ಗೊತ್ತಿರಬೇಕು. ದಟ್ ಈಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಅದು ಇಲ್ಲ, ಇದು ಇಲ್ಲಾನು ಆಗಬಹುದು, ಅದು ಗೊತ್ತಿಲ್ಲ. ವಿ ಡೋಂಟ್ ನೋ.
With your lordship's permission, I'll just go to one more quote.
Yes, yes, yes. ಇದು ಏನಾಗಲ್ಲ, ಆರ್ಗ್ಯೂ ಮಾಡ್ಬಿಡಿ. ಸ್ವಲ್ಪ ಏನೇನ ಹೇಳಿದ್ರೆ ಹೇಳಿ. ಪಡಿ ಪ್ಲೀಸ್. ನಿಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇತ್ತು, ಇವ್ರು ಮುಗಿಸಿದ್ದಾರೆ.
ಇಲ್ಲ, ಎರಡು ಡಾಕ್ಯುಮೆಂಟ್ ತೋರಿಸ್ಬಿಟ್ಟೆ.
Just one, what I wanted to point out today, of course, I should have pointed out that day itself. I just want to trace a little bit of the labor proceedings, because my concern is, Malaz, in an original side appeal under the Companies Act, it's virtually being converted into a labor recovery thing, which is why I wanted to point out, Malaz, that finally they seem to be interested in the recovery. Some money seems to be, is what they want to expect. I don't think they even expect to work. I'm told, Malaz, that even if They are now, I mean, we're willing to offer, but then it'll take about 2 or 3 years to even absorb them. I think everyone knows that work is not going to happen. Finally, this is, so therefore, I just wanted to point out what His Lordship Justice Arvind Kumar held, where clearly he said that there has to be an adjudication for the retrenchment to be
Provided they make application.
correct, Manoj, provided, and
And
then the
liberty
next,
was given to them.
correct, and then next step was 33C2. Then what else they did was they filed a writ appeal, withdrew the writ appeal, filed a review, then filed another writ appeal. All of the time, Manoj, no application was filed. Then in 2022, they filed an application, and then that's when I think the Labour Commissioner says 28 years too late, you've come. So, and against that, I'm told a writ petition is now pending.
Yes.
That is pending.
Yes.
ಒಂದು ಎರಡು ಶಬ್ದ ಹೇಳ್ಬಿಟ್ಟು
ಹೇಳಿ.
Court officer, sir.
Court officer.
My colleague has flagged a document in 34 of 2014. ಅದು ಅವ್ರಿಗೆ ಇನ್ನೊಂದು ಚಾನ್ಸ್ ಕೊಡ್ತೀರಾ ಸಾಹೇಬ್ರ ಅದಕ್ಕೆ ಏನೋ ನಾನು ಹೇಳಿದ್ದು ಈಗ ನಾನು ಅವ್ರದ್ದು ಆನ್ ಮೈ ಟರ್ಮ್ಸ್ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಅದು ನನ್ನ ಶಬ್ದ ಅಲ್ಲ. ಮೊಹಮ್ಮದ್ ಅಲಿ ಜಿನ್ನಾ ಯೂಸ್ ಟು ಆಲ್ವೇಸ್ ಸೇ ಐ ಆಮ್ ರೆಡಿ ಫಾರ್ ಎ ಕಾಂಪ್ರಮೈಸ್ ಪ್ರೊವೈಡೆಡ್ ದೇರ್ ಆನ್ ಮೈ ಟರ್ಮ್ಸ್. ಹಾಗೆ ಆ ಇವರು ಆ ಥರ ಆಗಬಾರ್ದು ಅಂತ ಹೇಳಿ ಒಂದು ಚಾನ್ಸ್ ಕೊಡೋದಾಗ ಕೊಡ್ಬೋದು. ನನಗೆ ಐ ಆಮ್ ಫೀಲಿಂಗ್ uncomfortable with the figure that my colleague has given.
ಚಾನ್ಸ್ ಕೊಡ್ತಿದ್ವಿ ನಾವು, ಆದ್ರೆ ಗ್ಯಾಪ್ ಭಯಂಕರ ಇದೆ.
ಅದು ಚಾನ್ಸ್ ಕಮ್ಸ್ ಬಟ್ ಒನ್ಸ್.
Correct. Often it does not.
An offer comes but once. See, merely because my learned friend is fair, I should not expect this situation. That's the assurance I give to him and to the Honorable Court.
Anyway, all right. ಇಬ್ಬರು ನೋಡ್ಕೋತೇವೆ.
ಯಾವುದು ಇದು?
Reply affidavit.
ಇಲ್ಲ, in this document, ಎರಡು ಸೆಟ್ ಇದೆಯಾ?
ಒಂದ್ ಸೆಟ್ ಇದೆ, ಅಡ್ಡಿಲ್ಲ. ನೀವು ನೋಡ್ತಾ ಇರೋದು ಯಾವ್ದದು? ಇದೆ.
ಇನ್ನೊಂದು ಇದೆಯಾ ಎಕ್ಸ್ಟ್ರಾ? ಇನ್ನೊಂದು ಎಕ್ಸ್ಟ್ರಾ ಇದೆ. ಇದು this is that in 34 of 84, the propounder has filed an affidavit. I'm reading that. You have that and it's come from you. Please turn to page 3.
188. ಇರ್ಲಿ, ಅಲ್ಲಿ 3 we can understand that. Only 4-5 pages ಇದೆ. ಪ್ಯಾರಾ ಹೇಳಿ, ಅದರ ಬದಲಿ ಪೇಜಿನೇಷನ್ ಇಲ್ಲ. Instead you can quote paragraph number.
Kindly turn to para 6, 7 and 8. Averments in paragraph 19, 20 and 21 are here when he submitted that the petitioner.
ಅಲ್ಲೇ ನಿಮ್ಮ ಧ್ವನಿ ಕೇಳ್ತಾ ಇಲ್ಲ.
The above scheme was done by great effort.
ಎಲ್ಲಿಂದ ಓದ್ತಾ ಇದ್ದೀರಿ?
Paragraph 6, last but one page.
The averments at paragraph.
Averments at paragraph 19, 20, 21 are hereby denied. Submitted that the petitioner with intent of reviving the above scheme has put in great efforts to settle the dues of the creditors. The petitioner, who is also into some similar business, intends to revive the company in order to expand its manufacturing capacity. Petitioner is not into real estate business. Perhaps I would lay stress on that. It is submitted that the petitioner prays that the revival may be permitted under the supervision of this Honorable Court, whereby the petitioner would periodically furnish details regarding revival of the company for the kind perusal of the Honorable Court. It is further submitted that the meetings of the shareholders, creditors, and others were convened pursuant to the order of this Honorable Court, and the chairman appointed by this Honorable Court, upon being satisfied regarding the quorum, has called for the meeting in order and has taken the votes. The same was reported to the Honorable Court and is being accepted. At this stage, the validity of the meeting cannot be challenged. The meeting was called upon and the quorum present and the votes are considered. 6. Petitioner is ready and willing to provide employment for such persons who are on the rolls of the company as on the date of winding up. This may assume some relevance and importance.
This is as on which date?
Paragraph 7.
This was filed on which date?
22/6/2014.
That was more
Yes.
than 10.5 years, 2 days less than
Yes, please.
10.5 years. ಅದು ಆದ್ಮೇಲೆ ಏನೇನಾಗಿದೆ ಅಂತ ನೋಡ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ, ಆಮೇಲೆ next-
ಕಂಟಿನ್ಯೂಸ್ಲಿ ನೀವು ಇವರು ಬಿಟ್ಟಿಲ್ಲ ಏನ್ ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ. They have never allowed them to
No,
function at all.
I want the honorable court to put a question to them. Without working, can you ask this much money? ನಾನು ಹೇಳಿದ್ರೆ I will become a villain.
ಇಲ್ಲ.
No, no, no.
What you are doing it,
ನನ್ನ ಸಂದರ್ಭ ನೋಡಿ.
Understand.
That's
ಅಲ್ಲ, but therefore we did not, drag you in this talks at all, so that you can argue your matter. That's the reason. This was this is dated.
This is dated 26/6/2024. 26/6/24. ಇನ್ನೇನು ಇದು ನೋಡಿ. 14 ವರ್ಷ ಹಿಂದೆ.
Can I just point out one aspect, my lords, in this affidavit? I understand your lordship's doubt. The para 7, which my lords just read, the last words are as on the date of winding up order.
As of the date of
There were,
winding
as
up
the lordship recollects, there were 2 winding up orders. First winding up order was 27/7/2006, and the second winding up order is 20th March 2012.
Yeah.
And admittedly, all of the employees before your lordships today were retrenched on 27/7/94. So the undertaking may not,
ಆರ್ಡರ್ ಆದಾಗ ಎಷ್ಟು ಜನ ಇದ್ರು ನಿಮ್ ಪ್ರಕಾರ?
and that I'll have to find out, Mals. I'll just find out. But none of these employees were there because their whole grievance was that they were retrenched on 27/7/94 under 25FF.
25FF is transfer compensation.
Correct, my transfer, on the ground that there is a change in the
Change of ownership
management in the company.
management ಅಂತ.
That was of course subsequently in 2012 negative. But the fact of the matter is they were retrenched on 27/7/94. So this undertaking applies to those employees who are on the rolls as on the date of winding up.
That was
There are 2 dates, even assuming it's the earlier.
ಅಲ್ಲ, ಇದನ್ನ ಫೈಲ್ ಮಾಡಿದಾಗ ಅವಾಗ ಆಲ್ರೆಡಿ 2 ಇದ್ಬಿಟ್ಟಿತ್ತು ಅಂತನಾ?
At that time, order, the company already been wound up. So it file ಮಾಡಿದಾಗ there was definitely a winding up order. There were in fact 2 winding up orders.
ವೈಂಡಿಂಗ್ ಅಪ್ ಆರ್ಡರ್ಸ್ ಯಾವ್ಯಾವು?
27/7/2006 was the first winding up order. As the lordships may recall, that is Justice Sabayat's order.
27/7/06. Another is?
That 27/7/06 order was set aside on 4/10/07 by the division bench.
ಆಮೇಲೆ
The second order winding up is 23/2012, 20th March 2012.
Okay. As on that date ಅಂತ ನೀವು ಹೇಳೋದು.
Yes, ma'am.
ಅವಾಗ ಎಷ್ಟು ಜನ ಇದ್ರು ಈ ಡೇಟಿಗೆ?
ನಾವೆಲ್ಲ ಟೋಟಲ್ 150 ಜನ ಇದ್ವಿ.
ನೀವು ಬಹಳ ಜನ ಇದ್ರಿ. As on 20 March 2012, who were on the rolls of the company?
27/4/94 ನಮ್ಮನ್ನೆಲ್ಲ ರಿಟ್ರೀಚ್ ಮಾಡಿ ಹೊರಗೆ ಹಾಕ್ಬಿಟ್ರು ಸರ್. ದಟ್ ರಿಟ್ರೀಚಿಂಗ್ ಇಸ್ ಇಲ್ಲಿಗಲ್ ಅಂತ ಹೇಳಿ ಅಂತ ನಾವು ಲೇಬರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ವಿ. ಅವಾಗ ಲೇಬರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಮಗೆ 50% ವೇಜಸ್ ಕೊಡಿ ಅಂತ ಹೇಳಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ.
ಅದು ಹೋಯ್ತಲ್ಲ.
ಅದನ್ನ ಆಮೇಲೆ ಹೈಕೋರ್ಟಿಗೆ ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿ
ಅದು ಹೋಗ್ಬಿಡ್ತು, ಅದು ಇಲ್ಲೇ ಇಲ್ಲ.
ಆದ್ಮೇಲೆ ಮತ್ತೆ 4513 ಒಳಗೆ ನಮಗೆ ಇದ್ ಮಾಡಿ ನಮ್ಮ ಅಪೀಲ್ ನ ಅಪೀಲ್ ಮಾಡಿದ್ರು.
ನಿಮ್ಮ ಅಪೀಲ್ ಏನು ಅಪ್ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು?
ನಮ್ಮ
ದೇರ್ ಇಸ್ ನೋ ಟ್ರಾನ್ಸ್ಫರ್ ಎಟ್ ಆಲ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು. ಆಮೇಲೆ ಯು ಕ್ಯಾನ್ ಗೋ ಅಂಡರ್ ದಿ ಪ್ರಾವಿಷನ್ಸ್ ಆಫ್ ID Act ಅಂತ ಹೇಳಿದ್ರು. ನೀವು ಹೋಗಿಲ್ಲ, ಅದ್ರ ಬದಲಿ ನೀವು ಕಮಿಷನರ್ ಆಫ್ ಲೇಬರ್ಗೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್
ಅಲ್ಲಿಂದನೇ ಬರ್ಬೇಕು ಅಂತ ಹೇಳಿ ನಮ್ಮ ಸೀನಿಯರ್ ಅವಾಗ ಸುಬ್ರಾವ್ ಸಾಹೇಬ್ರು ಅದನ್ನೇ ಹೇಳಿದ್ರು.
ಸರಿ ಅಲ್ಲ,
ನಾವು ಇದ್ ಮಾಡಿ ಇವಾಗ ಗವರ್ಮೆಂಟ್ ನವ್ರು ಏನಂದ್ರೆ ಒಂದು ನೋಟು ಇದ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ, ಅದನ್ನ ನಾವು ಅಪೀಲ್ಗೆ ಇದು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿ ಅದನ್ನ ಚಾಲೆಂಜ್
ಮಾಡ್ಕೊಳ್ಳಿ. ಅದು ಸುಬ್ರಾಯ್ ಹಂಗೆ ಹೇಳಿದ್ರೆ ಎಲ್ಲ ಗೊತ್ತಿಲ್ಲ, ಯಾರೇ ಅದನ್ನ ಹೇಳಿದ್ರು ಅದು ತಪ್ಪಿದೆ. ಓಕೆ.
I think as on that day,
12,
the date of
12.
around 27 workmen or something like that.
27 ಇದ್ರಾ?
27, ಇದ್ರು ಅಂತ ಹೇಳಿದೆ. I am one of those.
ರೆಕಾರ್ಡ್ ಪ್ರಕಾರ.
I am one of those.
He appeared.
You are one of the workmen.
I am one of
the 27.
Out of those 27.
Now, the next document to be noticed by my lord is the OSA 8 of 2016 record, page number 64. This is scheme, it's scheme propounded. Sir, I request my lord's kind attention to paragraph 13 at page 64.
ಇನ್ನೊಂದು ಫೈಲ್ ಇದೆ.
ಎರಡು ಸೆಟ್ ಇದೆಯಲ್ಲ?
ಇದೆ ಇದೆ.
Please turn to page 64. It's a
OSA. ಹೌದಾ? ಹಾ, ಅದೇ.
It's annexure A to OSA 8 of 2014.
Are you, whether your client is agreeable for any proposal? You appear for whom?
I have paid CA 350.
Adhe.
I'm also an employee.
You are also working.
What I'm saying is, you let the scheme be fulfilled. That is all is my prayer.
ಅದು ಪ್ರೇಯರ್ ಆಯ್ತು. ಈಗ ನಮ್ದೊಂದು ಪ್ರೇಯರ್ ಇದೆ ನಿಮ್ಗೆ. Whether your client will agree for getting some money and say goodbye at least.
You would have to agree.
ಅಲ್ಲ ಅಂದ್ರೆ ಎಷ್ಟು ಏನಾರ ಇದೆಯಾ ಅಂತ.
Positive statement, make a positive statement.
ಹಾ.
An employee.
So
I'm
far
a
as-
saving.
27 ಜನ ಇದ್ರಿ.
There was no offer till now. It was only for them. I will.
Only problem,
ಅಲ್ಲ,
I don't
ಈ
know who
offer
they-
is not money.
No, it's
Quantum ಅಲ್ಲ.
not in part.
That was
Whole
Money.
Yes, sir.
money.
I understand.
Money which is in the purse.
Please.
Nobody will know how much it is ಅಂತ. ಅದು ನಿಮ್ದೇನ್ರ ಇದ್ರೆ ಹೇಳಿ. ನೋಡೋಣ.
How many people do they represent? We need to know that also. At least here the number seems to be 150. How many employees do my learned friends?
27 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
27 ನೀವ್ represent ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ 27 out of 150.
ಇಲ್ಲ, ಇಲ್ಲ ಅವ್ರೇನ್ ಹೇಳಿದ್ರು ಡೇಟ್
27
ಆಫ್
is to ಇರೋದೇ 27 ಆ ಡೇಟಿಗೆ ಅಂತ.
ಅವತ್ತಿಗೆ ಇರೋದ್
ಸೆಕೆಂಡ್ ವೈಂಡಿಂಗ್ ಅಪ್ ಆರ್ಡರ್ ಆದ
ಕರೆಕ್ಟ್. ಆಸ್ ಆನ್ ದಟ್ ಡೇಟ್ whoever employees.
ಮಾತ್ರ ಇದ್ರು.
ಕರೆಕ್ಟ್.
ಹಂಗಾಗಿ 27 ಪೈಕಿ ನಾವು ಇಬ್ರು
ಹ್ಮ್.
ಅಂತ ಅವರು ಅಂಬೋಣ.
That,
or wala.
as on if they were employees, as on that, that possibly, that 91 lakhs is possibly for that, but that I will get, that I'll have to, because the undertaking and the scheme of arrangement is very clear and explicit that it's the employees, any one-time settlement, any payment will be made. But the union unfortunately represents people who are retrenched far earlier, workmen who have retrenched far earlier. Now, if there are 27, I'll just check up if that number is correct. If there are 27 employees, then we'll have to again. I'll ask.
ಹಂಗೆ ಉಳಿತದಿಲ್ಲ ನೀವು ನಮ್ಗೆ ಹೇಳಿದ್ದು.
I thought when that offer is on the table.
If that is 27.
Correct. If that is 27.
Yes.
The propounder.
Ah.
This is a page 59, my lord, annexure A, scheme for arrangement for revival of the company, and this is the order in question. This is accepted and this is the subject matter. Please turn to internal page 64, ink page 64. And I'm requesting my lord's kind attention to 2 terms, 4 terms, 13, 14, 15 and 16.
13, 14.
13, 14, 15 and 16. Since the property of the company is situated in prime industrial location, the same can be better utilized for carrying out the objects of the company. Tikitala?
13, 14,
Ink
15.
page 64,
54 ಆ?
64.
64. You are right.
Paragraph 13, 14,
14,
15 and 16.
15, 16.
Since the property of the company is situated in prime industrial location, the same can be better utilized for carrying out the objects of the company.
ಏನಿದು? What is this document?
This is scheme.
Scheme.
And
Which,
then page 59, commencement.
Okay.
Scheme of arrangement for revival.
14, 13,
then
14,
Millard,
15, 16.
The propounder has already approached the major shareholders, debenture holders, and other existing secured creditors, major non-secured creditors of the company, and the employees who are on
Were
the
on
rolls
rolls on the date of winding
winding
up.
up,
Maybe
though their
their
representative-
affidavit is
Yes.
relatable to this.
Uh,
ಅಥವಾ their affidavit base ಮಾಡಿಕೊಂಡು ಈ ಸ್ಕೀಮ್ ಅನ್ನು ಮಾಡ್ಯಾರ.
yeah. So that is very clear. OTS, it's the OTS. Then paragraph 15. Since the shareholders, secured creditors, debenture holders, major unsecured creditors, and the employees with the company have expressed their willingness for one-time settlement, their dues, the propounder who is interested in the company has proposed this scheme arrangement. Then 16.
Employees of the company have expressed their willingness for one-time settlement of their dues.
So, propounder who is interested in the revival of the company has
Company
proposed this
has
scheme of
proposed
arrangement.
this scheme of arrangement.
This is the offer which
Ah.
is accepted by the court.
ಈ ಒನ್ ಟೈಮ್ ಸೆಟ್ OTS ಇದೆಯಲ್ಲ,
OTS.
in terms of that, what your clients did?
ಅದು ಮತ್ತೆ ಕೇಳಬೇಡಿ, ಅದು ಪ್ರಯೋಜನ ಇಲ್ಲ. ಅಲ್ಲ, ಯಾಕಂದ್ರೆ I should not
Okay.
enter into the bargain. 16. The scheme will also have a social objective in as much as the scheme is approved and the company stands revived, the employment opportunity can be provided. Besides the employment opportunity, the state exchequer will stand to gain by way of future taxes. This little ideas. Kindly go to page 68. In the tabular column of the scheme, at heading G, my lord would notice a tabular statement, and item 8 is the provision for employees, namely OTS.
Page?
Page 68. My lords would find a tabular statement.
Correct.
Item 8 is
Employees.
I'm supporting the view of the honorable court, that is OTS.
Correct.
Yes.
Because it is there on the record.
It's there. OTS, 8, item 8, as per OTS, employees. Then kindly turn to next, the bottom, portion 2, paragraph 2. The propounder undertakes to settle all dues of the employees of the company as per the one-time settlement. The company shall also offer employment opportunity to its employees upon commencing the commercial production after revival of the company, an assurance.
Correct.
Then will please turn to 9, paragraph 9. That is the
Upon the scheme
inconsequential but
becoming
noticeable.
effective.
Upon the scheme becoming effective, the propounder shall pay so and so of the company for every share of 1 rupee with full paid up and held by them in the company, subject to the production of the share certificate.
ಇದೇನು ಸಂಬಂಧ ಇಲ್ಲ.
Then kindly, then 13. I do to close. Next page 13.
You are right.
In the event of the scheme failing to take effect, the scheme shall become null and void, and no right or liability accrue.
No right or liability whichever would accrue to the
Yes, sir.
incurred inter se by the propounder or any of the creditors.
The order accepting the scheme is at page 28, the impugned order.
Page
28. Paragraph 4.
ನಮ್ಮ ಬೈರಾರೆಡ್ಡಿ ಸಾಹೇಬ್ರ
Yeah, hold on. I think must have read it. I think I wouldn't weary your lordship.
ಅದೇ
That's
ಅಲ್ಲಿ ಒಂದು 38 ಬಂದಿ ಒಂದು
38. All other reports filed by the official, other head,
Next.
and the application become infectious and accordingly disposed of. Official liquidator claims that there are further charges towards securities services to be paid by the ಅದೇನು ಅಗತ್ಯ ಇಲ್ಲ. No, my lord, when an appeal was filed against this, the appellate bench, the writ appeal court, said that you file a review petition. A review petition was filed. The review petition order is at page 42. Against that, the present appeal. ಇದು ಕಾಬ್ವೆಬ್ ಅಂತ ನಾವೊಂದು ಸಾಮಾನ್ಯ ಒಂದು ಬೆದರಿಕೆ ಬರುತ್ತೆ. This is bigger than the cobweb. the learned senior advocates is also on instructions from the instructing counsel would submit that the petitioners are before the court without there being any claim adjudicated. ನಮ್ಮ ರಿವ್ಯೂ ಪಿಟಿಷನ್ಸ್ ಸುಬರಾಯರು 9 ದಿವಸ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರ ರಿವ್ಯೂ ಗ್ರೌಂಡ್ಸ್ ವೊಲ್ಯೂಮಿನಿಯಸ್. And ultimately, the one submission is grounds urged in support of the review petition are neither considered nor noticed. Well, for this OSA, the ground I am submitting is the various grounds urged in the review petition and presented before the court are not considered, and ultimately it would, so one senior advocate made a mention that you kodbekadala kottide anta, that is accepted as true. Then Subbarao, paragraph next page 5, learned senior counsel Subbarao would however submit that the large number of workmen are qualified workmen they may employ. Then assurance is given that they will be employed. And after this date,
This is which date?
this is
2016,
15,
April 2016.
11/4/2016.
As on that, nobody was in employment.
No, that is the statement given at that time. That's the statement given. Well, we gave the statement, it is with them.
ಗೊತ್ತಾಯ್ತು.
ಅಲ್ಲ,
ಶ್ರೀ ಕಸ್ತೂರಿ
ಹಾ.
ಆ ಮುಂದ್ಗಡೆ ಏನೋ ಒಂದಿದೆ ನೋಡಿ.
ಕೊಡಬೇಕಾದೆಲ್ಲ ಕೊಟ್ಟಿದೆ ಅಂತ ಎಲ್ಲಿದೆ?
ಅಲ್ಲ
ನಾವು we are not calling in question the statement made at the bar. We are only trying to infer that ಕೊಟ್ಟಿಲ್ಲದೆ ಇರುವಾಗ ಸಂದರ್ಭದಲ್ಲಿ ಇದ್ದೇವೆ, ಈಗ ಮಾತಾಡ್ತಾ ಇದ್ದೇವೆ. ಇಲ್ಲಿ ಹೇಳೋದು ಅವ್ರಿಗೆ ಕೊಡಬೇಕಾದೆಲ್ಲ ಕೊಟ್ಟಿದೆ, ದಿಸ್ ಬೇಕಾರ ಅಪೀಲ್. That is the submission made. And ಇಷ್ಟೇ ಅಲ್ಲ, during the pendency of OS 8 of 2006, when the Honorable Division Bench was hearing the matter, similar statement was made and it was dismissed for default. On demonstration of the fact, then there was a change of advocate and Shankar walked in. The only point I pointed out to the court was this submission that kodbekadala kottide is false. The court accepted it and restored the file. Well, this is where we are. Now, Millard, to make it very short, I would only, I think I should, the Ramakrishna Menon is of some assistance. Your Lordship will.
ಅದು only right of audience ಕೊಡ್ಬೇಕು ಅವರಿಗೆ ಅಂತ
compilation ಒಂದು ನಾನು ಈಗ
ಇನ್ಫ್ಯಾಕ್ಟ್ 529 ಕ್ಯಾಪಿಟಲ್ ಎ ಇರಬೇಕು ಸೆಕ್ಷನ್ ಆಫ್ ದಿ ಕಂಪನೀಸ್ ಆಕ್ಟ್ ಪರ್ಸೂಯಂಟ್ ಟು ರಾಮಕೃಷ್ಣ PR Ramakrishna
and it's a constitution bench decision
ಅಲ್ವಾ?
ಹೌದು,
ಕರೆಕ್ಟ್.
PR Ramakrishna Menon ಅಲ್ಲಿ ಒಂದು ಅವರು
ಜಜ್ಮೆಂಟ್
no, justice 3:2 was the decision. The Honorable Justice E.S. Venkatramaya pronounced the judgment on by the majority. Then Millard, Justice Chinnappa Reddy found fault with one narration of a perspective, perspective, and the Chinnappa Reddy adds to sentence, I will give my reasons for this ಅಂತ ಹೇಳಿ ಡಿಸೆಂಟ್ ಗೆ ಕೊಡ್ತಾರೆ. ಅದನ್ನ ತಮಗೆ ಒಂದು ನಿಮಿಷ ಹೇಳ್ಬಿಟ್ಟು ಅದನ್ನ ಹೇಳ್ಬಿಟ್ಟು ಐ ವಿಲ್ page 87 in my compilation, kindly go to page 87.
ಕೊಡಿ.
Page 87 ಅಂತ ಇಲ್ಲಿ ನಿಲ್ಲಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಇನ್ನೊಂದು ಸಿಕ್ತಾ?
87 ಅಲ್ಲಿಂದ ಬಿಗಿನ್ ಆಗತ್ತೆ. ಯಾವ ಪೇಜ್ ಅನ್ನ ಓದ್ಬೇಕು ಅಂತೀರಿ ನೀವು?
ಕೈಲಿ
ಒಳ್ಳೆ ಜಜ್ಮೆಂಟ್ ಇದು. ನಮ್ಗೆ ಲೇಬರ್ ಲಾ ಹೇಳುವಾಗ ನಮ್ಮ ಪ್ರೊಫೆಸರ್ ವಿಶ್ವೇಶ್ವರಯ್ಯ ವಿಶ್ ಟು ಟೆಲ್ ದಿಸ್.
ಅಲ್ಲ, ಈಗ ಯಾಕಂದ್ರೆ ಐ ಆಮ್ ಟ್ರೈಂಗ್ ಟು ಟೇಕ್ ಅವೇ ದಿ ಕ್ರೆಡಿಟ್ ಫ್ರಮ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಸೆಡ್ ರಾಮಕೃಷ್ಣ ನೋಡಿಲ್ಲ ನೀನು ಅಂದ್ರಿ. ನೋಡಿದ್ದೇನೆ, ಹಾಕಿದ್ದೇನೆ.
ಅಲ್ಲಿ ಎಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ?
ಅವರು ಲೇಬರ್ ವಿಷಯದಲ್ಲಿ ಹೇಳುವಾಗ ಚಂದಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ. ಅದನ್ನ
105 ಬನ್ನಿ.
105
ಜಜ್ಮೆಂಟ್
105 ಎಲ್ಲ ಅಷ್ಟೇ.
So Justice Chinnappa Reddy also agreed with Justice Bhagavati.
Yes, sir.
But he gave additional reasons.
He quotes Shakespeare to disagree on a note that came from your lordship. That statement of from Justice Reddy. paragraph 13. ಅಲ್ವೇ? Paragraph 13,
1-3.
a page number ನನಗಿಲ್ಲಿ
Correct, 13 in the
Ah.
beginning act.
majority. I agree with my brother Bhagavati. I wish to add a few words, and not because I have much more to say, nor ever hope to say that what he said more felicitously, but because my brother Venkatramaya has disagreed, and my regard for him compels me to add a few words of explanation. You take my life when you do take the means where I live. You take my life when
If you take
my
the means of
livelihood.
livelihood,
Yes, yes.
this is Olga Tellis perhaps.
Yes.
They have borrowed from
No, yes,
Shakespeare's.
please, please. This indeed is the cry of the workers of Ramakrishna Industries Limited. The desire to be heard by for the board. Bread, ಅದು board ಅಂತಿದೆ, ದಯಮಾಡಿ bread ಅಂತ ಓದ್ಬಿಡಿ. To be heard before the bread is taken out of their mouth. A battle royal appears to be raging between the two rival groups of shareholders of the company. A petition for winding up the company has been presented by one group of shareholders, and an application for the appointment of a provisional liquidator too. Quite apart from section 445(3) of the Companies Act, which provides for the order of the winding up, it shall be deemed to be a notice of discharge of the officers of the company, employees of the company, except when the by this sentence next is it is plain that the future of the workers is at stake, and their right to work is in jeopardy as the result of presentation of the winding up petition. I think I should stop here and say that your lordship will, the labor jurisprudence is more pronounced than ever before. And the situation is that they have a say in the matter. Their say is not heard. The review petition filed is dehorsed. In fact, it's like a sphinx. Doesn't give the reasons. Say, Vishwamitra said when Menaka came, no, not mine. The child was his, he said, not mine. And that's how the story began in the Mahabharata. You will have to see this, and as I submitted, the decisions require, the order requires to be considered. And again, ನೀವು ಕೇಳ್ತೀರಿ ಎಷ್ಟು ವರ್ಷ ಮತ್ತೆ ಮಾಡಬೇಕು ಅಂತ. That
ಅದಕ್ಕೆ ನಾವು ಹೇಳಿ
no, I'm that way. ಇನ್ನು ಯಾರು ಬೇಡ, ನೀವು ತಿಳಿದಿದ್ದನ್ನ ಕೊಡಿ. ಇವ್ರನ್ನ ದೊಡ್ಡ ಬಾಯಿ ಬಿಡ್ತಾರೆ. They open their mouth as long as the nerves permit. Please put a restraint on them, and my letter friend, I borrow from him equitable order. He said equitable order. Kindly pass an equitable order that meets the ends of justice, and we trust the honorable court. There's no meaning in opening our mouth too wide or make a cry before the honorable court. There's no meaning. Please pass equitable orders.
ಹಿಂಗೆ ಹೇಳಿ ಇಟ್ಬಿಟ್ರೆ ನಮಗೆ ಎಷ್ಟು ತ್ರಾಸ ನೋಡ್ರಿ.
I'll be the last one, your lordship knows not to ask for equity from this court, but no, honestly, at the end of the day, the issue boils.
ನೀವು ಅದನ್ನ ಒಂದು ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇತ್ತಲ್ಲ, ಕೋರ್ಟ್ ಮೇ ಪಾಸ್ ಸಮ್ ಇಕ್ವಿಟೇಬಲ್ ಆರ್ಡರ್ ಅನ್ನೋದೊಂದು ಮೆಮೊ ಹಾಕಿ ಕೊಟ್ಟುಬಿಡಿ. ವಿಲ್ ರಿಪ್ರೊಡ್ಯೂಸ್ ಇಟ್. ಅಲ್ವಾ?
Should not be difficult.
Correct.
Yes, that Mataya.
But ಅದು ಸೈನ್ ಮಾಡಿಸ್ಕೊಡಿ, ಬೇರೆ ನಿಮ್ದಷ್ಟ ಬೇಡ.
ಕೋರ್ಟ್ ಈಕ್ವಿಟಬಲ್ ಆರ್ಡರ್ ಮಾಡ್ಬೋದೇನಪ್ಪ?
ಹಾ.
ಅಲ್ಲ, ನೀವು ಹೇಳ್ಬೇಕು ಅವ್ರಿಗೆ. ನೀವು ಹೇಳಿದ್ರೆ ನಾವು ಬರ್ಕೊಡ್ತೀವಿ.
ಕರೆಕ್ಟ್. ಅವ್ರ ಕೈಯಿಂದನೇ ಬರ್ಸ್ಕೊಟ್ಬಿಡಿ.
ನಮ್ಗೆ ಅನುಕೂಲ ಆಗುತ್ತೆ ಅಂದ್ರೆ ನಾವು ನಮ್ಗೆ ಅನುಕೂಲ ಆಗ್ಬೇಕು. ಯಾಕೆಂದ್ರೆ 30 ವರ್ಷದಿಂದ ತುಂಬಾ ಸಫರ್ ಆಗಿದ್ದೀವಿ. ಅದೊಂದು ಮನಸ್ಸಲ್ಲಿ
ಅದ್ ನೀವು ಈಗ ನಿಮ್ಮ ವಕೀಲರು ವಾದ ಮಾಡ್ಯಾರೆ, ಅದಕ್ಕೆ ನಿಮ್ಮ ಸಪೋರ್ಟ್ ಇದ್ರೆ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಕಾನೂನು ಪ್ರಕಾರ ಏನ್ ನಮ್ಗೆ ತಿಳಿಯುತ್ತದೆ.
ಕಾನೂನು ಪ್ರಕಾರ ಅಂತಲ್ಲ, ಈಕ್ವಿಟಿ ಪ್ರಕಾರ ಆರ್ಡರ್ ಮಾಡಿ ಅಂತ ನಾವು ಹೇಳ್ತಾ ಇದೀವಿ.
ನಿಮ್ ಲಾಯರ್ ಹಂಗ ಅದು ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳುವಾಗ ಸ್ವಲ್ಪ ಅದ್ರ ಮರ್ಮವನ್ನು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು.
ಹೌದು. I don't want Jinnah to appear again here. Adiga has something, he will get that. One memo hakake.
All right.
My lord, my situation has become like Trishanko. I don't know, my lord, whether to argue because.
Argue. Your prerogative, lawyers' right to argue.
No, my lord, for that reason. But the scope of appeal is what was being argued here. What I am taking your lordships now is not just as to.
391 ನಿಮ್ದು.
392, section
ಅದು
392.
ಕಣ್ಮುಂದೆ ಇಟ್ಕೋಬೇಕು ಅಷ್ಟೇ.
The issue where, my lord, one of us will lose the opportunity of appeal. Only that is the reason, my lord, that is there. Otherwise I will argue.
ಹೇಳಿ ನಿಮ್ದೇನು ಹೇಳ್ತೀರಿ ಹೇಳಿ. But Shankar's wise words,
Please, my lord.
see how he played with the mind of the court. He took us to Shakespeare, Merchant of Venice, gradually, and he came down and he said, we should not wide open our mouth. There lies all the, ಎಷ್ಟು 50 ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿರ್ಬೋದು, ತಮ್ದು ಪ್ರಾಕ್ಟೀಸ್ ಆಗಿರ್ಬೋದು, 50 ವರ್ಷ ಆಗಿದೆ.
ನನ್ನ ಪ್ರಾಕ್ಟೀಸ್
ಹಾ.
don't react. This is my 63rd year. And at the age of 19, I became an advocate, and Bar Council had difficulty in enrolling me. E.S. Venkatramaya, A.C. Bhairappa and Itaraj sat together one evening in Century Club and resolved it. Shankar, you become a legal practitioner at the LP Act 1924. And by reason of the fact that I was a legal practitioner, I was enrolled the next day. Hoodwinking law was the first issue in that. At the age of 19, I was an advocate.
But you have to leave your legacy to young people like us. Yes. See what he said, we guessed. It arises, the wisdom arising from long experience at the bar life. ಆ wisdom ನಿಂದ ಹುಟ್ಟುವಂಥ ಲೆಸನ್ ಅನ್ನು ತಗೋಬೇಕು ನಾವು. ಯಾವುದೋ ಒಬ್ಬ ಇಂಗ್ಲಿಷ್ ಪೋಯೆಟ್ ಹೇಳಿದ್ದ, we had experience but missed the meaning ಅಂತ. ಹಂಗಾಗ್ಬಾರ್ದು. We should have experience, we should derive lesson from the experience. So with that preamble, prelude, you may start your argument.
My lord, the respondent herein, my lord, brief facts of the case. This company, my lord, that is Shrishma Fine Chem Company Limited, my lord, it was into manufacturing, my lord, of pharmaceutical products. My lord, it had huge land bank of around 42 acre, 38 guntas of land. My lord, due to pollution control problem and all other issues, it became sick and ultimately it went into liquidation.
Saga.
The second time, my lord, few of the employees, including the petition applicants who are there herein, they had also approached this honorable court for revival of the company. It did not happen. We could not get the necessary funds. And further, my lord, we filed, the company was wound up. We went to appeal. It was remanded. Even at that point of time, it was not there. Ultimately, the company came to be wound up. But after company coming into becoming wound up, my lord, the respondent herein filed an application.
It was not wound up. It
was
was
wound up.
ordered to be wound up.
Ordered to be wound up. It
There
was
is
not.
lot
dissolved.
of difference
Please,
between
my lord.
company, your brother
Please,
knows that. He appeared.
It was
for
ordered to
company
be wound up.
Long period.
It was ordered to be wound up. On 23/2012 was the second order which was passed. But at that point of time, the situation is there was building, there was 42 acre, 38 guntas of land, which was there. At that point of time, the respondent herein filed an application. My lord, section 391 of Companies Act, whatever, my lord, they might say they have purchased all the secured creditors, they have assigned all this interest, they have right to file an application seeking for revival of the company. Now, once the revival application is filed, this honorable court ordered for meeting of the shareholders and secured creditors.
Right,
3/4 majority, they
employees
said that it is there. But in the scheme of
Employees ಇರ್ಲಿಲ್ಲ ಅದರಲ್ಲಿ. Employees ಇರ್ಲಿಲ್ಲ.
employees ಇರ್ಲಿಲ್ಲ.
Other day, Vikram
they,
had shown that.
At that point of time, employees were not heard, or their meeting was not called out. Even as a unsecured creditor or anything, they were not permitted. Kindly take, my lord, scheme of arrangement annexure E1, my lord, company application 237 of
ನಿಮ್ದಾ?
2023. Now,
ಕೊಡಿ.
company application 237, it is a connected matter, my lord, which is there.
What is your prayer in that?
My lord, to enforce
391 is your prayer.
392.
392 is
Kindly,
your prayer.
my prayer.
Correct.
Restrain the respondent company represented by its propounder from selling the scheduled properties. But the second prayer is what ultimately 392 says. direct the respondent number 2 to revive the respondent number 1 company by restarting the factory and reinstate the applicants as its employees with all the benefits. Now, the reason why I have filed this application, I will take, my lord, your lordship, with section first application, afterwards the provisions of law, my lord. Now, situation.
Others come afternoon. This will go on. You are entitled to sit. But don't feel that you are captive audience, because we may not take the next matter. We'll finish up this matter. And that apart, we have some bar association ಕಾರ್ಯಕ್ರಮನೂ ಇದೆ ಇಬ್ಬರಿಗೂ ಅದಕ್ಕೆ. Yes. Please, ಅದಾದ್ಮೇಲೆ you said it. ಬೇರೆ ತೊಳಿ.
Scheme of arrangement, my lord, page number 135. Which, my lord, is
Therefore, you oppose a review. Since you seek
enforcement. I am not asking for setting aside of the order, but at the same time, my lord, why the situation has arisen is, here the respondent, in brief, just my argument is, everyone filed objections saying that it is an intention of the company to sell the land, that is the propounder, and not to restart the company. He filed an affidavit every time before this honorable court, assuring this court that I will revive. I am not into real estate business. Thereafter, on the basis of that representation, company got revived. There is affidavit also filed stating that I will restart the factory. I will take everyone employee whoever is eligible. Afterwards, now stating that we could not start factory. There is no, we are having hardship in starting the factory.
Throughout ಈ ನಮ್ಮನೆ litigation ದಲ್ಲಿದೆ. ಈಗ ಮತ್ತೆ ಎರಡು ಸೂಟ್ ಇದಾವರು.
The scheme.
Sit down.
If that assurance, if I can.
Can't overtake the lawyer. It's lawyer's prerogative. Yes.
If I will take your lordships through assurance first, and thereafter the law. That is.
Shankar has shown that assurance.
The Shankar has, the senior advocate has shown the assurance that affidavit. As to in what context it is filed, the first affidavit is filed by the official liquidator and the KDB. Apologies, my lord. Please, my lord.
Which paragraph? Could the lordship excuse me for 5 minutes? Once court one matter each. Just 5 minutes.
ಆ 5 minutes ನಲ್ಲಿ ಮುಗಿಸ್ಬೇಕು ಅಂತ ಅವ್ರು ಹೇಳಿದ್ದೆ ನಿಮ್ಗೆ.
ಅಲ್ಲ, ನಂದು ಅಷ್ಟರೊಳಗೆ ಆಗುತ್ತೆ.
ಬರೋದ್ರಲ್ಲಿ ಮುಗಿಸ್ಬಿಡಿ.
Lord, annexure E1. Page 130, my lord, is the scheme of revival.
130. Mr. Shankar took us
Please,
through
my
that
lord.
also.
It is 136, my lord, was because this is what, my lord, scheme will not be revived. Had I come to this court at that point of time, or any other real estate person had come before this court, that I am interested in that company, I want to purchase that land and sell that land.
16, para 16.
Para 16, my lord, is what the first assurance.
Employment opportunity can be provided.
Can be provided. Please.
If the scheme is approved,
if the scheme
and the company stands revived,
it is the first scheme, my lord.
Correct.
They will have to tell something to the court that this is how I want to revive this company. It is on the basis of this, an application will be allowed for holding the meeting of the shareholders as well as the creditors of the company. Now kindly take, my lord, page number 139, the scheme. Para number 2. The propounder undertake to settle all dues of the employees of the company as per the one-time settlement. The company shall also offer
that one-time settlement. Yes, sir.
One-time settlement, there is, no one has produced, my lord.
ಮತ್ತೆ ಅದು ತೋರಿಸೋಕೆ ಇದನ್ನ ಎನ್ಫೋರ್ಸ್ ಮಾಡೋದಿದ್ರೆ
Enforce. One-time settlement ಆಗ್ಲಿಲ್ಲ. There is no one-time settlement. Then further, because, my lord, kindly say, my lord, it is
company shall both the sides shall undertake talks towards OTS ಅಂತ ಬರಬೇಕಿತ್ತು ಅದು. Otherwise, ಈಗಾಗಲೇ talks ಆಗಿದೆ, one time settlement ಆಗಿದೆ ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ಇದೆ.
It is an ex parte. He files an application. It is not that employees are made party to any of these proceedings. It is an assurance given by a propounder.
The company shall also offer employment opportunity to its employees
upon commencing the
commercial production after the revival of the company.
Now, this is the scheme which he wanted it to be sanctioned by this honorable court for revival of the company.
Correct.
company ordered for, my lord, meeting of the shareholders and, my lord, that is annexure F, page 142 is there.
ಆಯ್ತು, ಇನ್ನು
ಅದು,
ಎರಡು ಸರಿ.
That is,
Where ಡಿಸೈಬರ್ ಆರ್ಡರ್.
please, my lord. And chairman's report, everything, my lord.
ರಿಪೋರ್ಟ್ ಓದಿದ್ರೆ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರಲ್ಲ, ಎಂಪ್ಲಾಯೀಸ್ ನಾವು
Employees.
ಕಟ್ಟಿಲ್ಲ ಹಿಂಗೆ ಅನ್ಕೊಂಡು ಹೇಳಿದ್ರು, ಅದು ಇದೆ.
ಅದು ಇದೆ.
Okay.
Thereafter, after meeting is held, my lord, the position of law is that just because 3/4 majority of shareholders or anyone accepts, that does not mean court is bound to sanction the scheme. Court will make sure that this scheme is in the benefit of the revival of the company or in the benefit of the overall everyone person of the company. Hence, my lord, objections will be called for from the all the stakeholders who are present in the court. That is to say, my lord, ROC, that is regional director who looks after the affairs of the company, or as the official liquidator as in the case, because it was already wound up. In this case, they also filed objection before this honorable court. That objection, my lord, of official liquidator
Is that?
Lord,
ಅಲ್ಲ, ನೀವು ಅಲ್ಲಿಗೆ ಯಾಕೆ ನಮ್ಗೆ ಕರ್ಕೊಂಡು ಹೊಟ್ರಿ ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಸ್ಕೀಮ್ ಅಪ್ರೂವ್ ಆಗಿದೆ.
scheme approve ಆಗ್ಲಿಲ್ಲ ಇನ್ನು.
ಆಗಿಲ್ಲ.
This is the scheme. After ಒಂದಾದ್ಮೇಲೆ ಒಂದು stage, scheme meeting report and court ಮುಂದಿಟ್ರು. Thereafter, it will not be sanctioned. All others objection will be called for by the company court. That was called for, and reply statement was filed by the official liquidator, page 172, annexure J.
172.
Yeah, later.
Saying,
My lord, kindly take, my lord, page 173. The company in liquidation is having assets. 42
Para
acres
3.
ಇದೆ, ಪ್ಯಾರಾ 3 ಒಳಗೆ ಎಷ್ಟು ಅಸೆಟ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು. My lord, kindly take page number 179, para 17. That the official liquidator submits that in exercising the power under this section, the court so far as possible follows principles applicable to insolvency proceedings relating to an individual. Court inquires as to whether trading operation are fair, whether company became a victim of some temporary embarrassment, commercial solvency needs to be tested. A very valuable summary of legal proposition relating to discretion of the court vis-a-vis power of stay of winding up proceedings is it is extracted. If the court, my lord, H in that, my lord, resumption of business of the company is a must.
ಇದು ರೇಷಿಯೋ ಡೆಸಿಡೆಂಡಿ ಆಫ್ ರಾಯ್ ಚೌಧರಿ ಕೇಸ್ ಇದು.
Rai Chaudhary case, and this is what will be looked into by the company court while sanctioning this scheme. Now, after this, that the official liquidator further submitted scrutinized on the basis of the above mentioned principles, few glaring discrepancies are noticed. It files the following objection. Kindly take page 181. B. That the applicant claims that he is in the similar business
of the company in liquidation. ಹಂಗಾಗಿ provide the names of such companies along with the constitution of the board ಅಂತ ಕೇಳಿದ್ರು.
because it was a pharmaceutical company.
Correct.
He had assured that he will restart the production. But the applicant claims that to pursue the main objects of the company in
ಬಿಡಿ,
liquidation.
ಅದು relevant ಇದೆ. Come to 183.
183.
Para 24 ಗೆ ಬನ್ನಿ.
Para 24. That the official further submitted on perusal of the above mentioned statement elucidates that applicant is spending, investing approximately an amount not exceeding 116 crores for settling dues of workers, not quantified, assumed to be 2.36 crores.
2.36 crore ಅಂತ.
The market value of the land and building of the company in liquidation is not less than 50 to 60 crores. It was as on that date.
2. Assumed to be 2.36 crore ಅಂತ. ನಿಮ್ಮ ಫಿಗರ್ ನಿಮ್ಮ ವರ್ಕ್ಮೆನ್ ಆಫ್ ಕೋರ್ಸ್ ಯೂನಿಯನ್ ಲೀಡರ್ ಕೊಟ್ಟ ಫಿಗರ್ ಇದನ್ನ ಕಣ್ಣು ಮುಂದೆ ಇಟ್ಕೊಂಡು ಮಾಡಿದ್ರೆ ಇದ್ರ ಎಷ್ಟು ಪಟ್ಟಾಗತ್ತೆ ಅಂತ ನೋಡ್ಕೊಳ್ಳಿ. ಜಸ್ಟ್ therefore Mr. Shankar was saying pass equitable order.
Para number 25.
Further submit that with all these
Down the road.
features when scheme is filtered through the canons.
My lord, without firm commitment of
Fine.
revival of the company in liquidation, the tall and noble claims made by the applicant regarding providing employment and revenue to the exchequer is building castles in the air. And
Come
further,
to,
it
come to
directs-
A. A.
Applicant be directed to file an affidavit that the land will be used for setting up factory industry and not for any other commercial exploitation. Applicant to show his bona fide be directed to deposit in his, in this honorable court a sum required for revival of the company. Applicant be directed to file quarterly returns with the honorable court. Now he files an affidavit that is Annexure K, page 186.
186.
86.
Got it.
This is reply affidavit to the statement of by the official liquidator.
Come to 6.
Para 6, my lord. This is where averments made in para 19, 20, 21 are hereby denied. It is submitted the petitioner with intent of reviving the above scheme has put up great efforts to settle the dues of the creditors. The petitioner who is into similar, he also says who are into similar business, because that is the objection. The context has to be seen with the affidavit filed by the official liquidator. Intends to revive the company in order to expand its manufacturing capacity. The petitioner is not into real estate business. It is submitted that petitioner prays that the revival may be permitted under the supervision of this honorable court, whereby the petitioner would periodically furnish the details regarding revival of the company for kind perusal of this honorable court.
That was in 2014.
No, my lord, it is not about 2014. It is to sanction the scheme, unless if that,
No, no.
my lord,
This affidavit
this
was
is affidavit.
filed.
That is before the sanctioning of the scheme.
Correct.
It is in aid of all this.
June 2014.
June
ಅಂತ date
2014.
ಇದೆ ಅದರಲ್ಲಿ.
Please, my lord.
Ah.
No, this is in 2014, my lord, but it is before sanctioning of the scheme.
Okay.
Now, further, my lord, page Annexure L, page 191.
Yes.
The
Paragraph.
ROC, my lord, files an objection.
Come to 194.
194, my lord.
Yes.
Para number 7.
Read.
Clause J of the petition provides that upon scheme becoming effective and payment of dues to KDB, the KDB shall execute sale deed in favor of the company in respect of leasehold properties. Consent. However, such transfer of land in favor of propounder should be subject to condition using land only for the revival of the company and not for doing any real estate business. Even in para 5, my lord,
Real estate business ಅನ್ನ ಮಾಡಬಾರದು ಅಂತ. That does not mean should not sell the land ಅಂತ.
one minute.
All difference ಇದೆ
ಹೌದು.
ಎರಡಕ್ಕೂ.
ಅಲ್ಲ 193. Kindly take page number 193.
193. ಯಾವುದು?
Revival, para 5.
In liquidation,
Revival of the
maybe
company in
for
liquidation
running
may
the-
be for running of the business of the company for which it was
Maybe for the running of. ನೋಡಿ.
not for doing real estate business.
ಹಾ.
No, this is the observation. Remember, what I am submitting before, and reply affidavit is filed, Annexure M.
ಹಾ.
Page 195, Annexure M. Reply affidavit by the propounder. Page 198, my lord, is the relevant portion. Regarding
Para-
3,
para
5.
5 middle.
Middle,
ಹಾ.
3, 5. ಅದಕ್ಕೆ ಅಂದ್ರೆ to reply to that affidavit filed by the ROC, he files a counter affidavit. It is submitted that the petitioner with intent to reviving the above scheme has put up in the great efforts. The petitioner who is also into similar business, same, in order to expand the business in its manufacturing capacity. The petitioner is not into real estate business. Further, petitioner is ready and willing to provide employment for such persons who were on the rolls of the company as on the date of winding up. Next para number 6.
Last 5 lines.
Please, my lord. It is in reply. The petitioner
Petitioner most humbly submits.
please, my lord.
ಇದು ನಾವೆಲ್ಲ ನೋಟ್ಸ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿವಿ ಈಗ ಓದ್ಕೊಂಡು ಅದಕ್ಕೆ ಇಷ್ಟೆಲ್ಲ ನಿಮ್ಗೆ ಲೀಡ್ ಮಾಡೋದು. Yes. Ready and willing to abide by any such conditions imposed by court.
The ultimate intent for the above petition is to revive the company which has potential to sustain rather than being liquidated.
Yes.
But the position of law, my lord,
Is
with respect to this, my lord,
ಅದಾದ್ಮೇಲೆ ಈ ಆರ್ಡರ್ ಆಗಿದೆ.
it is sanctioning the scheme. Now, my lord, with respect to this, company in liquidation, my lord, ultimately the entire custody of the company is with the company court. there are various shareholders, creditors and everyone. For suppose company in liquidation, everyone has an uncertainty whether they will get 1,000 rupees or 1 rupee, they don't know, or they might not even get any amount.
ಒಂದು assurance ಏನು ಅಂದ್ರೆ you will not be liable to pay ಅನ್ನೋದು ಬಿಟ್ಕೊಂಡು ಅಷ್ಟೇ. Because company is founded on the principle that it trades with limited liability.
Please, ma'am. Now, he proposes a scheme. Now, entire shareholding he wants to take over. That means to say ownership of the company. So, this happened, my lord, in Bombay and everywhere. Well, my lord, oil mill company and everything, when it was wound up, everyone started propounding a scheme only with an intention not to revive any company or anything, but to take over the land. So, throughout, my lord, Honorable Supreme Court, various courts have made sure that if it is only with an intention to take over the land, no one will sanction the scheme. If I come before this Honorable Court saying that I want this land, that's why I want to propose a scheme, this Honorable Court would not have sanctioned the scheme. So when everyone files an objection saying that this is your intention,
ಅದನ್ನೆಲ್ಲ consider ಮಾಡಿ sanction ಮಾಡ್ತೇವೆ.
kindly, madam, kindly take Annexure N, page number, para number 5. Now this is not that this affidavit are not taken. The registrar of companies has filed a petition before the.
ಅದನ್ನು ಹೇಳಿದ್ದಾರೆ ಅವರು. Filed petition on behalf of the regional director, Ministry of so and so, so and
Please,
so.
the petitioner has filed his reply complying the objections that were raised. So it was the objections, he said that he is complying those objections. No further objections are filed. Everyone said that if one propounder comes and says that I am going to revive the company, I will give employment opportunity, no one will come in between. It is with this assurance and everything, this Honorable Court at that point of time sanctioned this scheme. Now, after this sanctioning of this scheme, my lord, now, he had also given an undertaking that he will file a quarterly report before the court as to how he is going to revive the company and everything. Now, he has sold major portion, 17 acres of land. It is under those circumstances that I filed this application under section 392 of Companies Act. Kindly take, my lord, section 392 of Companies Act.
ಇವರ ಸೆಕೆಂಡ್ ಪ್ರೇಯರ್ ಅದು.
Please, my lord. Now, power of tribunal to enforce compromise and arrangements. Where the tribunal makes an order.
Means company court.
Company court, my lord. It was 2002 amendment, but it never was enforced. Makes an order under section 391 sanctioning a compromise or an arrangement in respect of a company. It shall have power, it shall have power to supervise the carrying out of the compromise or an arrangement until it is sanctioned and it is revived. Company court has jurisdiction and may at the time of making such order or at any time thereafter give such directions in regard to any matter or make such modifications in the compromise or arrangement as it may consider necessary for the proper working of the compromise or arrangement. C2, subsection 2. If the tribunal aforesaid is satisfied that a compromise or an arrangement sanctioned under section 391 cannot be worked satisfactorily with or without modification, it may either on its own motion or on the application of any person interested in the affairs of the company make an order winding up the company. And such order shall be deemed to be an order made under section 433 of the Act.
Even if it is made under 392, it partakes the character
Ultimate
of an order under
433. So ultimate order is, my lord, you have given solemn assurance before this court and
what you say is
taking advantage of this court order.
You should implement the scheme which is approved by the court. Since you are not doing it alternatively, if it cannot be directed to implement, the company should be wound up.
Please, madam. If that is first opportunity should be given to him. Now, if he says that I cannot do it, I am not going to, though I have given all the.
You are opposing Mr. Shankar's review petition.
That appeal, I am not there. It is only in the furtherance
On
of.
that premise only.
Please, madam.
Winding up, ನೋಡಿ, ಅಲ್ಲಿ ರಿವ್ಯೂ ಮಾಡಿದ್ರೆ the effect may be 392(5).
Automatic.
But if you stick on to your first prayer,
Please, madam.
which is confined to 391, then you repel contention of Mr. Shankar.
Please.
Clarity, legal clarity.
Legal clarity. If it is for
Understood
that
that,
reason,
yes.
it is under those circumstances, my lord, I have filed
If
this
they
application.
cannot do that, then direct them, direct winding up of the
Please, madam.
company
Now-
itself.
Now, after this order is passed,
they have said that litigations were pending and everything. But no such document is produced. Or even for reviving or manufacturing, an attempt should be shown to the court, and thereafter if one person says that I had attempted but I did not get, that is one thing.
ಅಲ್ಲ ಅಲ್ಲಿ PIL ಏನು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಿದ್ರಲ್ಲ, ಯಾವ್ದದು
ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಕ್ಕೆ ಸಪೋಸ್ ಈ ಫ್ಯಾಕ್ಟ್ರಿ ಸ್ಟಾರ್ಟ್ ಮಾಡೋದಕ್ಕೆ ನಾನು ಫಾರ್ಮಸ್ಯೂಟಿಕಲ್ ಮಾಡ್ತೀನಿ ಅಥವಾ ಈಗಲೂ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ಕೊಂಡು, ಮೆಲೋಡ್ ಸ್ಯಾಂಕ್ಷನ್ ಇಸ್ ನಾಟ್, ಇಟ್ ಇಸ್ ಗಾನ್.
ವಿಚ್ ಇಸ್ ದಟ್ PIL?
PIL.
OS PIL ಎಲ್ಲಿ, ವೇರ್ ಹ್ಯಾವ್ ಯು ಸ್ಟೇಟೆಡ್? ನಮಗೆ ರೆಕಾರ್ಡ್ ಬೇಕಲ್ಲ.
I have produced the memos, my lords.
ಎಲ್ಲಿದೆ ಅದು?
I produced it along with the case.
ಕೊಡಿ.
Last time.
ಅದು ಅಲಾಟ್
I apologize, my lords.
ವೆರಿ ಅಲಾಟ್ ಮತ್ತೆ ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡ್ಬೇಕು.
See the order sheet at page number 16 onwards, my lords.
PIL ಎಲ್ಲಿದೆ?
Yeah, number I have, my lords, because the notice is not yet issued to me, that matter.
Notice
The lordship sees. The PIL number.
They have
my
filed
lord,
objection also in that. Objection ಹಾಕಿದಾರ KIDB ಅವರು?
KDB has filed an objection in that the original writ petition, my lords, where your lordships are directed to execute the lease come sale deed. I've just
ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮೇಲೆ ಅಪೀಲ್ ಆಗಿಲ್ಲನ?
ಅದು ಆಗಿಲ್ಲ, ಅವರು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ರು, ಅದು ಆದ್ಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್, ದೇ ಹ್ಯಾವ್ ಕಂಪ್ಲೈಡ್ ವಿತ್ ದಟ್ ಆರ್ಡರ್. ತಾವು ಮಾರ್ಚ್ ತಿಂಗಳಲ್ಲಿ ಆ ಆರ್ಡರ್ ಮಾಡಿದ್ರಿ, ದೆನ್ ಇನ್ ಅಕ್ಟೋಬರ್ ಮಂತ್ ದೇ ಹ್ಯಾವ್ ಕಂಪ್ಲೈಡ್ ವಿತ್ ದಟ್ ಆರ್ಡರ್. ಅಂಡ್ PIL ನಂಬರ್, ಮೈ ಲಾರ್ಡ್ಸ್, ಐ ಹ್ಯಾವ್ ದ PIL ನಂಬರ್, ಇಟ್ ಇಸ್.
ಹಂಗೆ ಕೊಟ್ಟರೆ ಹೆಂಗೆ ರೆಕಾರ್ಡ್ ಕೊಡಕ್ಕೆ?
ಐ ಅಪೋಲಜೈಸ್.
PIL ಏನು ಅಂತ ಗೊತ್ತಾಗಬೇಕಲ್ಲ.
ವೆರಿ ವೆಲ್, ಮೈ ಲಾರ್ಡ್ಸ್.
PIL ಇದನ್ನ ಕೊಡಿ, ಏನು ಪೇಪರ್ಸ್ ಕೊಡಿ ನಮ್ಗೆ. PIL ಏನ್ ಹಾಕಿದಾರೆ ಅಂತ ಗೊತ್ತಾಗಬೇಕಾ?
ಅವರು ನಮ್ಗೆ ನೋಟಿಸ್ ಮಾಡಿ ಪೇಪರ್ ಕೊಟ್ಟಿಲ್ಲ, ಅದು ಪ್ರೇಯರ್ ಅಲ್ಲಿ
ಅದು ಏನಿದೆ ಅಂತ ಕೊಡ್ಬೇಕಾ?
ವೆರಿ ವೆಲ್, ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ದಟ್.
ಅಲ್ಲಿ what they have challenged very allotment of the land itself.
ಇಲ್ಲ, they say that revenue entries in respect of certain survey numbers that are allotted to me in Mazura Hosalli, Hubli, ಅದು government ಗೋಮಾಳ land. Therefore, you should not mutate the entries in favor of the private respondent ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ರು.
Private respondent ಅಂದ್ರೆ ನೀವೇ?
ನಾವೇ.
ಆಯ್ತಾ, ಇದೆಯಾ ಏನಾದ್ರು?
It is in these circumstances.
ಈಗ ಗೊತ್ತಾಯ್ತು, ನೀವ್ ಹೇಳೋದು ಇಷ್ಟೇ. ಸ್ಕೀಮ್ ಅನ್ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವೈಂಡಿಂಗ್ ಆರ್ಡರ್ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿಸಿ, ಇಲ್ಲ ವೈಂಡಿಂಗ್ ಅಪ್ ಆರ್ಡರ್ ಕೊಡಿ.
ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿಸಿ ಹೇಳೋದಕ್ಕೆ ನಾವು ದ ಕಾಂಟ್ಯಾಕ್ಟ್ ವಾಟ್ ಐ, ಯಾಕಂತಂದ್ರೆ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಕನೆಕ್ಟೆಡ್. ನನ್ ವೈ ಐ ಸೆಡ್ ಮೈ ಲಾರ್ಡ್, ದೀಸ್ ಟು ಆರ್ ಬೋತ್ ಕಾಂಟ್ರಾಡಿಕ್ಟರಿ ಟು ಈಚ್ ಅದರ್. ವಾಟ್ ಐ ಸೇ ಮೈ ಲಾರ್ಡ್, if what is the position now, what is happening? If they say that they have difficulty to implement the scheme, that one or the other obstacle is coming in there between, they cannot say that hence I am selling the land, my lord, because they have given 100 undertakings before this honorable court to get this land or this company into their hands. It is, had they not given, my lord, everyone will say that these are my difficulties. There are provision under section 392 which.
Because 17 acres is already sold, he may sell other.
Please, my lord.
Portion also. And
If there is no interim order granted, if there was no interim order granted, my lord, when I had filed company application, at that point of time also there was, I had this threat of selling. They had not sold, but next date of hearing there was 17 acres, my lord, they had already sold that land. And thereafter this interim order was granted.
Yes.
Well, that's why I would say, my lord, it was, my lord, fraud on court, my lord, is considered as the gravest form. In this case, my lord, kindly visualize this situation, my lord. I know that if I file some affidavit before this honorable court will pass some order. Just for the purpose of business or taking over the land, I file that affidavit, I take over that land, and thereafter I don't even comply with whatever assurance that I have given to this honorable court.
Sanctity to the scheme would not remain.
My lord, it would become a mockery of the entire provision, my lord, when if no one had filed objection or if something is there, one can visualize that yes, they thought that they could sell the land. Everyone filed objection. At that point of time, they said, no, I will not sell the land. I mean to say real estate business. I want to start factory business in the same premises. It is the undertaking that was given before this honorable court.
Yeah. Anything to be added?
I don't wish to carry polls to Newcastle.
You are more
And I'll not,
richly experienced because you are counsel for OAL.
I don't want to take much of your lordship. I am sailing with Mr. Rakesh, my lord. Only thing is, my lord, my prayer and my application is to this extent that you implement the scheme.
391 you are confined.
Yes.
You don't travel
Implement
to
ಮಾಡಿ.
392.
Yes.
But suppose if 391 petition dallu, A Ramaya says,
Yes.
391 petition ಹಾಕಿದಾಗ implementability the issue ಹೇಳ್ತು ಅಂದ್ರೆ ultimately 392(5) ಹೋಗ್ಬೋದು ಅನ್ಕೊಂಡು ಲಾ ಇದೆ.
ಹೌದು.
ಅದಕ್ಕೆ ಸಪರೇಟ್ 392 ಅಂತ ಕೇಳೋ ಅಗತ್ಯ ಇಲ್ಲ. You implement the scheme.
Yes.
If you cannot, then we will direct winding up of the company.
Goes
ಅಂತ
back to
ಅನ್ನೋದು.
square one again.
Understood.
That's all.
Yes, Mr. Babu.
Regarding PIL, you was mentioned. That was about 22 acres land.
Well,
Regarding PIL, my learned counsel mentioning about 22 acres land was allotted on single unit complex by KIDB. That was the dispute in PIL, not entire land. About 20 acres still pending. They have not yet sold. There they can start the.
There they can start the company and
Yes,
the industry and another nimdu in
Then
terms
I'll-
of this scheme.
Yes, my application is my lord.
Ah.
I was the first person to file the application for revival of the company. When BIFR referred this company to this.
Wind up.
winding up.
You said it should be revived.
Yes, my lord. BIFR referred,
Now you are you are appearing in which matter?
company application 46 of 24, madam.
It's your application.
Yes, madam.
Your prayer is
To implement the scheme of
scheme.
arrangement.
So you are sailing with them.
Direct them to not to sell the balance land and also kindly direct them to cancel. I mean, I'm praying this honorable court to cancel the sale already made.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ನೀವು ಬೈಯರ್ನ.
By then I can.
ಮತ್ತೆ
how
ಇಲ್ಲಿ
can I-
ಮಾಡಿದ್ರೆ ಅವರು ಬರ್ತಾರೆ
how
ನಮ್ಮ
can I-
ಚೇಂಬರ್ಗೆ.
How can I?
ಯಾವ ಆಧಾರದ ಮೇಲೆ ಮಾಡಿದೀನಿ ನನ್ನ ಹಿಯರ್ ಮಾಡಿದಂಗೆ ಅಂತ ಮುಂದೆ ಮಾಡಿ.
Because he has undertaken that he will not sell the land, but now he has sold. As per his undertaking, my lord, he has to revive the company under supervision
That
of
we
this
look
company.
into. But you have not implemented the buyer of the land,
Yes,
knowing that he has sold the land.
Yes,
How we can pass order to cancel the sale without hearing them?
I will implement them, my lord.
At this stage ಏನ್ ಮಾಡಕ್ ಏನ್ ಮಾಡಕ್? Yes.
He has submitted that he will revive the company under supervision of this
What
company, my
you are
lord.
going to do
But
to the
so far,
company?
not even single time he has come before this court stating that so and so problem he is
Okay.
facing.
Next, what you want to do?
Without permission of this
You
honorable.
have said that, don't repeat. You are not saying anything new. You are, in fact, you are saying you are giving some discount in what they have argued. Yes.
I reply, minutes. A very well-known adage that time and tide waits for none. The vagaries of time, my lords, needs to be considered. All these affidavits that my learned friend has pointed out on the other side.
No, we have understood now. It is
ಅದೆಲ್ಲದು
not that.
ಹೌದು.
We will agree with you now. Where there is a scheme that has to be implemented. Where scheme cannot be implemented, no option but to direct winding up of the company. What is your contention? Are you going to implement the scheme or not?
We completely intend, even as of today, my lords, in good faith, we intend to revive the company and start some sort of production. My lords, it may not be. Business interests, my lords, may change from time to time because of regulatory issues or various other
Then it
issues.
travels to 392.5.
Now, my lords, now, if your lordship sees.
There is no via media.
Now, my lords, even if I were to revive the company, for me to revive the company, my lords, I need to still satisfy all these debts that I have incurred over the past 10 years. Now, it is not a question of me, my lords, suddenly reviving the company that I can revive. When I contemplated this scheme in the year 2014, when I filed that 2013 company petition, my lords, I had made an assessment of the finances back then, that the land is worth so much, the industry is worth so much. I can revive the industry by paying so much money. all of those aspects, my lords, have radically changed since the year 2012 up to now. Since the year 2013 up to now.
Question is not that. What you are going, there are two options in company law.
I understand. my
Either
lords.
implement the scheme or direct winding up of the company. That's the only way.
Therefore, I'm making that submission, my lords, that I will still implement the scheme. There is no question of me not implementing the scheme. For
You will
me to
implement the
implement,
scheme.
I'm ready to implement the scheme. However, my lord,
How you are going to implement the scheme? Give us the proposal, because 391, 392 is that one only. There is no other go. Either you have to implement the scheme or company should be wound up. No third way.
I understand, my lords. Therefore, now the scheme as contemplated, my lords, originally, the scheme says only three aspects. Now, first thing is, my lords, that I have to settle the dues of all the company's creditors and the various stakeholders that are there. That is done, my lords.
You have settled.
I have settled all of as on the date of liquidation, my lords, whatever was there, we have settled. Now they say that as per the OTS value is not furnished. Now we have produced, my lords, the sum of 91 lakh that was given to Mr. Vasu, who has taken that sum and distributed it amongst his employees or the employees who stood employed with the company as on the date of liquidation. Now a distinction is sought to be made as between the workmen and the employees, stating that the employees are different, the workmen are different. Whereas the workmen were paid way back in the year 1994 itself about 20 lakhs, which is a handsome sum of money at that point in time, my lords, 30 years back. Now, considering, my lords, the proposal that I have provided to your lordships, as well as, my lords, the amounts that have already been paid to these employees and the union workers, my lords may kindly consider the amount that I'm willing to show my bona fides and settle this matter all in for once. Because, my lords, the aspect that is being brought forth by my learned friends who have filed the company applications, my lords, is twofold. Like I said that day, they're trying to have a safety net. They want to eat the cake. Sorry, they want to have the cake and eat it too, because the OSA, they sailed with the employees union all along, my lords. Even your lordships may kindly see his lordship's Justice Bopanna's order, where they have not presented a tangible scheme.
Allah, ಎರಡು aspect ಇದೆ. You are arguing against Shankar's petition now. When it comes to their 391, 392, his is 3191, 392, his is 391. What are you going to do for that?
Precisely, my lords. That is why, if your lordships kindly sees 391 for a moment, my lords.
Yeah.
How compromise has to be looked into. 391 subsection 2 says, if a majority number representing 3/4 in value of the creditors or class of creditors or members or class of members, as the case may be, present and voting either in person or where the proxies are allowed by proxy at the meeting, agree to any compromise or arrangement, the compromise or arrangement shall, if sanctioned by the tribunal, be binding on all the creditors of the class,
So that
all the
we
members.
have crossed that now.
Now we have crossed that, because
Then what happens?
now, my lords, the only thing that is left for me, my lords, is to revive the company. How to revive the company, my lords, is a matter of business interest. I will revive the company, my lords, in the manner that is both profitable as well as in a manner that it sustains itself.
No.
Now I cannot, now, my lords.
You do it under the supervision of the court. That's the law.
That is in 392, my lords.
391, 392, they are
392.
cousin sections. Therefore, scheme is approved now. How are you going to implement the scheme? ಅದನ್ನ ಹೇಳ್ಬಿಟ್ರೆ ಮುಗಿದ. This is on the assumption that Mr. Shankar's petition, we are not agreeing with them. If we agree with Shankar's petition, and if you do not show us the reason as to why, justification as to why scheme is not implemented, then we travel to 392.5. No option. ಹಂಗಾಗಿ you have to come out with some concrete. ಈಗ ಯಾರ್ಯಾರಿಗೆ ಕೊಡೋದಿತ್ತು ಅಮೌಂಟ್ ಕೊಟ್ರಿ ಈಗ, ಹೌದಾ? ಮಾರಿ ಆಯ್ತು, ಕೊಟ್ಟಾಯ್ತು. ಈಗ ಮುಂದಿನ ಸ್ಟೆಪ್ ಏನ್ ಮಾಡ್ತೀರಿ ನೀವು ಅಂತ?
ಈಗ ಮುಂದಿನ ಸ್ಟೆಪ್, ದೇ ಸೇ ಐ ಆಮ್ ಇನ್ವಾಲ್ವ್ಡ್ ಇನ್ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಬಿಸ್ನೆಸ್, ಐ ಹ್ಯಾವ್ ಸೋಲ್ಡ್ ಇಟ್. ಯಾರಿಗೆ ಸೋಲ್ಡ್ ಮಾಡಿದೀನಿ ಅನ್ನೋದನ್ನು ಕೂಡ ಅವರು ಹೇಳೋದಿಲ್ಲ. ಬೇಕು ಅಂತ ದಿಸ್ ಇಸ್
ನಾವು ನಿಮ್ಗೆ ಕೇಳ್ತೇವೆ.
Now, my lord, we have sold it to industries because it is a KIDB industrial land. I cannot sell it to anyone else. It has been sold to industries for the purpose of manufacturing. On the last occasion, I made, my lords, a solemn submission before this honorable court that I will try and impress upon them to take all these people into even employment if they're both qualified as well as eligible. My lords had granted me that opportunity to consult with my client. I consulted with my client. Now, my lords, the clients thereafter consulted with all those purchasers who are establishing these industries. In a period of about 2 to 3 years, these industries will come up. Manufacturing will start. Therefore, my lords, my humble submission is,
Yes.
for something that has now once bloomed and withered away, to once again water it and bloom it again.
Where is
I have
your stand-
produced-
Where is your stand as against theirs?
My stand against this is
ಎಲ್ಲಿದೆ ಪಿಟಿಷನ್ ಎಲ್ಲಿದೆ ನಿಮ್ಮ ರಿಟರ್ನ್ ಸ್ಟ್ಯಾಂಡ್ ಎಲ್ಲಿದೆ?
we have filed our objections.
You have filed your objections.
We have filed our
Further here ಮಾಡಕ್ಕಾಗ್ತದೆ ಇದು. You have to hear it further. Call ನೀವು ಬರ್ಬೇಕಿತ್ತು, ನೀವು ಅಲ್ಲಿ ಇರ್ತೀರಿ ಯಾವ್ದು? ನಾಳೆ ಒಂದು 15-20 ನಿಮಿಷದಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡಿ.
ವೆರಿ ವೆಲ್.
ಕಾಲ್ ಟುಮಾರೋ ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ಅಷ್ಟೇ ತೋರಿಸ್ಬೇಕು. ಸ್ಕೀಮ್ ಅನ್ನೇ ನಿಮ್ ಹೆಂಗ್ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ತೀರಿ? ವಿದಿನ್ ವಾಟ್ ಪೀರಿಯಡ್ ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ಡೂ?
ವೆರಿ ವೆಲ್.
ಇಷ್ಟೇ ಮಾಡ್ಬೇಕು. ಅಲ್ಲಿ ಆಪ್ಷನ್ ಇಲ್ಲ, ನೋ ಆಪ್ಷನ್.
I'll just take.
My lord,
My lord.
serial number
22.
25, my lord. Day after tomorrow.
ಎಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
My lord.
Well, at serial number
execution ಬರ್ತಾ
22,
ಇದೆ.
there is an urgency in this
ಏನ್
matter
ಅರ್ಜೆನ್ಸಿ?
in respect of death benefits as well as pension and pensionary benefits.
ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
My lord, no, my lord, there is an urgency.
ಎಲ್ಲೆಲ್ಲಿ
Kindly
entry
have
ಮಾಡಿದ್ರೆ
done
continue
tomorrow, my
ಮಾಡಿ.
lord.
ಇನ್ನುಳಿದೆಲ್ಲ
It's very difficult. My lord,
My lord,
kindly
execution ಬರ್ತಾ ಇದೆ, ಅದಕ್ಕೆ ನಾಡಿದ್ದು.
ಯಾವ ಮೂಡ್ ಇನ್ ದ ಆಫ್ಟರ್ನೂನ್ ಈಗ ಬಂದಿದೆಯಾ ಫೈಲು? ಬಂದಿಲ್ಲ. ಇಟ್ ಇಸ್ ಲಿಸ್ಟೆಡ್ ಟುಡೇ ಆಫ್ಟರ್ನೂನ್ ಹೇಳಿ.
My lord, 22, my
Day
lord.
after tomorrow, my lord, execution ಬರ್ತಾ ಇದೆ.
Sir, we are not looking at you.
come to Justice.
137
137.
Yes.
of the same complaint.
Okay. You're right.
Let's, probably by oversight, or I don't know whether the tribunal was misled. You'll also have to see para 8. It extracts 371J, but omits to note down a very relevant part of that 371J, which has resulted in
All
the
these.
tribunal focusing on something else. You'll also have to see the extract of 371J,
A, B, C.
A, B, C, under C,
Equitable opportunities and facilities for the people belonging to so and so.
reason, matter of public education and vocational training, subject to the requirement of the state as a
ಅದು
whole.
ಬಿಟ್ಟೇ ಬಿಟ್ಟಾರೆ.
Bitte. Now, let's, apparently, the entirety of this order by the tribunal is cut and paste from the learned single judge's order in by Justice Sanjay Gowda's order. Let's may draw your lordship's attention to that in page 83 minutes. Yes, show me that. What page in this?
That's not there.
ಇದರಲ್ಲಿ ಇರ್ಬೇಕಲ್ಲ ಸಂಜಯ್ ಗೌಡ್ರದ್ದು.
At page 87, 83 minutes, the judgment starts.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಸಂಜಯ್ ಗೌಡ್ರದ್ದು ಯಾವ್ದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದೆ ನಾನು.
83 madam.
83.
Out.
ಹಾ.
That's
You are
the
right.
judgment, my lords, which the tribunal has followed it, my lord.
ಹಾ.
83 is the judgment.
Ah.
At page 87, his lordship also has omitted to,
He also has not considered.
therefore, the entirety of the
So tribunal duplicated that particular paragraph.
yes, entirety of the judgment, my lords, I can show from para to para, it has been reproduced by the tribunal.
ಇದನ್ನೇ ನಾರಾಯಣ
So this becomes relevant for the purpose, my lords, of interplay between Article 16 and the provisions of 371. Now that, my lords, though I have read that, would your lordships permit me to read just para 6 of the judgment in
apex court judgment.
no, Andhra judgment, my lords?
That's what, that's apex court
Not
judgment,
except-
na?
Vemaredi, give me that.
Ha, you were, where 371D was being considered.
Yes, yes.
That is at page number?
89 on.
Government of AP versus Vemaredi.
You're right. 2007 SCC.
Yes, let me just preface it. Though, my lords, it is 371D with the slight changes of notwithstanding being there, rest of the provisions are identical to
Almost,
371J. There's not much of a difference because all those provisions under 371J provide for such a
But ಅಲ್ಲಿ government ಇಲ್ಲಿ governor.
that is precedent, and this
ಅಲ್ಲಿ
is
president ಇಲ್ಲಿ governor.
this is governor. Other than these two, my
The
lords,
substance remains same.
substance remains same. So therefore, while dealing with 371D, in para 6, my lords, the court has explained how it becomes permissible only because of 371, sorry, Article 16(3). My lords, I may be permitted to read para 6, my lords, which is at page
State
88.
action be it legislation,
Plenary.
plenary or subordinate.
Or an executive order which denies citizens equal opportunity and access to public employment on the ground only of place of birth would be invalid qua the provisions of Article 16(2) of the Constitution of India. Article 16(3) of the Constitution, which makes an exception to the limitation of Article 16(2), is confined to enabling Parliament to prescribe the qualification of residents in the state as
As
a
a whole, not any part thereof.
not, so as a whole, the concept, my lords, is absolutely necessary in a 371J to take it out of the finding fault with Article 16(2). Parliament can, like in 371J, provide for reservation.
Part of that also.
Yes, but then the concept is that you provide for as a whole,
Whole.
not to the HK region alone. So therefore, under the governor's order, there is a provision made applicable to the entire state. But a reservation by way of organizing the cadre, certain posts are identified and reserved in respect of those posts. Let's in HK region, they found so many posts as requiring to be filled, giving them the benefit of the governor's order of the preferential
Preferential
appointment.
appointments.
They also provided for reservation. Within that cadre, you have 75% exclusively for residents of that area. The 25% is open to everybody. In the other cadre, that is non-HK cadre, the whole of the state, this is by common governor's order. Therefore, it is providing for the entire state, not reservation by a particular region, which otherwise would fall with 16.2. Therefore, under section 16.3, Parliament can make a provision for the entire state as a whole. Therefore, necessarily 371J incorporates under C the provisions of providing for and regulating the appointments or reservation in whatever manner as state as a whole. Then only it will be valid, otherwise it is
False foul of 16.2 anta ಒಂದು.
16.2. That's the purport of para 6. You will also already read, I won't trouble reading again. This is reiterated again in para 14.
What is stated in 6 is consistent with what is stated in Narasimha Rao, A.V. Narasimha Rao.
Yes.
In that way it is structured.
That all falls not from that pronouncement of the
That
court
pronouncement only.
only.
Okay.
Now, apart from the constitution itself under 16.2.3 providing for it, 16.3 says you can provide with a residency requirement, provided it is
Parliamentary legislation.
And not Parliament also can't provide for a region. It has to provide
Whole of the state.
state as a whole. Now, my lords, if the tribunal and the learned single judge have omitted to address that issue,
Whole derailment happened.
the entire order becomes unsustainable, my lords, in my humble submission. Now, kindly come to my lords para.
So that mistake crept in. They could have reproduced that whole provision itself. They could have done it.
They should have, my lords, I don't know how by oversight the government was before the courts and the.
ಅದನ್ನು ಶಾರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿದೆ ನಾನು ಜಸ್ಟ್ ಮಾತ್ರ ಹೇಳ್ಕೊಂಡು ಕೈ ಬಿಟ್ಬಿಟ್ರು.
But without state as a whole,
It's very important.
the provision becomes unworkable.
And it becomes not only that, apart from its arguable unworkability, it is a package.
Yes.
And there is a presumption that the Parliament knows the law declared by the High Courts and the Supreme Court.
Yes.
Then they structure legislation.
That's true.
Therefore, when these concepts are specifically treated under particular provision which fits into that class of constitution provisions, that ought to have been.
When it came to providing for 371J, the Parliament was aware of the march of law and therefore advisedly they omitted the provision notwithstanding. By then, my lords, the law had been pronounced by the courts in several judgments of the Supreme Court, pointing out that how there cannot be violation of Article 14, 15 and 16. Therefore, they advisedly, but still they said it can be provided as long as you comply with 16.3. Now, 16.3 says you can't provide for only that reason, you have to
For
provide
whole
for
of the state, you have to do it.
So therefore, when the governor made a provision for whole of the state, providing for reservation of 75-25, the executive government cannot mess with it and then say the intention of the parliament is to provide for a greater reservation for the person coming from that. Therefore, I allow them that advantage by applying the principle evolved in Indrasani for the purpose of 15.4, 15.5, where the court said, based on merit, when a appointment is being made, if you are merited and can take a place in under general category, then you will be placed in that category first. Thereafter, the reserved categories would remain intact for the purpose of filling up by the persons who have the benefit of reservation. That doesn't apply in this case. It is actually prohibited by law in terms of 16(2) and 3 read with 371J. Therefore, Lords, the learned single judge unfortunately applies that provision, that law, where he says the intention of the parliament read with Governor's order requires a greater support of the government for expanding the reservation which is available, which is a misconception. It can't be. The governor, once he makes, I have pointed out, my lords, earlier when I read, even the governor himself cannot meddle with it if it is once provided for, nor can state provide by a legislation. They were also struck down, my lords, insofar as Andhra is concerned.
Tribunal struck down it.
Yes, that is made clear, my lords, by few of the paragraphs, if your lordship permits me,
Yes.
reading from this, my lords, paragraph 14 may kindly be seen, my lords, which shows what is the scope of Article 371D.
Other day you did it.
Yes.
State as a whole.
No, I'm not going to read.
Equitable opportunity.
I'm not going to read this. I'm only pointing out that these paragraphs deal with each one of these
Components.
components of 371J. And therefore, my lords, even though it may become repetitive, I just want to show
Yes.
which of the paragraphs deal with each of those concepts.
At least 14 and 15 other day you read and just we made mark.
Yes, my lords.
Apart from that, any other paragraph?
No,
please?
kindly see 15 for a moment, my lord. Just one sentence.
Very well.
The area of departure cannot therefore extend beyond what is unmistakably and specifically delineated by the words employed therein or in the presidential order made thereunder. In effect,
Where you are reading?
para 15 minutes, the second line, article page 92, para 15. Article 371D is a special provision which makes a departure from the general scheme of the Constitution. The area of departure cannot therefore extend beyond what is unmistakably and specifically delineated by the words employed therein or in the presidential order made thereunder. I replace, my lords, presidential order to governor's order. So you can't, once it is provided for, by executive order, you can't meddle with that.
Even otherwise, governor could not have meddled.
Yes. Once the cadre is, because that's a one-time exercise to organize the cadre, provide, consider how many posts are there, apportion them, proportionate to the requirement
Whole of the state.
as a state as a whole, and then provide for reservation, again keeping in view the entire state's interest. That exercise having been done by the governor under governor's
State
order
could not have
and
done
the rules made, the state could not have made. Let's the several judgments, lords, which have dealt with these very concepts of reservation, cadre, organizing cadre, but some in substance, lords, whatever your
right.
lordships have expressed just now, my lords, is covered. So therefore, my lords, your lords may take note of these paragraphs, my lords. I don't intend to read them.
15.
14 to 19, 26, 28, 30, 63 and 77.
14 to 19.
26,
Ah.
28, 30, 63 and 77. On facts, your lords have noticed in this particular case, there was a time frame for organizing the cadre. That time frame was once extended. Beyond that, there was no power vested in the state government to reorganize the cadre and apply them to Jilla Parishad and other institutions where also milords were under the government's control. That the Supreme Court said is not permissible. And this has reiterated, and some of these paragraphs, milords, deal with that. That is, you can't, once you exercise this power, can't meddle with that in exercise of state's power in any manner.
Whether that Andhra judgment went in appeal to.
Yes,
Supreme Court?
milords, page 137.
Any modification?
No, except saying, milords, this is what it says. The teachers of the Panchayat Samiti, milords, page 137 bottom.
Very small.
Yes. Para 1, milords, first they say we see no reason to interfere with the considered decision in exercise of jurisdiction on 136. While dismissing the appeal and specially petition, we deem it appropriate to make the following observations. Since the recruitment to the local authorities, Panchayat Samiti and the Jilla Parishad are said to have been done in compliance with para 8 of the presidential order, the state government is at liberty to send a proposal to the Union of India for obtaining the approval of the President of India to integrate the teachers of the Panchayat Samiti and Jilla Parishad, who are also government servants with the existing local cadres of the teachers. As and when such proposal is sent to the Union of India, the same shall be considered at an early date. However, milords, they agree with the well-considered judgment, milords, by the division bench of the Andhra Pradesh. Thereafter, the government, central government did permit that integration which was observed.
By statute, by legislation.
By presidential order. That was again held to be bad, milords, by the
That
Andhra.
can be done only by legislation.
Yes, milords. Page 249 is the judgment. I won't trouble reading that, but that has no bearing on our issue. Therefore, milords, I'm not troubling your lordships. I've also placed.
So it is once for all. If it is done, nobody can interfere with that.
Yes, in fact, in para 60, page 67 is the judgment of Dikshitulu. Volume 1. Let's, in fact, what is contained in this paragraph has been reiterated in this division bench judgment. But since Dikshitulu specifically draws attention to the position in law, I just want to draw your lord's attention to para 89 and para 79. Give me Dikshitulu.
They follow the 2007 Andhra Pradesh.
No, Dikshitulu was first of the order, where the question was whether the High Court, which was excluded from Article 311, would come by virtue of the presidential order. In that context, they said, even though there is a non-obstante clause, let's kindly see para 79 and 89, just two paragraphs.
Page?
Page 67. 80? Page 89, milords, relevant part.
Yeah.
para 79. It is true that this very phrase in the context of the provision in Article 311 includes the employees of the High Court and members of the judicial services. But it must be remembered that the provisions of Article 311 are a general nature. They give constitutional recognition to fundamental principle of natural justice by making its protection available uniformly to all government servants. That is why in the context of that article, this phrase has been spaciously construed. As against this, Article 371D is a special provision which marks a departure from the general scheme of the Constitution. The area of departure cannot be extended beyond what is unmistakably and specifically delineated by words employed therein. But this is actually reproduced in para 6, which I read earlier.
Of single judge.
Of the division
Andhra-
bench order.
No, 2007 Supreme Court, na?
That went to,
Andhra Pradesh.
yes,
Ah.
Vema Reddy
Reddy's,
case
yes.
has reproduced this. But however, my lords, this has been taken from the Supreme Court's order in Dikshitlu.
Okay.
Page 89, my lords, has again stated the same thing. It's not here. 89. 79, I read.
Yes, 89 or not? 89 you have read, para 79 you have read, na?
Next page, my lords. This holds true even when the same words are used in different contexts in the same enactment. Therefore, in a special provision like Article 371D, as its heading itself proclaims, which derogates from the general scheme of the Constitution for a specific purpose, general undefined phrases are not to be interpreted in their widest amplitude, but strictly attuned to the context and purpose of the provisions.
Correct.
Conversely, had it been the intention of the Parliament, it would have been differently worded.
Correct.
Now let's add clause 19 of the Governor's order, which was added at a later point of time. Let's draw your lord's attention to clause 19 of the Governor's order, which provides for interpretation.
By the government.
Which was added by the government by a subsequent amendment. That provides for interpretation. Now
Not a power to make at all.
Yes.
Power to interpret is there. Anta.
Yes, therefore this sentence would squarely apply to any argument that then enables the government to change the entire text of the Governor's order by providing for additional benefits to persons coming from that region. It has to be strictly construed because this is a
ಅಲ್ಲಿ ಗವರ್ನರ್ಸ್ ಆರ್ಡರ್ ನಲ್ಲಿ ಪವರ್ ಗಿವನ್ ಟು ದಿ ಗವರ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
power is given to the government to interpret what governor has provided
Said.
for.
You can't do something
No.
which the order does not provide for.
On first principle itself, it is to be understood that way, my lords. But then it is also supported by a ratio in Dikshitulu, which says you can't traverse beyond this being a special provision under the Constitution.
Whether in that Dikshitulu case, that Andhra Pradesh,
Yes,
whether that President's order, it was not Governor's order. President's order gave any power to the government?
no. In fact, my lords, when government legislated after failing
In the
successive-
subsequent case,
Yes, it was
that
struck down,
itself is struck down.
saying that you have no such power. It has to be only by the process contemplated under 371D.
Which is a complete code itself.
Yes. Therefore,
Direction as may be necessary for the purpose of looking to this order or
that is, let's, in the governor's order, there's a power reserved in the governor to issue such directions as may be.
Governor
necess-
himself may issue.
Yes, but to make it workable.
No, even otherwise that power is with the governor.
No, let's power to authorize issue of direction. The governor may, by order, require the state government to issue such directions as may be necessary or expedient for the purpose of giving effect to this order.
So governor's sanction is, delegation is necessary.
Delegation is there, but it says to give effect to the governor's order.
They cannot do anything that would run counter to what the governor has said.
Yes.
In any way, whatever is to be done, it should be within the four corners of the governor's order.
Yes.
On principle that in Dikshitalu, it referred to president's order.
Yes.
On the same principle, here also it is like that.
Now, my lord, insofar as issuance of circular by the state government is concerned, as I mentioned earlier, it is to supplement and give effect to governor's order. The circulars which are in tune with the governor's order are permissible in law because of.
Anna, but one aspect is there. I understand what you have said. We understand that. Apart from power to interpret, governor has power to authorize the state government to issue necessary rules, norms, etc.
To work out.
Even that, to work out his order.
He must authorize.
Order of the governor.
Yes.
Not something else.
Yes.
Anta ನೀವು ಹೇಳೋದು.
Yes. Lords, I have already taken your lordships through various provisions made by the governor of prescribing the appointment, vacancies being identified, cadre being organized, the process of making selection, examination.
So our governor's order is all exhaustive.
Yes.
So they could not have done anything which would not give effect to or which would expand the scope of governor's order.
Yes. Lords, since I have already indicated the paragraphs, though I am not reading them, that would make good my submission that this was in excess of what is permissible in law. And therefore, the government's action in undoing what had happened by the time it did by the impugned circular is bad. Now, in the light of that, my lords, the only aspect.
In other words, even assuming that government was authorized by the governor, it was for giving effect to governor's order.
That's right. Not in excess of
what
what
he
is
has
provided
said.
for in the.
Yes.
Let's, I won't trouble your lordships with the learned single judge's order which is relied upon.
Justice
Because.
Sanjay
lords,
Goda Sahib.
Yes, the entire, as I mentioned, I'm sure lawyers preceding me must have stressed on those aspects. But just to generalize, the court, my lords, went into a different direction altogether.
Because it omitted to see that part.
See that part and assumed that government could by circular provide for and do that. And it adopts in para 80, 90 and 94 of its judgment. Let's say your lordships would find learned single judge's order at page 100. Para 33, 34, 35, 36.
One of convenience combined.
Hundred.
100, the para 33.
33.
They refer to subsequent.
This clarification.
Yes. Fundamentally resulted in the meritorious among the local cadre to be fitted into the non-local cadre, leaving some room open for a larger number of posts to be made available in the local cadre for the less meritorious from the persons coming from the local region. To illustrate, assuming 400 posts available for direct recruitment, 300 posts were reserved to the non-local cadre and 100 posts were reserved for the local cadre, and in a competitive examination conducted where 500 candidates become eligible, out of which 150 were from local region, the more meritorious among this 150 would first compete for the vacancies in the local cadre, and let's say 50 out of 150 of local cadre candidates become eligible for selection on merit in the non-local cadre, then the remaining 100 cadres candidates from local cadre would remain for consideration in the local cadre, and they would all be fitted into local cadre. This is, my lords, traversing beyond what is provided by the governors by identifying the vacancies, providing for cadre, HK cadre, non-HK cadre, and providing for reservation. Now the 35 minutes further makes it, if on the other hand, entirety of 150 candidates from local cadre were asked to compete only for 100 posts available in the local cadre because of the option that they had exercised at the time of making the application, then the prospects of a larger number of local candidates being selected would get drastically reduced.
ಇದು appeal ಆಗಿಲ್ಲ ಇದು
Pending, one appeal is pending.
Here only. ಏನು ಇದು
Kindly permit me to read.
ರಿಟ್ ಅಪೀಲ್ ಏನದು? Date of 23.
Kindly see para 58 lots of the same judgment. Page 113, para 58. Yes, it's page 11.
As explained.
Earlier, this resulted in the local candidates competing with non-local candidates for the non-local cadre posts. And if they become eligible for selection, they were required to be appointed in the non-local cadre. And only if they were unable to secure selection in the non-local cadre posts where they were to be considered for local cadre posts. This procedure, as already explained above, resulted in higher prospects of securing selection for the less meritorious among the local candidates. It's not contemplated under the governor's order.
2016 circular was set aside by the tribunal.
So therefore, my lords, the entire rationale which
59 over.
59.
Now 58 you have read.
It is to be stated here that the governor's order as promulgated initially did not enable the government to issue any circular clarifying the process of recruitment to the local cadre post. However, by the amendment of 2014 to the governor's order, whereby para 19 was inserted, the government became empowered to not only interpret but also issue clarifications regarding provisions of governor's order. Thus, the power to issue 6 circulars from 15 to 23, clarifying the manner in which the provisions of governor's order were to be applied, are traceable to the paragraph 19 of the governor's order, and they would thus have the
So
legal.
1900 which gave power to the governor. Again here, arguably, he forgot to say the power was given to the government to make rules to give effect to the governor's order only.
Correct, not government
Or
itself.
independently doing something.
Correct.
Contention.
This having been pointed out.
Whether the governor's order was amended. Governor's order.
No.
They are saying. as
Only
a-
by circular.
No, not that. There is interpretation clause
That-
and there is enabling clause also.
That was by amendment inserting 19.
Who did that?
State government.
Therefore, I am asking you. Governor only. Governor only.
I'm sorry, I stand
That's
corrected.
fine. Okay. Anyway, that amendment is also, Mr. Naik will say,
2014 order, your lordships have seen,
ah,
that was amendment to 2013.
so President also gave 2013 order, under which governor gave 2013 order. 2014 is amendment to the 2013 governor's order, enabling the state government to make rules to give effect to the 2013 order.
That's I advisedly said it was done by the state government because the footnote under that amendment says it is done by DPA. Government order dated soon. It doesn't make any reference to governors. Maybe there is some order by the government, but it is for the state to find.
First line by the order of the governor, this notification. Lordship will kindly see the order.
Just see the text of the amendment.
Book your lordship will kindly.
ಅಲ್ಲ ಒಂದು ಪಾಸಿಬಿಲಿಟಿ ಏನಿದೆ ಅಂದ್ರೆ ಗವರ್ನರ್ ಮೀನ್ಸ್ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಅನ್ನೋ ವ್ಯೂ ಇಟ್ಕೊಂಡು
ಹಿಂದಿನ
ಅವ್ರು ಮಾಡಿ ಯಾವುದೇ ಆರ್ಡರ್ ಬಂದ್ರು ಇನ್ ದ ನೇಮ್ ಆಫ್ ದಿ ಗವರ್ನರ್ ಬಂದಿರ್ತದೆ ಅಂತ. 60 ನೀವು ಅದು ತಿಳ್ಕೊಂಡು ಹೇಳ್ಬಿಡಿ, ವೆದರ್ ದಿಸ್ ಇಸ್ ಮೇಡ್ ಬೈ ದ ಗವರ್ನರ್ ಹಿಮ್ಸೆಲ್ಫ್, ಸಿನ್ಸ್ he is raising that, apex court say where such a contention is taken up, the governor should answer ಅಂತ ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ. ಹೌದು, there is such a judgment, there is one such judgment where I think it was in Ipiraipa itself maybe, but there is such a judgment. My memory tells me that there is such a judgment, perhaps in 74 SC 555, it may be, it could be, where doubt arises as to what is the order issued in the name of the governor. Is the really order or not? If that doubt arises, then the governor himself has to clarify anta one ruling ide. Even otherwise also you can clarify, because this says by the order of the governor antide. Howdu, but the following order made by the governor is hereby published.
Now kindly see the last page also.
Possible, let's, I am not making any case
That's
out
what,
of
that's
that.
what.
By the order in the name of the governor. First it is signed by the.
ಅದೆಲ್ಲ ಅಲ್ಲ, ಗವರ್ಮೆಂಟ್ ಮಾಡಿದ್ರು ಇದನ್ನ ಹೇಳ್ತೀನಿ. ಹಂಗಾಗಿ ಅದು ದಿಸ್ ವಿಲ್ ನಾಟ್ ಲೆಂಡ್, ಯು ಹ್ಯಾವ್ ಟು ವೆರಿಫೈ ಮಾಡಿ ನೀವು ಹೇಳ್ಬೇಕು. ಓಕೆ,
That's in terms of the governors,
ಅದಕ್ಕೂ ಗವರ್ನರ್ ನೇಮ್ ಆಫ್ ಗವರ್ನರ್ ಅಲ್ಲ, ಬಟ್ ಫಸ್ಟ್ ಇಲ್ಲೇ ಇದೆ. Otherwise they would not have put that. Not a small thing that they will put something and say that governor even when he has not done.
it could be in terms of 166 of the constitution, which all orders are made in the name of the governor.
That's right.
So therefore, let him verify. It doesn't make much of a difference, my lords, insofar as I am concerned.
ಇದಿರಲ್ಲ, ಹಂಗಿದ್ದಾಗ ಇದಿರಲ್ಲ heading ಅಂತ. Anyway, if you verify that. Correct, but just verify. ಅದ್ ನೋಡ್ಕೊಂಡು ಹೇಳಿ. ಓಕೆ,
Page 12 ನೋಡಿದ್ರೆ
Take out the judgment
2.
of the paragraph in my submission, 24, 25, 20, 23.
it is 2013 order.
following order made by
In
the
my
governor is
note,
hereby.
we give this to the court.
Signed there. That is by the DPA. Oh, by order, there is,
In the name of governor of Karnataka.
there is name of the governor. So that is made by him, and then by order in the name of the governor, whatever it is,
That is for complication. But I am very.
No, otherwise they would not have said the following order is made by the governor. ಸುಳ್ಳು ಹೇಳಿಕ್ ಬರ್ತದ. Anyway, just verify.
On this aspect, I conclude my submission. Adopt, my lord, such of those which have been argued by other councils relevant to this particular issue, create this line of submissions which I have made. Only aspect which remains for my purpose is to show that after the provisional select list was notified, they took this step to undo it. So therefore, with amounts to changing the rule of the game once the game is played, wherein, my lords, some judgments have been cited. I won't cite that, but I have one judgment which I need to point out to your lordships. But before I do that, my lords, I just want your lordships to take note the factual aspect. After the governor's order, local cadre was organized in terms of Rule 3. Posts were identified in HK region, keeping in view 371J2B. Proportion of reservations were decided under clause 3(2), providing for operation of roster under chapter 3 of the governor's order. Notification of 8/7/2020 by special rule provided for recruitment of assistant professors. The method and manner has been prescribed. Thereafter, the candidates have appeared in written test. After they appeared,
The select list was, provisional select list was
Preceded-
made and they figured there.
preceded by candidates coming from that region, exercising their option. Those who want to consider even under non-HK region, opting for it. Those who do not want, not opting for it. So an option had been exercised. Based on that option and the merit of respective candidates who had taken the examination,
List
the
was prepared.
provisional select list was notified on 30th of January 2023. 2 days thereafter, the government comes up with the impugned circular, which in my humble submission amounts to undoing what had already happened. I'm only showing this for the reason of this judgment, my lords, which takes note of such situation resulting in, my lords, hit by the principles insofar as impermissibility of change of rules.
Once the game began. ಅಂತ.
Yes.
ಯಾರೋ cite ಮಾಡಿದ್ದಾರೆ ಈಗ already. It is cited also.
Then your lordship may take note of para 23.
23, another unique feature of the present case is that the selection committee has reduced marks to facilitate horizontal reservation by taking it as a vertical reservation. Admittedly, the rules do not provide for such reservation.
Then para 24 says a candidate may not have a vested right, but once you cannot change to facilitate another group of persons. This is important for my purpose. Para 24.
A law which enables a candidate to get a post cannot be changed to facilitate another group of persons, since the candidate acquires vested right to be considered.
Accordance with law as held in
Sorry.
Devankatti. Devankatti is extracted, which also, lords, was somewhat under similar circumstances. Para 25, admittedly in the case on hand, the appellants are entitled to get the respective posts as per the advertisement issued. The said advertisement has not been amended. It was sought to be modified on advice of the government, though an earlier decision was taken on the similar lines but wisely withdrawn. fixing cutoff marks for a particular category has got a rationale behind it. Reducing it only for the purpose of providing employment to a particular category when the others have already acquired some right would be an affront to Article 14 of the Constitution. Kindly see, my lords, para 26. We have already discussed the scope and ambit of relevant clauses contained in advertisement, particularly subclause 15 and 19. In our consider
Modify the selection
not have
process.
unbridled power either on the state government or the selection committee, selection process.
There were reduced cutoff marks after the results are published.
Here, this is a reduction of cutoff. There, my lords, the entire method and manner of
It is
selecting
still grievous, son, more
Giving-
grievous.
to enable giving them a larger reservation to give them the option, despite they not having opted for being considered under non-HK reason, based on their merit to opt any vacancies that would arise, which would result in their giving up for all time to come. This was under compulsion they were done because they apprehended. Once they knew their possibility of getting selected by provisional select list, they were all apprehensive that they will not come in. Therefore, my lords, despite the caution that you will lose for all time to come,
They
here
opted for,
they opted for and took this. No, they did not opt. They were forced to
forced
take this
to, in a
by
way, forced
reworking,
here.
by reworking the select list. That, my lords, is impermissible by the,
Last three lines in 26 nalli.
yes.
What was done by way of publishing the selection list after the change is nothing but a ministerial act.
In the light of this, my lords, the order needs to be set aside. Government is required to direct continuation, my lords, after the provisional list was
Published
notified.
from that stage, it should go further. ಅಂತ ನಿಮ್
For the
context.
proceeding.
Okay. ನೀವು ಒಂದು ಸ್ಮಾಲ್ ರೈಟ್ ಅಪ್ ಒಂದು ಕೊಟ್ಬಿಡಿ.
Already prepared, my lords, if your lordship permits.
ಕೊಡಿ. Have you referred to this judgment also?
Everything, lords, the entirety of whatever I have argued,
Argued. Okay.
those which I have not read also, some of them I have extracted.
Very
Grateful.
good. ಮತ್ತಾರು ಬೇರೆ ಯಾರು ಇದ್ದಾರ? ನಿಮ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬೋದ? ಮೋಸ್ಟ್ಲಿ ಪ್ರೊವೈಡೆಡ್ ಇಫ್ ದೇ ಪರ್ಮಿಟ್ ಯು.
No, Constance told me that he is on your side.
ಮತ್ತೆ ಅವ್ರಿಗೆ ಬಿಟ್ರೆ ಅವರು ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರೆ ಈಗ.
Please, I mean
ಮಾಡ್ಬೋದಾ?
30.14, my lords.
ಹಾ.
30.14. In my case, we are for the respondent, appearing for the land counsel for the respondent, my lord.
Thank you, Mr. Naik. Thank you so much.
State is in appeal against the order of the tribunal, my lords.
Ah.
Tribunal has upheld our contentions that the rules cannot change in the midway after the process has started, and therefore it's struck down rightly. And this is the reasoning that is adopted, my lords, which is the reasoning of the honorable learned single judge is entirely different, my lord. But in the present case, the learned tribunal has considered all the aspects, my lords, and held that the process already begun. And now you have changed the rules of the game, which is not proper, one thing, my lords.
ಅದೇ ಅದ್ರಾಗ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
ಅದ್ರೊಳಗೆ ಬರ್ದವ್ರು ಸ್ವಾಮಿ, ಇದ್ರೊಳಗೆ KT ಇದರ ಆರ್ಡರ್ ಅಲ್ಲಿ, ಈ ಕೇಸಲ್ಲಿ impugned, the state is now challenging this order of the learned tribunal, my lords.
It's tribunals passed different orders.
Conflicting with
Yes,
each
yes.
other.
So he is one of the.
He is in that conflict.
Yes.
If the state has challenged here.
Yes, yes, yes.
Okay.
That's all.
ಸ್ಟೇಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೆ ಅಲ್ಲ? ಯಾಕೆ ಎರಡು ಆರ್ಡರ್ಸ್ ಬಂದು? ಜಡ್ಜಸ್ ಬೇರೆ ಬೇರೆ. ನಾವು 50 ಜನ ಇದ್ದೇವೆ, ನಾವು 50 ಆರ್ಡರ್ ಬರೀತೇವೆ.
ಇದು
50 ಆರ್ಡರ್ಸ್ ಬರೀತೇವೆ ನೋಡಿ. ಅಥವಾ ಅವರಿಗೆ ಇದು ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಹಿಂಗ ಒಂದೇ ದಿವಸ ಬಂತ? ಇಲ್ಲ, ಬೇರೆ ಬೇರೆ.
Later judgment has said it is perverse.
Okay.
The word used.
But they did not refer to perverse. ಮೊದಲಿನ ಜಡ್ಜ್ಮೆಂಟೇ perverse ಅಂತನಾ? Circular.
The government
is
circular
perverse.
is
Have they referred to the earlier order?
perverse. All these judgments.
ಅಲ್ಲಲ್ಲ, this two sets of judgments. Whether the subsequent judgment refers to the earlier judgment?
ಇಲ್ಲ ಇಲ್ಲ.
ನೋಡಿ ಯಾರು anybody knows about government may be knowing,
Not referred.
ನೋಡಿ.
My lord, in this order is not referred, order is dated 1st January 2024, order by the KSAT, but doesn't refer to,
That is not referred.
no.
ಅದು ಆರ್ಡರ್ ಡೇಟ್ ಎಷ್ಟು?
ಇದು ಅದು honorable single judge of this honorable court is
No, not that.
ಬೇರೆ
Tribunal itself gave two conflicting judgment.
ಇದ್ರೊಳಗೆಲ್ಲ ಬರ್ದಿಲ್ಲಲ್ಲ.
ಆ ಮೊದಲನೇ ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರಾಗೆ ಇದೆಯಲ್ಲ, ಇಲ್ಲಿ ಮಿಸ್ಟರ್ ನಾಯಕ್ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರು, ಅದ್ರ ಆ ಕೇಸ್ನಲ್ಲೇ ಇದೆ.
Replication of a circular dated 16/11/2016. But the 2016 circular was set aside by the tribunal.
By judgment dated, that must be subsequent to the earlier one which upheld another circular. That is the reason you are here. Mr. Nayak said, conflicting judgments of the tribunal is, ಒಂದ್ರಲ್ಲಿ reasoning ಹಿಂಗೆ, ಇನ್ನೊಂದ್ರಲ್ಲಿ reasoning ಹಂಗಾಗಿದೆ ಅಂತ. What we are asking is whether the subsequent judgment refers to the
Judgment of the tribunal, putting this action of the government to be bad is in the order dated 24/8/2021.
21.
That is, that consider 16/11/2016 circular, which is the replication of 1 to 20.
Yes. Anyway, question remains unanswered. Yes, you know.
In the state, the two state different. And there are totally one petition is filed in respect of a matter where the circular was quashed. In respect of another matter, totally we are concerned here with 4 recruitments. One is recruitment of assistant professors in the Department of College Education, where Nayak sir appears. Another recruitment is recruitment to graduate primary school teachers and school education, where P.S. Rajgopal sir appears and Prince Bisham, that is another matter. Then in respect of sub-inspector, reserve sub-inspector 4, that is where P. Venkateswar appears. There, Tribunal took a contrary view. There is one more recruitment which was conducted by KPS following the same circular. That also Tribunal has set aside the circular, where 3 writ petitions have been filed under the selected candidates, the state government and the KPS. So in 4 petitions, the respondents who are the original applicants there are selling to the petitioners in the other cases. So if they conclude their submission, they will be supporting the petition.
Please. Our contention only this much, my lords.
Similar.
And rightly, my lords, the publication recruitment notification was 18/12/2021.
Allah, why you are arguing that matter in advance before the government?
That's, I will reserve my submissions, my lords, if any, madam. Good.
They are selling the petition.
Anything new? What Mr.
One thing is
Nayak has argued, Rajgopal,
nothing, my lords.
Lakshmi Narayana, they
Please.
have argued. Anything you want to add?
One element, my lords, one submission is, my lords, please, an element of malifides would also be read into this, with the plea is raised, my lord, that the entire process is almost over. At that time, this administrative circular, etc. comes, by
Legal,
retrospectively.
Legal
changing-
malified.
Yes, yes.
Legal malified
Yes.
or factual?
No, my lords, the legal malifieds, my lords, coupled with the assertion is, my lords, it is to benefit a particular area that has been done.
ಆ contention ತಗೊಂಡಿದ್ರ KAT ಅಲ್ಲಿ?
ಹೌದು, I will point out, my lords, my
ಯಾವ್ದು?
written submissions, my written submissions, I will point out, my lords. Please.
ಚಂದ್ರಶೇಖರ್ ಬಿಡ್ತೀರಾ? ನಿಮ್ದು ಎಲ್ಲ ಮುಗಿಸ್ಬಿಟ್ರು ಅಷ್ಟು ಅಂತ.
So that, my lord, I can reply to those arguments.
All those arguments you can.
Abhinav, I asked to argue, my lord, kindly have it on Friday, my lord, he will address arguments, he is not there.
ಈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನ್ ಮಾಡ್ತಿದ್ರು ಮಾಡಿ, ಮತ್ತ ಕೈಲಿ ಅನ್ಕೋಬೇಡಿ, ನಮ್ಗೆ ರಜೆಯಲ್ಲಿ ತೊಂದರೆ ಆಗ್ತದೆ. ಅದು ಇನ್ನು ಉಳಿದ್ರೆ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ ಮರ್ತ ಬಿಡ್ತೇವೆ ನಾವು. ಬಹಳ ವರ್ಕ್. ಫ್ರೈಡೇ ಇಸ್ ದ ಲಾಸ್ಟ್ ಡೇ, ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಅಷ್ಟೇ ತಗೊಳ್ಳೋರು. ಏನ್ರ ಇದ್ರೆ ಹೇಳಿ, ಇಲ್ಲ ನಿಮ್ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಹಾಕಿ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ. ಓಕೆ.
First of the order passed by Tribunal was, my lord, where, my lord, they hold that the right of the local candidates cannot be deprived in HKE, non-HKE region. And that was acted upon. And thereafter these circulars came, where they restrict, my lord, the HKE candidates to apply only in HKE area. If they give a option, they will be considered there. And one such order, Lord, is upheld by their lordships, my lord, while sitting with their lordship justice. Narendra. This process of enabling the HKE candidates to participate in the non-HKE, my lord, is upheld by this honorable court, my lord.
Was it when the recruitment process was on or before that?
Before, my lord,
So it was much before that one.
much before the circulars.
No, that's all right. But once the
There was no-
process begins,
No, there was no such question. There was not.
it
there
was
no
not the
such
point at all.
question whether they can be deprived in the non-HKE.
ಆ ಇಶ್ಯೂ ಯಾಕೆ ಹೇಳ್ತದು ವಿದೌಟ್ ದೇರ್ ಬಿಂಗ್ ನೋ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಪ್ರೊಸೆಸ್ ಆಗಬಹುದು ಅನ್ಕೊಂಡು.
Applications were common for both. The options were given, they considered, my lord, in HKE. HKE candidates wanted, my lord, that their names would be, my lord, in the non-HKE also. And the court held, my lord, that non-HKE person should be considered against the HKE candidates, candidature should be considered
Against
non-HKE.
non-HKE.
Subsequently, these circulars came. It was in 2015 and 16 era.
ಆ ಜಜ್ಮೆಂಟ್ ಇದೆಯಾ?
ಇದನ್ನ
ಒಂದು ಕಾಪಿ.
Lord, their lordship judgment, my lord, last time ಕೊಟ್ಟಿದ್ದೀನಿ. WP 334941.
ಮಿಸ್ಟರ್ ನಾಯಕ್ ನಿಮ್ದ್ರಲ್ಲಿ ಇಲ್ಲ ನಂದು?
This was rendered, my lord, in application 2018. The recruitment was in respect.
No, that came before just brother Narendra and brother Joshi, na? That bench.
Copy last time.
ನೋಡ್ರಿ.
3291 WP. APSC. You are reading that copy. 3394 of 2018. Judgment ಕೊಟ್ಟಿದ್ದು.
ಕಂಪೈಲೇಷನ್ ಕೊಟ್ಟಿರಿ ನೋ ಸಿಂಗಲ್. ವಿ ನರಸಿಂಹರಾವ್ ದೀಕ್ಷಿತಲು ಅದರಲ್ಲಿ ಸ್ಕೋಪ್ ಆಫ್ 371J, ಪ್ರೆಸಿಡೆಂಟ್ಸ್ ಆರ್ಡರ್, ಗವರ್ನರ್ಸ್ ಆರ್ಡರ್ ಇದೆಲ್ಲ ಎಕ್ಸಾಮಿನ್ ಆಗಿದೆಯಾ?
They examined, my lord, the right under article 6. Why they should be denied? They must be considered, since one application is there, they apply for both, it should be considered there.
The applications are in two silos. The application which have been filed there should also be considered here.
ಹಂಗಾಗಿ ಅದು ಅಲ್ಲಿ ಇದೆಲ್ಲ ಇಶ್ಯೂಸ್ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ.
There the meritorious candidates were considered, my lord, in the HKE, non-HKE reason. Ultimately, it will boil down to the same question, whether they should be denied an opportunity in non-HKE reason.
You also appear for petition?
I appeared for the petitioner in the case that is referred to by learned senior advocate, my lords. The issue was not that much.
was
The
not
issue was pertaining to,
That's what he also said.
yes, my lords. So that has no bearing on,
Right of the candidates under orders issued under 371J. Not much discussion and other.
it did not,
E.V. Narasimha Rao.
it did not have anything to do,
They were not considered.
it did not have anything to do with Hyderabad, Karnataka reservation also, my lords. It was only whether a meritorious candidate on his own merit could have been considered under GM or not. That was the issue.
But under in the light of 371J.
Yes, my lord. So that has nothing to do with the present issue at all, my lord.
Those notification came subsequently, my lord.
But
This
sir, but
question,
therefore it cannot be that.
yes. My lord, this judgment and the procedure that was being adopted, my lord, law was laid down, my lord, by the KAT and my lord subsequently upheld in this honorable court. To nullify this, my lord, they come out with this 2006-2022 and my lord 15-6-2022. They came subsequently. In the result, my lord, the judgment rendered by this honorable court, my lord, by their lordships, and my lord, in the other matters, my lord, before the KAT, my lord, they were nullified because they changed the basis of. They changed the basis.
So reverse.
Reverse. Then when the protest was made, they withdrew the circular, where again they go back to the same earlier procedure. If you are merit, you will be considered, wherever merit is there, you will be considered, irrespective whether you are HKE or non-HKE. Because application was one. My lord, it is a process of evolution, my lord. How this has to be worked, my lord, government is still learning. Even in 371D also.
We are also learning.
My lord, there is no concrete procedure as such, my lord, is accepted and acted upon. They are still in the process of permutation, combination, how it should work, how this will work, all this. In that process, my lord, all these applications, my lord, have been, the circulars have been issued. Your lordship may remember one thing, my lord, the circulars were issued not under the 371J. These are issued by the government. How can government either create an embargo, my lord, on 371J candidate? I can understand these circulars were issued at the instance of the governor, and thereafter it has been withdrawn. My lord, maybe, my lord, the scope and ambit of 371J will have to be considered. When this was issued by the government, curtailing the right of, my lord, the HKE candidates, just by saying that 371J has created one cadre for you, you go and get yourself selected in that cadre. And the learned single judge, my lord, in that writ petition says, it is not like a pigeonhole. The word that the learned single judge uses, it is not like a pigeonhole where you will be put into 371J pigeonhole. Such a restriction cannot be created by virtue of 371J.
Because of absence of non-obstante.
No, not
Even
without
by the scheme itself.
by the scheme itself. The existing right, my lord, have been taken away. And you get selected there only, you don't come to the other part. Whether that was intended under 371J. Now an attempt is made to say, when there is a separate cadre, you should be selected there only. My lord, by citing, my lord, the judgments rendered in 371D. If your lordship could see the presidential order, my lord, under 371D, there were 63 cadres, my lord, in Andhra Pradesh, in several zones that they created. By virtue of that, my lord, the entire, the cadre itself is, my lord, carved out for each district. Therefore, a person in A district cannot apply in B district. That was by the president himself. There was a restriction in the residence only. In that context, my lord, the Honorable Andhra Pradesh and the Supreme Court has said, no, they tried to change, and my lord, some leverage, and the post also they wanted to include. Then said, no, you cannot do it. You cannot go beyond the order of the president. There was absolutely no discretion for the government or anybody, my lord, in 371D. You should go by the presidential order only.
Even that is the contention of Mr. Naik.
That is what now they are trying to draw sustenance from that. Here, your lordship, will kindly see the order of the governor. There was no such restriction or, my lord, bifurcation, no. You create a separate cadre for them and see that the posts in the Hyderabad, Karnataka region are freezed for the locals.
That is the baseline.
That is the baseline. And in 371D, my lord, another controversy was with regard to civil post
Yes.
371D, my lord, the presidential order only speaks of civil post. In our case, no. It speaks of even the post in the local authorities, corporation, secretariat, even judiciary also. There are notifications issued by the registry for 371J.
Which President's order did not admit in 371D.
My lord, it speaks, my lord, it does not confine only to one class. It speaks of, my lord, all posts, my lord, in all departments. Whereas in 371D, my lord, it confined only to civil post. Then the government thought of, Andhra Pradesh government thought of including, my lord, the post in panchayat, post in corporation, post in other local authorities. That became a subject matter of a challenge. Then the courts have held, no, you cannot change. Then they thought of making appointment in the local cadre of that and transferring them to panchayat. They also said, no, you can't do that. Because it is a separate cadre, you should work out in that cadre only, in that zone only. Then therefore the question of Article 16.3 came, whether that such a classification can be made. Then it became a subject matter of adjudication. Now your lordship will kindly see 16.3. It is empowered, my lord, the state to make, parliament to make regional classification also. In that sense, my lord, there is a protection to 371J under 16.3. It is not hit by section 16.
Not hit by 16, Article.
Your lordship will kindly see 16.3, my lords.
16 to 16.3.
3.
When the president had issued under 371D, that was set aside. Thereafter, some legislative efforts were also made. That also
No, that was with regard to, my lord, local authorities. Your lordships have seen, my lord, you make a representation to the government, government will consider it to include those vacancies in that panchayat and corporation, local authorities. The posts in the local authorities were not subject matter of 371D.
only civil posts were.
Only civil posts. Therefore, question of 311, 309, all those things, my lord, came for consideration. Ultimately, the court head, you cannot travel beyond 371D. It is only the president. Whatever the president has said, he has confined only to this limited post. It should be to this limited post only. The government cannot meddle with it. It was in those contexts, my lord, those judgments have come. Nothing is This article shall prevent the parliament from making any law prescribing, I am reading, my lord, 16.3.
Parliament can make legislation and provide for that.
Yes. So 371J, my lord, it is under that the protected umbrella. Parliament has made it, creating a separate cadre, local cadre.
Mr. Nayak, you said when Parliament made law, even that came to be struck down by the apex court. Which is that judgment to just tell, please be seated and tell. A.V. Narasimha Rao, which is referred by learned judge in Andhra Pradesh judgment. No, that was after single judge, after that, the judgment of 2007.
Rishulu.
Rishul. That, when, no, Reddy. 2003, 7. Then that went in SLP. Almost barring little modification, no modification at all except adding something came to be affirmed. Thereafter, legislative efforts, parliamentary efforts were made to intrude. Even that came to be set aside. That was in 2018. Just for a moment. 249. 240. Arun Mishra or judgment, Allah.
Radhakrishnan and Rama Subramanian.
Start the page 249. 249 other ಬೇರೆ.
It is 249. Volume 2, compilation of case law.
Volume 2. Government Teachers Association, Telangana.
Conclusion of that judgment.
3 not?
Integration ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳಿ.
ಇದೇ ಜಡ್ಜ್ಮೆಂಟ್ ನೀವು ಹೇಳೋದು?
The judgment which his lordship was asking has been dealt with in para 17, page 260.
The decision of court in Vemareddy.
Yes. Was
Before the Supreme Court by so and so signs the
established
application
before
for
the
amendment
Supreme
cast it.
by a common order dated 15, passed in the entire batch of
Civil
appeals.
In so and so signs,
So and
few
so.
arising out of
A
the
few
decision.
arising
Yes,
out of decisions in Keshwalo and the rest arising out of decision in Vema Reddy, the Supreme Court held that there was no reason to interfere with the decision of this court and that the appeals were liable to be dismissed. However, liberty was granted to the state government to send a proposal to the union for obtaining the approval of the president. Since the final order passed by the Supreme Court in the said appeal has a bearing on the present round of litigation, the order is extracted. Para 18. By the time the Supreme Court passed order on 39, the composite state of Andhra Pradesh
the
was
bifurcation, no?
bifurcated under Andhra
Then it
Pradesh.
appears that both the state government pursued the matter with the central government. As a result, President issued 2 orders.
And this was struck down.
Even that was struck down.
Yes.
Because once that order is made, subsequently it cannot be, what is the ground
No.
on which it is struck down?
Lords, in Vema Reddy, while dismissing the SLP, they said state government can send a proposal to the
To central government, president.
central government,
Huh.
which they did.
Ah.
That was subject matter of a challenge. That is what is referred to in para 18.
No, after they sent proposal to the president, president had issued 2 orders.
Yes.
Even those orders came to be set aside.
So probably what your lordships have in mind is the legislation made in 2005 by the state of Andhra Pradesh to overcome the bar which had been imposed by the time limit. So the state government independently legislated,
Correct.
which was struck down.
Correct.
Probably that is what your lordships
Correct.
have in mind. Subsequent to this order, the again, my lords, 2 orders were made by the central government, which were also held to be bad.
Bad.
Para 83, 84, my lords, is the.
Correct. Got the point. Correct. We have ಏನು ಅವ್ರು ಎಲ್ಲರೂ ಮುಗಿಸಿದ್ರೆ ನಿಮ್ಗೆ ಅನುಕೂಲ ಆಗ್ತದೆ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಅವ್ರ ನಡುವೆ ಏನಾರ ಬಂದು ಹೇಳ್ಬಿಟ್ರು ಅಂದ್ರೆ ಹೌದು ನಮಗೂ ತ್ರಾಸು ಅವ್ರಿಗೂ ತ್ರಾಸದ ಇಬ್ಬರಿಗೂ ತ್ರಾಸು.
So one proposition which my learned friend made, that Parliament can make provision as an exception to 16(2) by virtue of 16(3) is not correct. The Supreme Court has said in Kailash Chand Sharma's case that you can provide for state as a whole.
Whole, not for any particular
Not
reason.
for particular reason. So even under 16(3), it is prohibited. 16(3) is an exception to 16(2) as long as it is addressed state as a
Whole
whole.
of the state again.
Not for the reason. So therefore, my learned friend's initial argument that this court had said you can't prevent them taking the other is not, the reservation itself would be bad because that would be it by 16(3).
Without reference to Article 371J.
Let's,
What I said, my lord, 371J has a protected umbrella under 16(3).
let's.
No.
Not a subject matter of, my lord,
Anyway, that may not arise also.
Let's, our handicap is these issues which my learned friend, I'm not stopping him, but if he were to formulate and give us, we can assist the court. Otherwise, these are not part of any pleadings anywhere, either before the tribunal or before the single judge, when the matter came up, my lords, before his lordship, Justice Sanjay Kumar.
ಈಗ ಒಂದು ಇನ್ನೊಂದು ಡೇಟ್ ಹಾಕೋಣಂತೆ ನೀವು ವಾಟ್ ಆರ್ ದಿ ಲೈಕ್ಲಿ ಕ್ವಶನ್ಸ್ ದಟ್ ವುಡ್ ಅರೈಸ್
Yes,
ಅನ್ಕೊಂಡು ನೀವು ಒಂದು ಫ್ರೇಮ್ ಮಾಡಿಕೊಡ್ರಿ.
yes,
You share with
yes.
your learned
In
friend
the
also.
meantime,
In the meanwhile, he will also share
if my
his.
learned friend has something to say in support of his case, if we were to formulate, then we can assist the court with reference to that.
No,
Because
but he-
anything
he-
outside, we remain unprepared, my lords, because we
it's a
don't know
difficult-
everything. We had to make some research to
ಅದನ್ನ
understand.
ನಾವೇ ಮಾಡ್ಬೇಕು. ಬಿಗಿನ್ ಆಗುವಾಗ ಇಷ್ಟ ಏನೇನ್ ಕ್ವಶನ್
That I'll certainly do, my lords, with reference to pleadings.
ಅಷ್ಟ್
But if
ಮಾಡ್ಕೊಡಿ.
my learned friend wants to urge something which is
not in the
outside,
pleadings at all.
let him formulate so that we assist the court, my lords, on that.
ಅಲ್ಲ, even otherwise also he fairly said that that
Yes,
question may
Lord.
not arise at. That's what. ನಾಳೆ ಏನೇನಿದೆ? ಅದು ಒಂದು ಆಮೇಲೆ ನಾಳೆಗೆ ಹಾಕೋಬೋದಾ?
Lords, it
Stipulation.
is for them to,
ಅಲ್ಲ ಬಟ್ ನೀವು ಇರ್ಬೇಕಾಗ್ತದೆ.
no, I'll be here, my lords. I have no difficulty, but then
ಹಾಕೋಬೋದಾ?
I won't be able to formalize the quiz.
ಅದು ನಮಗೂ ಅನುಕೂಲ ಆಗ್ತದೆ. ಒಂದ್ ಸೈಡ್ ನೋಡಿ ನೀವೆಲ್ಲ ಮುಗಿಸ್ಮೇಲೆ ನಮ್ ನೋಟ್ಸ್ ಮಾಡ್ಕೊಂಡಿರ್ತೇವೆ ಮೆಂಟಲಿ. ಓ ಇವ್ರು ಹಿಂಗಿಂಗ್ ಮಾಡಿದ್ರು ಈ ರೀತಿ ವಾದ ಅನ್ಕೊಂಡು ಅಂತ. ಅವಾಗ ಇನ್ ದ ಲೈಟ್ ಆಫ್ ದಟ್ ವಿ ಕ್ಯಾನ್ ಹಿಯರ್ ಯು. ಅದರ್ವೈಸ್ ನೀವು ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ವಿ ಅಲ್ಲಿ ನಮ್ದೊಂದು ಸ್ವಲ್ಪ ಹೆಂಗಿದೆ ಅನ್ಕೊಂಡು ಬಂದ್ಬಿಟ್ರೆ ಅವರು ನಾವು ಇಲ್ಲ ಅನ್ಲಿಕ್ಕೂ ಬರಲ್ಲ. ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಮ್ಯಾಟರ್ ಇದು.
Since there are different cases, insofar as I am concerned with reference to assistant professors, I can formulate what arises in that case, because the other cases have a slightly different
Different ಇದೆ.
connotation. It is district-wise reservation, etc. So I am not very familiar with that and what issues arise under that. So therefore, my lords, insofar as
ಅಟ್ಲೀಸ್ಟ್ ನಿಮ್ಮ ಕೇಸ್ನಾಗ
I will certainly do that.
ನೋಡೋಣ.
I'll certainly.
But learned AG.
Whether it is amounting to change in the rules of the game, whether it can be retrospective.
ಅದೇ ನೀವು ಅದೊಂದು ಚಿಕ್ಕದೊಂದು ಲಿಸ್ಟ್ ಅಂದ್ರೆ ಮಾಡಿಕೊಟ್ರೆ ಇನ್ನುಳಿದವ್ರಿಗೆ ನಾವು ಈ ರೀತಿ ಬರ್ರಿ ಅಂತ ಅಂದ್ಕೊಂಡು ಹೇಳ್ಬಿಡ್ತೀವಿ.
Let's, I'll just point it out. There are 4 recruitments in question. The writ appeal.
ಅವ್ರದ್ದು ಒಂದೇ ಒಂದಿದೆ.
ಅವ್ರದ್ದು ಒಂದೇ.
ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್.
Please, madam, that's a batch of 6 cases.
And Chandrasekhar appears for
In that case.
ನೀವು
yeah.
assistant professor. sir.
Alla, our
So
case-
you are a real opponent to Mr. Naik.
Please, my lords, there, lords, insofar as the writ petition order of Justice Sanjay Gowda's, which arose of, that is out of KPTCL recruitment, because the jurisdiction lies with the High Court directly, my lords, it was filed in the, as a writ
ಅದು
petition.
ಅಪೀಲ್ ಇಲ್ಲ ಅದ್ರ ಮೇಲೆ ಏನು
ಅದ್ರ ಮೇಲೆ ಒಂದು appeal ಇದೆ ತಮ್ಮ ಮುಂದೆ.
ಒಬ್ರು ಹಾಕಿದಾರಲ್ಲ ಯಾರೋ
ಅದು ಹಾಕಿದ್ದಾರೆ.
ಒಂದೇ ಅಪೀಲ್.
ಒಂದು
Somebody your brother, not you, some other person said that we have filed appeal against
It is
that.
there, my lords. List ಕೊಡಿ.
That was 1218. Correct.
Serial number,
1218.
please, 30.1. Lords, in that case, actually what happened insofar as the list that arises there, there were 2 cadres, my lords, junior engineer and assistant engineer. There, my lords, in view of the fact that the single judge, after upholding the circular and the process, also said that in view of additional vacancies that are arising, in respect of one of the cadre, my lords, it got sorted out. In respect of the other cadre, my lords, only 1 person or 2 persons have filed the writ appeals. They were actually, it got tagged with these petitions. They were not complying with the office objection. Sriranga was appearing for KPTCL and he was making a submission. But still, my lords, that is before my lords. Now, apart from that, the matters which went up before the tribunal were 4 batches, as I said, assistant professors, my lords, primary school, graduate primary school teachers, and my lords, reserve sub-inspector's post, and the rural drinking water scheme, one other recruitment. My lords, so out of these 4, 2 were, my lords, circular has been struck down, where the state is the petitioner. In 2, my lords, the circular has been upheld. But ultimately, my lords, it is the petitioner who, the counsels who have argued on the other side, my lords, are in support of the, are contending that the circular is bad. But one thing, my lords, that has to be noted here is when 2020, when all the in all these cases, my lords, the facts that are common are that when the 2020 circular was in force, my lords, the recruitment notification was issued. And in the recruitment notification, the 2020 circular was also referred. That is one fact, which again, my lords, it could be a factor that because insofar as recruitments are concerned, when we refer to a certain circular, my lords, in the recruitment notification, it has a certain connotation in law in respect of. Thereafter, my lords, during the pendency of all these recruitments, the 23 circular came about. And thereafter, my lords, and in some of the cases, the provisional select list was issued.
ಯಾಕಿಷ್ಟು ಮೆಸ್ ಮಾಡ್ಕೊಂಡ್ರಿ? ಯಾರು ಒಬ್ರು ಒಳ್ಳೆ ಅಡ್ವೈಸ್ ತಗೊಂಡು ಆಮೇಲೆ ಈ ರೀತಿ ಮಾಡಿದ್ರೆ ಇಷ್ಟೆಲ್ಲ ಕಾಂಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ.
In this circular, they mentioned that there were pressures from the representatives of that area and the cabinet took a decision on
No,
that.
the other way of looking at it is we are very honest about what was in the circular, why, how it came about. So I will also formulate the 4 different batch of cases, and I'll just give a note, my lords. And in the main issue that arises is with regard to the circular. Now, but in view of the arguments that have been advanced, my lords, that the government circulars could not have gone beyond, my lords, the formation of the cadres itself. That is a separate issue, my lords. That is the only thing which arises in interpretation of 371J.
At least ನೀವು
ನಾ ಮಾಡ್ಕೊಡ್ತೀನಿ. I'll do it.
ಯಾಕಂದ್ರೆ 4 ಕೇಸ್ ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ.
ಹೌದು, ನಾನು ಮಾಡ್ತೀನಿ.
ಈ ಸೈಡ್
I will do tomorrow itself. I'll
ಮಾಡ್ಕೊಂಡು share it with Mr. Naik and
Please.
Mr. Chandrasekhar.
And Rajgopal sir and other counsels,
ಅವ್ರ ಜೊತೆ
because ಅವ್ರದ್ದು school education ಇದೆ. Then I think in so far as PP Hegde sir is in sub-inspector's case, sub-inspector's case, and Kantraj sir is in the other batch. I'll share it.
ಬಟ್ ಒಂದು ಅವ್ರಿಗೆ ಬಂದು ನಾಳೆ ಅಟ್ಲೀಸ್ಟ್ ನಾಳೆ ಹಾಕೊಂಡ್ರೆ ಅವ್ರು ಬಂದ್ರೆ ನಾಳೆ ಮುಗಿಸೋ ಮಟ್ಟಿಗೆ ಇವ್ರು ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರೆ.
Please, madam.
ಇಲ್ಲಪ್ಪ ನಾನು ನಡಿ ಅವ್ರು ಸ್ಟಾರ್ಟ್ ಆದ್ಮೇಲೆ ನಾನು ಐ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಡಿಸ್ಟರ್ಬಿಂಗ್.
Please, madam.
ಯಾರನ್ನೂ ನಾವು ಅಲೋ ಮಾಡೋದು
Because our side we have to complete.
ಅದಕ್ಕೆ ಅದು ಡಿಸ್ಟರ್ಬ್ ಆಗತ್ತೆ ನಮ್ಗೆ, ನಮ್ಗೆ ಥಾಟ್ ಪ್ರೊಸೆಸ್ ಡಿರೇಲ್ ಆಗ್ತದೆ.
And we would be
know-
answering something, a new question pops up.
ಅದಕ್ಕೆ
My entire, we are
Correct.
misdirected.
ಆಮೇಲೆ to the extent possible confine to your pleadings. Otherwise, they, you also may be in a disadvantageous
ಹೌದು.
position. They also
sir.
may be in a disadvantageous position. Pleadings ನಿಂದ ಹೇಳುವಂತ questions ಆ ರೀತಿ ಇರ್ತದೆ.
Please.
ಅವಾಗ ಈಸಿ ಆಗ್ತದೆ.
ಹೌದು.
That's the purpose of.
That is the
pleadings.
purpose of pleadings.
Otherwise, ಯಾವುದೋ ಒಂದು ಹೊಸ issue they may crop up also. We can't say like that. It may crop up sometimes. To the extent possible, ಅದನ್ನ avoid ಮಾಡಿ.
Please.
We have another bench.
Bench, please.
How, my lord, sir?
I'll just take.
Why do you want to use the meritorious candidate in HKE? Let them remain in HKE. A candidate with less merit, let him be appointed in non-HKE.
No, my lord,
No,
there is a option procedure. They are entitled to opt for non-HKE.
These are the person that was put to court and make it appear that the person may be interested in HKE only, you are compelling him to go to non-HKE.
ಹಂಗಿಲ್ಲ ಅದು.
ಹಂಗಿಲ್ಲ.
ಹಂಗಿಲ್ಲ, ಇವ್ರು ಹೇಳ್ತಾರೆ.
Okay. I'll just take you.
Promotion have to be more. Why do you want to compel him to come to the non-HKE? He is not saying. The candidates of non-HKE are saying, you are better suited there, don't come here. These are all the arguments that my lords will have to consider within the framework of the what will actually the question of law that is required to be answered. What happens to a candidate, where he will go ultimately, it's a matter of choice and ultimately his right not to be considered. What is the scope of 371J? Has it created any embargo upon the candidates of HKE area? No, that will be the real question.
Whether they are entitled to serve in the same reason or they can be compelled to go.
Embargo those candidates from competing in non-HKE. Some and substance of argument will be.
This will be the baseline of your argument.
Everything will fall in line what if this question is done.
With utmost respect, no, the baseline probably would be at what stage can that exercise be carried out?
I'll just show my lord in 10 minutes how this is happening.
ಅಲ್ಲ ಈಗ ಬೇಡ, ಈಗ ಇದೊಂದು ಇದೆ.
I'll just take 10 minutes, my lord. I am not going to repeat. ಅಲ್ಲ ಗೊತ್ತಾಯ್ತಾ? I am not going.
ನಾಳೆ ಬಂದು ಹೇಳಿದ್ರೆ ಕೇಳ್ತೀವಿ.
ಆಮೇಲೆ ಅವ್ರು ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ
ಇಲ್ಲ
ಅದು ಬೇರೆ ಪ್ರಾಬ್ಲಮ್
ಅಲ್ಲ ಅವ್ರ ಮುಂಚೆನೆ 10 ನಿಮಿಷ.
ನಾಳೆ ಬಂದ್ಬಿಡ್ತೀವಿ.
Yes.
ನಾಳೆ ಹಾಕಿ 2:30 ಹಾಕೋಣ.
2:30.
2:30 ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ಓಕೆ. 2:40 ಆಗ್ಬೋದು ನಿಮ್ದೊಂದು. 2:40 ಆಗ್ಬೋದು. ನಾ ಫೋನ್ ಮಾಡಿಸ್ತೇನೆ ಇಲ್ಲಿ ಅವ್ರದ್ದು ಆದಾಕ್ಷ.
ಯಾವ್ದೋ pronouncement.
29 ಏನದು? You need not wait. Mr. Nayak, ಹೋಗಿ, we have some other work. Yes. ಆಯ್ತು, ನಾಳೆ ಮಾರ್ನಿಂಗ್ ಹಾಕೊಳ್ಳಿ. ನಾಳೆ ಮಾರ್ನಿಂಗ್ ಬರ್ಲಿ. ಓಕೆ.
Serial number 27, my lord, it's a very short matter.
ಬೇರೆ ಇಲ್ಲ, ಇದು ಇದೆ, ಅನದರ್ ಬೆಂಚ್ ಇದೆ. ಈಗ ಹೆಂಗ್
My lord.
Immediately application.
My lord, serial number 22, my lord, kindly.
You have said we have already.
My lord, ಇದರಲ್ಲಿ ಡೆತ್ ಬೆನಿಫಿಟ್ಸ್ ಬಂದಿಲ್ಲ, ಪೆನ್ಷನ್ ಇಲ್ಲ,
ಅದಕ್ಕೆ ಇದು 3 ದಿವಸದಾಗ 8 ದಿವಸದಾಗ ಏನಾಗ್ತದೆ?
ಲೈವ್ಲಿಹುಡ್ ಗೆ ಕಷ್ಟ ಆಗಿದೆ my lord.
ಏನ್ ತ್ರಾಸ?
ಅಲ್ಲಿ there is no interim order, ಮತ್ತೆ ಅದು ಅಮೌಂಟ್ ಎಲ್ಲ ಪ್ಲೀಸ್ my lord, tomorrow my lord. ಏನ್ ಮಾಡೋದು ಮಾಡೋದು?
You can sit here. Oh, the mic is closed. List of dates. After dates.
I'm the update for the respondent. Yes, my lords, in this matter, I had sought time because learned senior counsel, Mr. Raghavan.
The lady with the child is here.
Sorry.
Because
Hello.
of that case. Sorry.
Yes, my lords, unfortunately, Mr. Raghavan is still on legs in one arbitration matter. Kindly permit me to assist your lordships instead of Mr. Raghavan, a poor substitute, no doubt, but I will assist my lords. Because we may require not more than 30 minutes to finish, 35 minutes.
I can complete it today if your lordship permits me. I'll complete.
Please.
Lord, may I request your lordship to kindly take the dates and events by the APMC, my lord, which has been given on 12th, filed on 12th of April 2023, my lord. Court officer. Names and dates. The dates events of your APMC, which respondent for. Well, preliminarily, two grounds were urged. One is that the final notification has not been issued within 1 year.
Award is behind.
Award has not been passed within 2 years from the date of the final notification. Now, if the dates given by the fourth respondent are seen, my lord, the notification is published in Gazette on 3rd of September 1994. my lord.
And the next day itself.
And
it is
17th of September 1994, it is published in Sanjay Vani and Samyukta Karnataka newspapers. 17/9/1994, my lord.
3994.
3994 is the Gazette, my lord. 17/9/94 are in the two, yes, my lord, two local newspapers. And 11/10/1994 is the village Chavdi, my lord. Which 11/10/1994, my lord, is in village Chavdi. Now, my lord, even in our statement of objections, we have categorically stated that there is a village Chavdi which has been taken on 11/10/1994. my lord. So the date should be the date on which the village Chavdi has been taken place, my lord, is the date which should be reckoned for purpose of, I have a decision to that effect, I'll point out, my lord.
From Mr. Learned DAG, Mr. Ron submits that the 3994 final notification, another preliminary notification.
Preliminary notification.
The preliminary notification under 4.1 having been notification dated 3/9/1994 should under section 4.1 was published in the local newspapers on 17/9/1994, and that the notice was affixed to Chowdi.
Yes.
On 11/10/1994.
Yes.
First off, that being the position for reckoning the statutory period of 2 years, 1 year.
1 year.
1 year, comma, the Chowdi affixture to be
Should be taken into consideration for
to be
computing.
reckoned. To be reckoned. In computing the period of limitation of 1 year, the Chowdi notice date should be reckoned.
Yes. And this fact is also stated in our statement of objections.
Ruling out.
Ruling it.
Give them in support of these
Sir,
sites.
court officers.
But
Page 26, my lord.
suppose ನೀವು 3/9/1994 ಇದೆಯಲ್ಲ
3/9/1994. Yes, ma'am.
ಹೌದಾ?
ಹೌದು.
ಅದಾದ್ಮೇಲೆ
17/9
5 ವರ್ಷ ಬಿಟ್ಕೊಂಡು ಚೌಡಿಯಲ್ಲಿ ಪಬ್ಲಿಷ್ ಮಾಡ್ತೀವಿ. ಅವಾಗ ಏನಾಗ್ತದೆ ಲಾ?
Lord, then
Then
reasonable.
that will very defeat very purpose
Correct.
for which 1 year is prescribed.
Correct, Lord. But
Yes.
here, Lordship will see 3rd of September 94 and 11th of October 94. There is hardly 1 month in this case, my lord. From the date of the Gazette, 3/9, 17/9 is
Correct.
the
In support of that.
para
Presses into
7 and 8.
ILR 1991 Karnataka 1183 DB paragraph.
para 7 and 8 maybe.
Paragraph 7 and 8.
Lord, I'll read, my lord.
Well,
Para
if it
7,
is
Lord,
then
page 30.
proceed further.
Yes, that's it.
Okay.
My lord. Now, my lord. So then, my lord, the next
VT
from
Krishnamurthy versus Stater case. 7 and 8. 1 second, I will just look into. Sundar Swami.
my lord, just another point. my lord.
Ah.
So therefore, if your lordship takes the delay of the period of stay granted in WP 28988
7
of
and
90,
8,
para 7 and 8, my lord.
final notification.
Same will apply
Article.
for purpose of award is what is taken. my lord.
In case ಬೇರೆ that did not include limitation period prescribed under section 6 at all.
Lord,
Post
for-
6 ನಲ್ಲಿ ಏನಾಗ್ತದೆ ಅನ್ನೋದಿದೆ ಇದು.
Correct. my lord. Now for
4-1 ಆದ್ಮೇಲೆ
village chavdi for both preliminary and final notification.
ಎರಡು
Lordship may kindly permit me to read para 8, my lord. Under the circumstances at page 31, I am of the opinion that while calculating the time period between final notification under section 6(1) of the LAC Act and publication of the award passed under 11A of the LAC Act, the date on which the last of the 3 publications envisaged has to be considered. In the instant case, the final notification was published in the relevant village chavdi on 29th of April 2009. There is no dispute as to it. The general award has been passed on 30th of March 2011. The time period between final notification under section 6(1) of the LAC Act and passing of the award is therefore within 2 years. Under the circumstances, so and so it cannot be held. So therefore, my lord, the last of the publication should be taken into consideration. In my case, the 11/10/1999 is the village chavdi, my lord, 94. And the final notification has been issued on 10/10/1996, excluding the period of stay of 1 year, 1 day in WP number 28988 of 94. Then it falls within 1 year from the date of the publication.
No, I'm just asking you.
Yes, ma'am.
Suppose we are giving to test, we have to take the extremes going by principles of logic.
Yes,
ತರ್ಕಶಾಸ್ತ್ರದಲ್ಲಿ 3/9/94 ಗೆಜೆಟ್ notification.
yes, ma'am.
You will sleep over for 5 years. One fine day, you will put the affixture, go by affixture to Chowdi, village Chowdi.
Then it would be mala fide, ma'am, because the lordship will see, just in order to save the limitation.
Not,
They will-
not malified. Very honestly they will do. Honestly they will do. ಅವಾಗ ಏನಾಗ್ತದೆ? Therefore, the proposition, we have just think, only one point he says the gap is not that big.
Gap is 1 month, ma'am. 1 month,
139/11/10.
1 month, ma'am.
1 month.
Just 1 month. ma'am. Because the process, if lordship also sees, 3/9 is,
These two notifications and Chowdi are not for your benefit. They are for the benefit of the landowners only, perhaps.
but in this instant case, my lord, I'll also point out that they have responded to the notification by virtue of the newspaper on 17/9/1994.
Correct.
But yet, since the section 4 mandates, my lord,
Chowdi.
we have also taken the Chavdi on 11/10/1994. There's a master drawn. I'll file it along with the memo, my lord, where the witnesses, villages have also
Signed it.
have signed. There's a master drawn to that.
So that your contention is it's within that time.
It's within that time.
Second point.
The second point, my lord, is with regard to the Final notification is on 10/10/1996. And draft award is on 12/8/1998.
Once. Final notification.
Is 10/10/1996, my lord.
Gadget.
Yes, my lord.
Ah.
And then the
Award is passed when?
draft award is the only draft, my lord. No award has been passed under 11A. Now, there is a stay granted in this honorable court, in this writ petition,
Draft is dated.
12th of August 1998, my lord.
Draft award is no award.
No award, my lord. Now,
Stay granted on
in this writ petition on 8/2/1999,
once.
my lord, before
99.
8/2/1999, stay of disposition insofar as the present.
Disposition.
This, I'll come to that.
Awardment you can say.
I'll come to that. Okay. Then 16/9/1998, my lord, is the stay in WP number 6880 of 97,
Once. 16.
9/1998, my lord.
Huh.
Stay of further proceedings in WP number 6880 of 97.
ಇದೇ matrix.
ಇಲ್ಲ ರಾಜಾಜಿ ಹೌದು ಇದೇ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ದಿ ಸೇಮ್
Parties ಇವರಲ್ಲ.
parties. The trust was also arrayed as a party.
Trust was also part.
Arrayed as
6990 stay in
WP number 6880 of 97.
ಏನೋ ಮಾಜರ್ ಕಾಪಿಯನ್ನು ಕೊಡ್ತೀನಿ ಅಂತ ಅಂದ. Copy
ಕೊಡ್ತೀನಿ. Give me. Give the
To
copy.
which petitioners were also parties.
Yes, ma'am.
Trust was a party.
Trust is the party.
Stay of further proceedings, sir.
Yes, my lord. And that came to be disposed of 15/7/2014.
Disposed of on
15/7/2014.
ಅದಾದ್ಮೇಲೆ ನೀವೇನ್ ಮಾಡಿದ್ರಿ?
My lord, now, my lord, just stopping here for a moment. There was no impediment to pass the award is what is being contended.
Correct.
Similar issue arose. Your lordship may kindly take the first decision which I have given. Division bench of this honorable court, ILR 1991, Karnataka. The
Stay, see.
stay of disposition.
96. Correct, ah?
10/10/1996 is the
It is
final
final.
notification. In the
To be issued on
in the Rajajinagar Housing Building Cooperative Society, WP number 6880 of 97, 16/9/1998. That is within 2 years,
2 years.
within 2 years. And it got disposed of
14/7/2014.
14/7/2014. In the meanwhile, in this writ petition, my lord, 3884 of 1999, the order is 8/2/1999. There's an order of stay of disposition,
8/2/99.
1999.
Disposition ಗೆ
I'll cover it.
cover ಆಗತ್ತೇನು?
I'll cover it, my lord. This decision directly is on that point.
Because that comes
They have to,
11A.
yes, they have said holistic reading of the other provisions has to be taken into
See
consideration.
further stay ಅಂತ stay of further proceedings ಅಂತ ಅಷ್ಟೇ
ಹೌದು,
ಅಲ್ಲ.
ಅಷ್ಟೇ ಆಗಲ್ಲ, because it also will relate to taking back the possession. And if possession cannot be taken, then the explanation to section 6 must be given full effect to para 6 of the writ petition. my lord. Para 6 of the decision. Though page 8, my lord, first decision ILR, yes, VT Krishnamurthy versus State of Karnataka. Para 6, my lord. Though as stated above, several grounds have been urged in support of the writ petition before us. Mr. So-and-so learned counsel for petitioner would confine himself to only 2 questions, namely, I'll omit the first one. Lord. Second, reckoned from the date of publication of declaration under section 6 of the Act,
Beyond
that is
2 years.
24th of 83, the award had come to be passed beyond 2 years stipulated under the proviso
Therefore
section
bad.
11A of the Act, therefore the acquisition is bad. Then, my lord, Mr. Sundar Swamy contended as the acquisition is one essentially for companies, the procedure under Part 7 of the Act must have been followed. Failure to follow the same will vitiate the acquisition. It's not the stand of the state government that this procedure followed. Therefore, on the short ground, the acquisition is liable to settle. Even otherwise, this is a case in which there's a gross violation of section 11A of the Act. That section had to come to be introduced by amending Act 68 of 84. The object of that section is to cut down the delay in matters of this kind. Therefore, the section specifically provides that if no award is made within 2 years from the date of publication of section
Anyway, he
6.
says it's bad
Yes,
because
Lord.
it is beyond that time.
Yes,
Where is that?
and
statement?
I'll point out, Lord, your lordship may kindly, one second.
Last paragraph.
No, paras 9 may be taken, my lord. Mr. R.N. Narsimurthy, learned counsel appearing for respondent 4 would submit that section 11A of the Act should not be considered in isolation. This must be construed along with section 9, which talks of notice to persons interested intending to take possession of the land. When this is read in conjunction with section 17, it will be clearly seen that section 17 came to be modified only on 24/9/84 because of the deletion of words waste or arable. On that date, if they wanted to issue notification that had been by reason of the stay granted on 20th of December 1983, therefore merely contending that only stay of disposition has been granted and there was no impediment to pass award is not correct. The explanation is very wide in its scope. It talks of any action or proceeding to be taken in pursuance of the said declaration. Section 6.1 explanation again uses the words action or proceeding. Section 6.3 says that after making of such declaration, government may acquire the land. Therefore, acquire is the action and proceeding is in relation to compensation. Consequently, if action or proceeding is stayed by the court, definitely it would inure to the benefit of the government. Now, my lord, the lordship will see in the next page, page 14, para 12, point number 2. Lordship may kindly turn to, after interpreting the word action and proceeding, my lord, para.
Action relates to acquisition, proceeding relates to compensation.
Yes, my lord. Kindly see, my lord, the page 16, lordship will get it. More importantly, if construction placed at page 16, my lord, more importantly, if construction placed by Mr. Sundar is to be accepted, language would have been in relation to making award instead of any action or proceedings in pursuance of such declaration. It's a narrow construction on comprehensive language used in explanation that is sought to be advanced. We are unable to agree. Precisely what has now been contended before your lordship, that yes, same point arose and the court did not accept that contention. Lord, another point, Lord, that I am relying this decision on, if lordship recollects. Now, my lord, nearly 9 crores and odd has been deposited by APMC insofar as this 172 acres are concerned. 6 crores is deposited insofar as the 100 acres which has been acquired under the urgency clause is concerned. Now, they have participated in a meeting which I pointed out, my lord, where they come and the heading of that meeting itself says consent for award. Consent for award. They participate and the price is fixed for both Srigandha Kaval and Hero Alli. Now they withdraw compensation of 2 crores and odd insofar as the Hero Alli is concerned.
Not Srigandha Kaval.
Not Srigandha Kaval. But they withdraw the compensation insofar as Srigandha Hero Alli is concerned. 2 crores is withdrawn. That is deposited back after the learned single judge order saying that the acquisition has lapsed. But if lordship sees they have retained that amount for nearly 14 years, this 2 crores and odd is retained by the trust for 14 long years, my lord. Now, lordship may kindly see the last paragraph of this decision, para 14, at page 24. This judgment has been consistently being relied upon by this honorable court in various decisions, my lord. Para 14, page 24, my lord. There's one other aspect which has a bearing. Admittedly, the petition, page 24, my lord, para 14. There is one other aspect which has a bearing. Admittedly, the petitioners filed the claim statement on 31st of March 1983, and the writ petition was filed on 19/12/1983. We have held in the writ appeal so and so as follows. This is clearly a case in which writ petition itself is not maintainable because admittedly
Once
he
he
had.
seeks compensation, then challenge to equation is not maintainable.
That's all. So today, my lord, their conduct itself, the question of going into Delhi AirTech, 80% not having been deposited, everything stands condoned because they have accepted the compensation. Now I ask a question to myself, my lord.
Paragraph 9.
This is paragraph 14.
14.
Lord, now I ask a question to myself, Lord. When would a land owner be entitled for compensation? Only if the land is acquired, my lord. He has received this amount, and if the landlord says it is without prejudice, that means without prejudice to seek enhancement of compensation. Now what they do, they receive this compensation of 2 crores. They also file an enhancement application before the civil court. A reference is made under section 18.
Petitioners have sought
Yes.
for reference.
Yes, my lord. They have made a reference. They have sought for it. Lordship, I'll file. Lord, what
AAG submits that in computing the period of 2 years for passing of the award, reckoned from the date the final notification was published, the interim order need not be stay of all further proceedings. Even if there is some interim order that comes in the way of interdicting action of acquisition.
Yes, correct. Yes,
The relaxation in terms of 11, proviso to 11A would be available.
The explanation to section 6 also.
First, same logic applies to invocation of explanation to section 6. First, in support of this, he banks upon the very same decision, paragraph 8 are the 9. Para 9.
Yes,
Para 9. VT Krishnamurthy.
9 and 12 also.
9 and
para 12.
Para 9 and 12.
Yes.
12. That is running page 16.
Yes, ma'am.
9 is 11, page 11.
Yes.
And para 12 at the page 16.
Yes. Your Lordship may kindly take the memo.
Submits that where the landowner has preferred a claim for compensation or for enhancement of claim of compensation, ordinarily he cannot maintain a challenge to the acquisition process at all. First off, he points out that the petitioners had sought for section 18 reference.
Yes.
Seeking enhancement of compensation, and therefore they cannot challenge the acquisition. First, further, he tells the court that a sum of rupees 2 crore deposited by the state by way of compensation has been retained by the petitioners for a period of 14 years, although they remitted back pursuant to order of this court. Remit madidava vapas kottidava 2 crore.
2014, in the year 2014.
How long they retained that?
For 14 long years, nearly 14.
18/10/2020.
Wide order dated 18/10/2014.
2014. Order is dated 24/6, my lords.
Wide order dated 24/6.
2014.
And the remittance was made on
18/10/2014.
My lord,
in support of that, have judgment to the new head.
Lord, the same para 14 of the
Para
judgment.
14. of Krishnamurthy is pressed into service. Okay.
That's the intention. Before I take your lordships to the memo, my lord, the order of remand by the Honorable Supreme Court. The Honorable Supreme Court also,
But whether you took up that contention that writ petition is not maintainable.
my lord, we filed a memo, they filed objections to it. I'll take your lordship,
Apex
no,
court.
here in this court itself,
Saying
that they have received the compensation and therefore the writ petition does not survive.
who had filed that?
We had the state had filed the memo, which is on record,
Correct.
and they filed objections to that memo. Now, my lord, what has happened? When the,
One second. Based upon that, writ petition came to be dismissed.
no, my lord, the, based on that, the court went to decide on 24/2 that the acquisition had lapsed. No orders were passed insofar as the memo is concerned. But we did, at the earliest point of time, we did say that the writ petition has become infructuous.
Learned AG says that memo dated
Dated 17/7/2003,
17/7/2003 was filed.
filed in WP
This court
37140.
in WP
37140.
of 2000.
7.
2000
It's actually
99.
wrong, 19, ತಪ್ಪಿದೆ my lord, memo ಅಲ್ಲಿ ತಪ್ಪು ಬರ್ದಿದೆ.
cannot be.
It can't, 2000, ಇಲ್ಲಿ 2007 ಅಂತ ಬರ್ದಿದೆ.
2000 seeking dismissal of the petition.
Saying that writ petitions do not survive
Since-
and same are liable to be dismissed.
Since telling that the writ petition does not survive, comma, the claim for compensation having been made and the 2 crore rupees having been received by the petitioner. However, no order was passed on the said memo. Allah, ಅಲ್ಲಿ 24 ಮೇಲೆ ಆಯ್ತು ಅಂತನಾ? They said 24 is not applicable.
24/2, it
That
does
is
not
24
lapse.
of export.
Yes.
So
Here,
of
the
export,
learned single judge applied 24/2
Okay.
and allowed the writ petition,
Okay.
which was carried up to the Supreme Court. And the Honorable Supreme Court has now said 24/2 will not applicable insofar as the present facts are concerned. And except 24/2, all other issues will be
Where
decided.
it remanded for consideration.
Yes. By categorically stating, holding that 24/2 is not no more available for the court to decide on that aspect. Now, my lord, even remanding the matter back, while remanding the matter back, the para 3.4.4, I'll just read to your lordship.
Apex court order.
Apex court order, where they say the said compensation was accepted by the fourth respondent under protest. Respondent 4 trust, original landowner filed land acquisition case number 1 of 2003 seeking enhancement of compensation, which seems to be pending. So the
No,
fact
if that were to be so, they would not have remanded the matter
No,
at
my lord,
all.
nobody has urged this point. I'm
The
now,
order says,
my lord, correct, my lord. Now it's for your lordship to apply the settled position of law, which says, my lord, as I said, you receive the compensation. You're entitled to receive compensation only if your land is acquired.
no, I am just asking myself, as often the members of the bar would say, I question myself this way. If that was the finding recorded by the apex court.
No, not
where was
finding,
the
Lord.
need for, no. the
They have
finding
just
as to
noted it.
They having,
Yes.
they having received the
Yes,
compensation.
yes.
They having made reference under 18.
Correct,
Where was the need for remand at all? Anta?
correct. Such simple point should have been taken note of and matter should have been decided. But yet, the Honorable Supreme Court has left it open for your lordships to decide on this aspect. Absolutely covered by decision which says that you cannot approbate and reprobate. Once you, it's like an arrow being shot, my lord, you cannot recall it. It is bound to hit the target. They have elected.
Well, whether it hits the target or not, it cannot be recorded.
That your lordship will decide, my lord. That your lordship will decide. My lord, now, my lord, this aspect that they have filed for enhancement is also found recorded in
With
the
the
order of
apex.
remand. Yes. Now, what is the effect your lordship will have to apply? My lord? This is an aspect that also falls for consideration.
Learned AEG draws attention of the court to paragraph 8.3.
3.4.4.
3.4.4 of apex court judgment order
22nd of March 2022.
dated
22nd of March 2022.
2022.
Yes.
Wherein a specific finding has been recorded to the effect that petitioner has claimed compensation and he has preferred section 18 reference
Yes,
for
sir.
enhancement.
In
And
case,
he has,
in LSC case number 1 of 2003,
in LAC case number 1 of 2003
seeking enhancement of compensation.
and ಅಲ್ಲಿ ಪೇಮೆಂಟ್ ರಿಸೀವ್ ಮಾಡಿದ ಬಗ್ಗೆ ಬಂದಿದೆ
ಅದು ಬಂದಿದೆ. The said
And-
compensation was accepted
and
under protest.
he has received, accepted the compensation under protest. Under protest. And under protest ಅಂತ accept
That's all,
ಮಾಡಿದ್ದಾರೆ.
that's all. That's exactly. my lord. If I receive the money under protest, it only means that I am not precluded from seeking enhancement of compensation. Now it's like mutually destructive
That
plea.
protest is only for seeking
Yes,
enhancement.
protest can only be for seeking enhancement of compensation.
He hastens to add that the protest should be construed only to mean that they have not given up their right to claim enhancement.
So the memo which I have filed.
And not for retaining their right to challenge the acquisition itself.
They have contested, they wanted to lead evidence, they have marked documents in the LAC case, my lord. And then it was again carried in writ petition before this honorable.
What happened in LAC?
Look, they have to probably apprise. I'm not aware of.
Reference ಏನಾಯ್ತು?
37174, my lords, that 100 acres, that we have noted in our list of dates, my lords. On 22/9/2014 itself is withdrawn after the disposal by the learned single judge.
There are two lists, my lord. One is 3884, ಇನ್ನೊಂದು 37170 ಅಂತ ಹೇಳಿ, ಅದು ಎರಡರದ್ದು ಬೇರೆ ಬೇರೆ ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ವಿ.
Separate list ಕೊಟ್ಟು.
List of dates and synopsis.
So LAC 1 of 2003 is withdrawn on 22/9/2014.
Professor PNR says that the said LAC came to be withdrawn
22nd September 2014.
on 27/9/2014 itself. So it is still pending ಅಂತ ಅನ್ಕೊಂಡು ಅವ್ರು ಹೇಳಿದ್ದು ತಪ್ಪು ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಅವರಿಗೆ ಅಪ್ರೈಸ್ ಮಾಡಿಲ್ಲ. ವಿಡ್ರಾ ಮಾಡಿದ್ದು ಯಾವ ಕಾರಣಕ್ಕೆ ವಿಡ್ರಾ ಮಾಡಿದ್ದು?
Because the writ petition acquisition was set aside by the learned single judge on 24/6/2014.
ಅಲ್ಲಿ ಹಂಗೆ
And we deposited back the compensation with the land acquisition officer.
because of that only, okay.
Yes.
And the amount, as already mentioned above, was remitted back. Because acquisition came to be settled.
No problem.
Next.
Look, the next decision in the same compilation, page 40.
Page 40.
Yes, my lord. Page 40.
2015 SEC.
15 SEC, my lord. Para 6 and 9. Para 6 at page 41. In this context, reliance was placed on decision of the division bench of this court in VT Krishnamurthy versus so and so. Wherein placing reliance on an earlier judgment of this court, so and so division bench held, it is well settled in law that where a person seeks compensation, he cannot maintain writ petition under Article 226 of the Constitution assailing the notification. This is
Ade.
based on doctrine of approbation and reprobation.
ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಕೃಷ್ಣಮೂರ್ತಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 14 ಇತ್ತಾ?
14.
Base,
Pa-
base,
Para 14, page 24.
24.
Yes.
ಅಲ್ಲಿ page 24 ಪ್ಯಾರಾ 12 ಅಂತ ಬಂದದಲ್ಲ ಅಲ್ಲಿ ಈ banks upon a learned single judge's order, order in W order. So this edition 2015 SEC online, Karnataka 5679, bracket nalli, BVNJ, bracket complete, paragraph 6. And add madkyo. Yes.
But I want to know whether he is arguing about 3884 or
No,
3717.
the same logic applies
To the both the
insofar
petitions.
as
All right, I'll answer all that because by clubbing, you know, there is there's some lot. When my turn
I'll
comes,
make my
I'll
stand
say
very
that.
clear, my lord. I have argued, only 2 points were urged, my lord, insofar as final notification not having been issued within 1 year. And there was no impediment insofar as the award is concerned under 11A. I have answered both of those points by relying upon the judgment to say that it is well within time, that is the final notification, taking the stay order into consideration. The final notification and village chavdi, if taken into consideration, is well within the time. Question insofar as the award is concerned, my lord, will not arise because of the interpretation that this honorable court has given to the explanation to section 6. Now, my lord.
That doesn't apply
Now,
to 3884. Probably. My learned friend is now arguing 317.
No,
other
no,
one.
I have stopped. I have relied that decision on 2 aspects.
Ade.
The award aspect.
Okay,
of
now you are arguing the other one.
Now I am arguing the other one. Now, in this case, my lord, what happens? 172 acres was acquired and there's no urgency clause invoked for 172 acres.
ಕೆಳಗಡೆ, WP number ಅಂತ WP number ಕೊಡಿ. 3881 of 1999 ತಾನೆ?
Yes.
Huh?
3884 of 1999.
1999 ಹೆಡ್ಡಿಂಗ್ ಹಾಕೋ ಹೋಗಿದೆ ಮೇಲಿಂದ ಇಲ್ಲಿವರೆಗೆ ಮಾಡಿದ್ದು ಕೆಳಗೆ ಇನ್ನೊಂದು WP ಬರ್ಕೋ WP
37140 of 1999.
37140 of 2000
Of 2000. Of 2000.
Idralli.
Where urgency clause is invoked.
Even that may not be correct. Only 11A and Mulad award Ashtmatra. Idralli, insofar as the 3884 is concerned, there is no deposit, there is no compensation, there is no Mulad enhancement. Illa. Ade
No,
ಹೇಳಿದ್ದು. ಅದಕ್ಕೆ ಇದೆಲ್ಲ confusion.
Lord, what I am trying to
separate ಹೇಳಿ so that ಅದು ಅದೇ ಬೇರೆ ಇದೆ ಇದೇ ಬೇರೆ ಇದೆ anyway yes
Lord, because there's only one meeting, which is held where they participate for consent, where price is fixed for both parcel of land, which touches both the writ petition.
learned AG says in respect of fixation of compensation is concerned, comma, only one meeting in respect of both the lands
On
was
24th
held
of,
on
24th of September 1999.
24/9/1999.
Yes,
99 and our stand ಏನಿತ್ತು ನಮ್ಮ compensation ಕೊಡಿ ಅನ್ನೋದೊಂದೇ
yes, my lord. For both land pertaining subject matter of writ petition 3884 of 99, my lord. That is Srigandha Kaval. And the Hero Halli writ petition also.
ಹೇರೋಹಳ್ಳಿ.
Yes. Where
Petitioner participated in that meeting
meeting, my lord.
and petitioner
And
had participated in the
15
same
lakhs.
meeting, specifically claiming
It was agreed to pay 15 lakhs per acre in WP number 3884 of 1999.
specifically agreeing to take rupees 15 lakh as
Per acre.
compensation per acre in respect of land comprised in 3884 of 1999
Yes, my lord. And 9.5 lakhs per acre
and rupees 9.5 lakh per acre in respect of land comprised in WP 37140 of 1999.
of 2000.
2000.
My lord, the reason why the writ petition in 37140, ma'am, the alternative prayer is for release, I'll just read out that prayer. ma'am. How that prayer will also, because what they are trying to seek as an alternative relief, or in the alternative, direct the respondents to pay compensation to the petitioners in terms of proceedings of the meeting dated 29th of April 1999.
Learned AG draws attention of the court to the alternate prayer
In
of the
WP number,
petitioners in WP number
37140.
two
37140.
40 of
2000.
2000. To the effect that in terms of what was agreed in the meeting dated
29th of April.
29 April 1999.
Yes. 29th
compensation
of
has to be paid.
24, sorry, my lord. Date is.
24/9/1999.
They have made a mistake in there.
24/9/1999.
Yes. So therefore, my lord, if that proceedings touches both lands of Srigandha Kava, then by virtue of this prayer that they have sought,
First, the very text of the prayer is structured on the premise of both the lands.
but the compilation of my judgment, my lord, one last decision, lordship may. Page 43, my lord.
ಏನಂತ proposition ಏನು?
The same, my lord.
Once
Roy Rodriguez.
Huh?
Lord, para 11. my lord. Here also, prayer is sought, my lord. Principles, para 11 at page 47. my lord. Principles of section 11A of the Land Acquisition Act cannot be made applicable to the facts of this case, inasmuch as the award is not passed belatedly in this matter after final notification. Section 11A of the Land Acquisition Act would be applicable only if the award is passed after 2 years from the date of final notification. Therefore, the same principle cannot be applied to the facts of the case. One of the most important factor in the matter is that petitioner has made representation. Sorry,
Where are you?
page 47, para 11. my lord. This is the decision,
Para 11.
para 11, my lord.
Section 4.
Para.
Representation as per the rest of the petition side, praying for either releasing the land to an extent of 2.2%. Or the alternative to pay compensation immediately in respect of said land. From the above, it is payable. Still has prayed for compensation in respect of area of 2 acres to which final notification not issued at that point of time. This itself goes to show that only the notice of the acquisition proceeding, but also had prayed for compensation. That is the teaching of this court in case of Krishnamurti referred.
Yes, they are nearly about, lordship will get consistently this honorable court relying upon VT Krishnamurti's case, my lord.
ಏನು proposition ಏನು what emerges from
Allah,
this?
that is clear that petitioner himself has prayed for compensation, my lord.
True, but by
And
way of
therefore he cannot, my lord, approbate,
if alternatively if he claims,
my lord, it will be
then
like
also
mutually destructive plea, my lord.
ಅಲ್ಲ,
Like if
ಅಲ್ಲ,
a plaint
ಅದು ಇಲ್ಲ
contends,
ಅಂದ್ರೆ land ಇಲ್ಲ compensation
ಇಲ್ಲ, my lord. compensation ತಗೊಂಡಾದ್ಮೇಲೆ ನಾನು ಹೇಳ್ತೇನೆ. If one accepts the compensation, I can understand if one demands. In fact, the very first compilation I have relied upon, where the Supreme
Lord,
Court.
can I seek one indulgence? Function ಇದೆ. If your lordship permit me, madam, I'll go. ಇವರಿದ್ದಾರೆ. ಇಲ್ಲ, ಇವರು ಇರ್ತಾರೆ. Permit me, madam.
ಹೌದು.
Subject to. Sorry, my profound apologies.
I should say sorry, I did not.
ಇಲ್ಲ, ತಾವಲ್ಲ, ನಾನು ಹೇಳು.
But there was irritation.
ಇಲ್ಲ,
for
ಇವರು
this
ಇರ್ತಾರೆ.
also.
ಇವರು ಇರ್ತಾರೆ.
Okay.
Earlier
ಕನ್ವೀನಿಯಂಟ್
decisions.
ಲಾರ್ಡ್ಸ್ ಮಾಡಿ.
One date ಯಾವ್ದಾರ ಒಂದು ಹಾಕೋಣ.
ಬೇಕಾದ್ರೆ ಶುಕ್ರವಾರ ಹತ್ರ ಹಾಕೋಬಹುದು. ಯಾವತ್ತು ತಮಗೆ ಕನ್ವೀನಿಯಂಟ್ ಆಗುತ್ತೆ ಅವತ್ತು.
Friday morning ಹಾಕೊಂಬೋದು. ಇಲ್ಲಿಗೆ ನಿಲ್ಸೋಣ.
Yes,
Huh?
yes.
Okay.
Just
Friday
to-
morning
just to
ಹಾಕೋಣ.
complete, my lord,
Complete it.
just to complete, my lord.
ಇವರು
The-
ಇರ್ತಾರೆ.
Yes, yes.
I have, in my first compilation, my lord, I have relied upon the decision of the Supreme Court in Urmila Roy's case, where the Honorable Supreme Court says is, even if the landowner shows an inclination to negotiate,
That is sufficient.
that is sufficient, my
To
lord,
negative
because,
the challenge to acquisition.
yes, because his actual grievance, even in this case, if your lordship sees,
Compensation.
is compensation. And my lord, the state, because of their application that they filed under section 66 of the Land Reforms Act, they themselves filed a declaration saying that they are in excess. We conduct that proceedings and we say that, yes, we'll await the outcome of that proceedings, and therefore the compensation need not be dispersed to them. There's nothing wrong in that stand of the statement. So today, my lord, in view of that alternative prayer that they have sought for, the writ petition can be allowed, my lord. We have no grievance today.
Learned AG adds that where the landowner shows substantial inclination to allow the acquisition to proceed by negotiating for compensation, comma, challenge has to be negative. And in terms of alternate prayer, made in WP
37140,
2000, comma, petition be allowed and direction be given for payment of compensation in terms of agreement dated 29/4/1999. Yes. 29 or 24?
24th September.
1999.
Interim order is already said that this meeting proceedings are cancelled. That's noted by this honorable court.
Entadu?
This 24/9/1999 meeting proceedings are cancelled by the government in the meeting dated 6/1/2000. That's noted by this honorable court in the interim order.
First, at this stage, Professor PNR points out that the proceedings of the meeting, said meeting, came to be rescinded by the
On 6/1/2000 by the state government.
government by order dated 6/1/2000.
2000.
Yes,
My lord, and this honorable court noted that in its order dated 4/12/2000.
and the same has been noted in the order of this court dated
4/12/2000.
4/12/2000. Okay.
Lord, but they continue to seek that prayer. It is their prayer. Lord, what the Honorable Supreme Court says is that the owners had in fact been willing to negotiate the price for the land at the time when acquisition was still incomplete, as only the notification under Section 4 had at that stage been issued. It's also significant that declaration under Section 6 had been issued and award rendered on dash. It is therefore evident that landowners had in fact acquiesced to the acquisition and cannot now turn around to say acquisition is bad in law.
ಮತ್ತೆ ಯಾಕೆ ರಿಮೈಂಡ್ ಯಾಕೆ ಮಾಡಿದ್ರು ಅಂತ?
That's all, my lord. Even ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋ ನೆಸೆಸಿಟಿನೇ ಇಲ್ಲ. According to me, it's open and shut case because of their conduct. They have, my lord, as I said, Land Acquisition Act is a procedural aspect, my lord. They can waive their right to challenge if there's any defect. They have condoned all the lapses, if any also. Lapses, if any also, by accepting the compensation. What remains, my lord?
The very apex court said all issues should be.
All this would be also an issue, my lord. And VT Krishnamurthy holds the field. This honorable court has been consistently relying upon and has said, yes, once you accept compensation, you close the door for challenging the notification. It's not open, my lord. Otherwise, it will
One
be.
humble submission here, my lords would also kindly see, even in the civil court, your lordships are well aware. Sometimes we make a prayer and then we say, in case this honorable court is not inclined to grant this relief.
ಅದು ಆಲ್ಟರ್ನೇಟಿವ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಅಷ್ಟೇ.
Language, but
ಅದು
here,
ಹಿಂಗೆಲ್ಲ ಹೇಳ್ಬೋದು ಆಲ್ಟರ್ನೇಟಿವ್ಲಿ.
here he has clearly said or.
ಆರ್ ಅಂದ್ರೆ ಆಲ್ಟರ್ನೇಟಿವ್.
ಅದೇ.
It's like mutually destructive plea, man.
ಪ್ಲೀ ಅಲ್ಲ, ಪ್ರೇಯರ್ಸ್. Mutually
in a plaint.
plea cannot be taken.
Correct.
Not prayer.
In a plaint, if in one breath, if I say,
In the for plaintiff, he cannot take.
correct. Even
Same it
defendant,
applies to
even
petitioner.
defendant, my lord,
Defendant, there is
can
some
take
relaxation.
inconsistent plea, but not mutually destructive plea.
ಇಲ್ಲಿ plea ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, plea ಅಂದ್ರೆ,
Prayers ಬೇರೆ,
on one
plea
hand,
ಬೇರೆ.
plea in sense, plea challenging the notification. And plea saying release the compensation.
Plea ಬೇರೆ. Plea.
Plea leading to relief, prayer.
Plea is one thing.
Yes.
Inconsistent plea cannot be taken is the law generally,
Yes.
subject to some 3 exceptions. But inconsistent prayer cannot be taken ಅಂತ ಎಲ್ಲಿದೆ ಅಂತ? ಹಂಗಿಲ್ಲ. One high court considered that aspect of the matter.
Fact specifically provides for taking inconsistent. In lieu of the prayer, you can ask for possession, you can ask for compensation, you can ask for injunction.
No, my lord, here, not only do they ask, but they also withdraw.
That's what.
That is what would be glaring and they'll have to overcome.
You are more on the conduct of the
Conduct, my lord.
landowners.
And land acquisition.
Why you cancelled the proceedings of 24/9/99?
Look, there were two aspects. One is, of course, under the Land Reforms Act, the inquiry was pending. The second is, the actual valuation to the land was only about 3 lakhs per acre. Your lordship will not be anyway, my lord. It's a unilateral act of mine in cancelling the
No, that binds him.
proceedings.
He can say it does not bind him, but He can say that binds you.
Correct, my lord. That's exactly. I'm willing to accept. What, the enforcement is of the meeting dated 24th of
No, it
September.
is for him to say that I am not bound by their cancellation. You can't say I am not bound by my cancellation. ಹಂಗಿದೆ.
Correct. But fact that they continue to keep their
It
prayer on.
only for 14 years. And Apex Court says they have shown inclination for accepting the
That's all.
compensation.
All other interpretation with regard to 80% having been deposited will all be academic. It need not be decided at all in this case.
So decide all issues means, once this is decided, other issues need not be decided, is also deciding the issues anta nim contention.
At this point also, what the Supreme Court has said, all issues must be decided.
All
This is-
issues must be.
This is
decided.
one of the issue that your lordship will
Suppose
decide.
if one issue, if I decide, and if I decide not to decide, also a decision only.
Yes.
Is yours
Like a limitation,
that way?
if your lordship holds that the claim is barred by limitation. All other issue need not be decided. Now, my lord, insofar as 172 acres we acquire, then the APMC says it is shortfall and another 100 acres be acquired. There are communications. And then based on that, we decide to acquire 100 acres by invoking urgency clause. So the writ petition insofar as the urgency clause was argued first, but it has direct connection with the 172 acres, which was first acquired, where it is under regular process 4 and 6, my lord, which we are well within time. 6 is well within time. Award has not been passed because of this stay, my lord. And then the urgency clause. Now, my lord, one other aspect is, my lord, the Yeshwantpur has about 85 acres of APMC yard, which is set up. Today, about 2,500 farmers come every day to trade their produce. This judgment will have an economic impact because the extent of land that is earmarked is 275 acres, which will at least cater to 5,000 farmers every day, my lord. That's one, my lord. Secondly, my lord, the APMC has deposited 14 crores as on 2000 itself. They have deposited the compensation.
ನೀವು ಬೇರೆ 2 ಕೋಟಿ ಯಾಕೆ ಕೊಟ್ರಿ ಇವ್ರಿಗೆ? 14 ಕೋಟಿ ಕೊಡ್ಬೇಕು.
ತಗೊಂಡಿದ್ದು 2 ಕೋಟಿ ಅಷ್ಟೇ ರೀ.
ಕೊಟ್ಟಿದ್ದಷ್ಟೇ sum.
Huh?
That's 80% they should have deposited. That they did not deposit. They said,
That is
"We
because
this money now."
the 80% was determined by the LAO, my lord. That amount was deposited as on that date, as determined by the LAO. That was the amount he had determined.
Lord, what happened in
And
the
that amount, yes, and that amount we deposited. Whatever he asked for, we deposited that amount. As on the date of taking possession of the 65 acres.
ಅಲ್ಲ ಬಟ್ ಅಲ್ಲಿ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಇರೋದೇನು? ಶುಡ್ ಬಿ ಪೇಡ್ ಅಂತಿದ್ಯಾ?
Should be paid.
ಶುಡ್ ಬಿ ಡೆಪಾಸಿಟೆಡ್ ಅಂತಿದ್ಯಾ?
He paid,
ರಜೀಶ್ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದೇನು? ಶುಡ್ ಬಿ ಪೇಡ್ ಅಂತನಾ?
should be paid.
Before taking possession of any land under subsection 1 or subsection 2, collector shall, without prejudice to the provisions of subsection 3, tender payment of 80% of the compensation for such land as estimated by him to the persons interested entitled thereto. They have to tender.
ಪೇಮೆಂಟ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
Please, madam.
ಟೆಂಡರ್ ಮಾಡ್ಬೇಕು. ನೀವು ನೋ ಅಂದ್ರೆ ನೀವು ಒಂದು ದುಡ್ಡು ಇಸ್ಕೊಂಡ್ಬಿಟ್ರೆ ಚಾಲೆಂಜ್ ಇಲ್ಲ.
Please, madam.
ನೀವು ನೋ ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಿದ್ರೆ ಚಾಲೆಂಜ್, ಅಥವಾ ವಿತ್ ಪ್ರೊಟೆಸ್ಟ್ ತಗೊಂಡಿದ್ರು ಚಾಲೆಂಜ್ ಈ ಅರ್ಥದಲ್ಲಿ.
Yes, madam.
ಫ್ರೈಡೆ ಹೇಳ್ತೀರಾ?
Please.
So far as I am concerned, learned senior counsel, as I pointed out, he is in.
ಫ್ರೈಡೆ ಹೇಳಿ.
Friday I will make 20 days.
ಫ್ರೈಡೆ.
No, we have to give.
To the court. Precedents.
This is the one.
Yes, yes.
ಬೇರೆ ಫುಲ್ ಮಾರ್ನಿಂಗ್ ಇಂದನೂ ಸಿದ್ಧ. ಜೋಶಿ ಹಾಕಿ ನಮ್ಗೆ ಸಿಗಲ್ಲ. ಇಲ್ಲ ಜೋಶಿ ಔಟ್ ಹಾಕ್ಬಿಟ್ಟು ನಮಗೂ ಬೇರೆ. ಥ್ಯಾಂಕ್ ಯು.
ಮಾಡಿಲ್ಲ ಅಂತ ಸುಮ್ನೆ 6 1 ಕೊಟ್ಟಿಲ್ಲ.